Good morning, everybody. Uh, Sir, Harshul sir, if it's okay with you, we can start. Uh,
Yes.
okay. So, good morning, everybody. Let me just start this session by giving a brief introduction for Sir. So, Harshul sir is the founder of the law firm Corporate Legal Practice, and he's expertised into non-litigation corporate matters, especially drafting and negotiating contracts and matters relating to corporate laws and capital markets. He operates from Mumbai and has more than 15 years of experience in the legal field. He's worked with some of the top law firms of the country as well. Prior to forming corporate legal practice, he was working with the merchant banking team at Vadya Gandhi and Company. He also specializes in IBC matters, and he has been a consultant IT
Kela mute,
in various CIRPs.
mute
So,
केलं
welcome, sir.
नाही.
Uh,
मायक्रोफोन तिथे राईट क्लिक केलं, मायक्रोफोन एरे stereo same as your system.
I would request everybody to put their
Microphone.
I would request everybody to put themselves on mute. Uh, and I would also request everybody to keep their cameras on during the session. If there are any questions, we can take them up during or after the session as per the convenience.
Speaker.
So, welcome, sir. We can start the session.
Thank you.
The system.
Am I audible?
Yes, sir. You're audible.
Thank you. First of all, at the very outset, I convey my gratitude to the ICSI IIP for giving me this wonderful opportunity and platform to share my thoughts on claim verification with all my colleagues IPs here. It is a very interesting subject when you talk about the verification of the claim and submission of the claim. A lot of queries come. I'm consultant to many IPs also, and I'm consultant to many COCs and financial creditors also. So this is one of the things where, they always have query every now and then, because this is an evolving law and many situations have come across over a period of time in last 5-6 years, where there is a lot of confusion about various types of creditor. Originally, when we see it was only operational creditor and financial creditor. Gradually, the concept of other creditors also came. The concept of home buyers as a class of creditors also emerged. So it's an evolving law, and things have changed from time to time. And various judgments are there. At certain areas, there are also certain contradictory judgments are there. So we'll discuss all of them. What is the correct position and how the courts have viewed from time to time on that. And it will be interesting to share my thoughts, and it will be also very interesting when this session goes on the interaction basis. Wherever you have any queries or questions, you can ask me that. Wherever there is any clarity needed in my lecture, also you should immediately ask. It's more of a discussion and more of a sharing of thoughts rather than training someone, because all of us will be having enriched experience in this particular area of field when we are practically doing the claim verification and claim submission process. So I'll share the screen with you all. Is it visible?
Yes, sir. It's visible.
Screen is visible, right?
Yes, sir. Yes, sir.
Wonderful. So our lecture now will start with uh, just to give the basic background about my practice. Also, I practice as advocate and solicitor as my background practice, and I practice as a insolvency professional. under IBC. And I'm also consultant to many of the IPs and COC and financial creditors. So this is one of the common area where we find a lot of queries coming from various IPs. My initial part of the lecture will discuss with the CIRP process, the claim submission and claim verification in the CIRP process, whereas the second part of the lecture will be dealing with the liquidation process, that is claim submission and verification under the liquidation process. It will be focused purely on the claim submission and verification and various judicial pronouncement that has taken place. There are ample judgments on this particular field about the financial creditors, about the operational creditors, the views of the judiciary on the home buyers, which slightly differ from the operational creditors about various aspects. So we'll discuss it in detail about all these area. So we'll start our session now. The first and foremost, you can see about the claim. I'm sure you know what the claim is all about.
Thank you.
But going by the definition of IBC, claim means right to payment. In any claim, right to payment is very important. If there is no right to payment, definitely you cannot establish the claim. The first and foremost thing you need to verify is whether a person has right to payment. For example, someone is claiming a damages for the breach of contract. Just merely an unsubstantiated damages or unsubstantiated claim does not give any right to payment. So someone who is claiming should have actual right to receive that payment, and right to payment is one of the very important part of it for any claim. And when there is a claim, only then the debt can arise. So therefore, when you are verifying the claim, when you are verifying or substantiating someone as a creditor, one of the most important part is there should be a claim, that is right to payment. So right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured or unsecured. Any kind of payment can be there, whether it is followed by judgment or not, whether there is substantiated by judgment or not, immaterial. Right to remedy. Second part, the definition deals with the right to remedy for breach of contract under any law for the time in force. If, again coming to the same part, if such breach gives rise to the right to payment. So again, we are talking about the right to payment. Merely a breach is not sufficient. Merely a breach of contract would not give anyone right to payment. It should be followed by a substantiated judgment, substantiated right of payment. So again, when there is a breach of contract, we are claiming damages, it should not be unsubstantiated damages. So therefore, right to payment should be there. Whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, secured or unsecured. There can be a disputed debt, still a claim would be submitted. It can remain under the disputed claim, but still you have to accept the claim as a disputed claim. So therefore, it can be disputed, it can be matured, it can be unmatured. All these things. For example, a guarantee is giving. Guarantee may not have been invoked also, and still the right to payment is there once it is invoked. So therefore, it is not necessary that the triggering point should be emerged or the triggering point should get invoked. Yes. Any query? Okay. So judicial view. What are the certain judicial views are on this? In Innovative India, in Innovative Industries Limited versus ICICI Bank and other, the Supreme Court held on 31st August 2017 that claim means a right to payment, even if it is disputed. In Swiss Ribbon case, the Supreme Court has held on 25th January 2019. As I said, it is an emerging law, so a lot of positions have emerged. These are all very crucial, important Supreme Court judgment. I am sure we all are aware. That claim gives right to a debt only when it becomes a due, and default occurs only when debt becomes due and payable and is not paid by the debtor. This way, the financial creditor proves a default, while operational creditor proves the right to payment of liability. When there is when this is kept in mind, the differentiating triggering of CIRP by financial creditors and operational creditor becomes clear. I'm just using for convenience the brief terms. FCs means financial creditor, OCs means operational creditor, CIRPs, corporate insolvency resolution process. SC is a Supreme Court. All this normal nomenclature which we use otherwise, I have used in brief, just for the brevity sake. Next, the claim has to be ascertained claim. That is, unascertained claim will not give any right to payment. So claim in the nature of breach of contract and a claim regarding managerial inventory costs, escalation costs, oversight being the nature of damages are not covered in the definition. Claim is right to payment, whether such right is disputed or undisputed, legal, etc. Section 311 defines the term debt is a liability or obligation in respect of the claim. So in my view, when we are talking about the claim part, just for the claim part, for initiating CIRP, the debt and default of for financial creditors and right of payment for operational credit. That is what you have to establish when you are approaching for the CIRP process. And hence, filing application to initiate the CIRP, it has to be crystallized or ascertained debt. However, merely to filing of the claim under CIRP of the corporate debtor in Form B or C, etc., before the IRP or RP, the claim need not be matured, need not be crystallized, need not, as it has been held in the matter of Axis Bank versus DBS, Axis Bank and DBS Bank versus EduSmart Services Private Limited. So therefore, a guarantee when we are making as a claimant, there you don't have to invoke the guarantee in specific. The guarantee, your claim rise as a guarantor, as a creditor. Coming back to now, public announcement, how the claim submission process works and how the claim submission will take place. You have to read the IBC code along with the various regulations, CIRP regulation which are there. So when I'm talking about the public announcement and claim submission process, you have to see section 15(1)(c), 18(1)(b), read with regulation 12(2), which gives 90 days timeline, and 6A of the CIRP regulation. 6A basically deals with the communication with the creditor, which is one of the very important responsibility now or duty of the IRP to communicate with the creditors about the public announcement and the inviting the claim. So when we are talking about the public announcement, adjudicating authority after admission of application under section 7, 9 or 10 shall by order declare the moratorium, cause the public announcement and call for the submission of claim under section 15 and appoint the IRP. As per section 15(1)(c), as per section 15(1)(c) read with regulation 6, the public announcement shall specify the last day of submission of claim, that is within 14 days of appointment of IRP, along with all supporting documents. While regulation 12(2) provides for the creditor who fails to submit the claim within 14 days can submit the claims on or before 90 days of the ICT, that is insolvency commencement date. So when we are talking about the timelines, we are aware that the claims are required to be submitted by the claimants within initial period of 14 days and then up to 90 days. Now, what is why these two different timelines? What is the rationale why this 14 days timeline is required when claim can be submitted even for the period up to 90 days? For the very simple reason, when you are forming the COC, the first month, you should know in precise who are the financial creditors initially to form the COC. Thereafter, it can keep on getting updated. But then, in the initial, there should be some cutoff date which will take for formation of the COC, constitution of the COC. And therefore, these initial 14 days timelines are that and you within this timeline only you should try to approach all the creditors to submit their claims. So usually by practice, how we do is first thing, when we are talking about the communication to the creditors, from where we get information about the creditors, the communication, how we will communicate, that is later on, that is very important question. Because if, for example, management is not cooperating with you, not giving you the information, how you can procure the information? In that situation, you can take out the information from the available sources like MCA. From MCA, you can see the charges which are registered. From there, you will come to know which banks are there. You will try and approach the banks through those details available with you. Similarly, details would be available with IU, information utility. You can take out the information from there, and you can take out those information and try to approach the financial creditor from those area as well. At the same time, if the management is cooperative, they'll be having a list of creditors, financial creditor and other creditor. They may not have been segregated, but they may have segregated the list based on secured creditor, unsecured creditor, etc. And they would be having the contact details, email IDs, yeah, telephone number, etc. You can try and connect through those details available. So usually we try to, on the first and second day itself, we procure all the information from available information from the management of the corporate debtor, and this on priority basis about the information of the creditors. And then on the third, fourth day, we start communicating with the creditor, seeking claims from them, forwarding them the email along with the public announcement and this order of CIRP, etc. So that they can, along with the forms also, we also give them the form which is given in Schedule 1, so that they can easily fulfill the form and submit their claim. So that is how the communication works. But then when we are talking about the timelines, this 14 days timeline is for initial submission of the claim by all the creditors. Thereafter, even if it is delayed, we can submit it up to 90 days within under regulation 12(2). Now, again, the question arises, what happens in case there is someone is approaching after 90 days? What can we accept the claim? Logically, yes, after 90 days also we may deny, we may not deny. That discretion lies with the IRP or RP. But by logical conclusion, how the views of the judiciary are, we'll discuss those judgment as well. Usually, we accept the claim. I mean to say, they submit the claim, we accept that submission. We also examine the claim, verify the claim, we put it before the COC and confirm with the COC that we can admit the claim even if the 90 days timelines are over. Despite of that, these claims have come belatedly, and with COC's permission or majority of the permission to admit the claim, we admit the claim. Because after 30 days, we have to take the resolution of the COC on every aspect that we deal with. And therefore, it is always advisable to put those facts as a process. Who's put those new claims which have come after 90 days, since it has come after the statutory timelines, after the statutory period, we should always seek the permission from the COC as a process that these are the claims which we have received after 90 days beyond the statutory period, and we should seek permission from the COC to admit them if it is admissible. Of course, we examine and verify, keep it ready with the COC. We explain to them what are the facts of that particular thing in the next COC meeting, and we examine everything, we verify, and then before accepting or before issuing the admission letter or mail, we inform it to the COC, we take permission and approval of the COC. If the COC approves, we put it forward. Otherwise, we also do not admit, let them go to NCLT. If COC denies that we should not take after 90 days, we, as a matter of practice, we say, logically, we should admit it. They are not time barred dead or etc. And all the lacunas are not there. In that case, we put it before the COC. And we try to convince the COC to, if it is admissible, then we put it before the COC to take their approval. If they approve it, we admit the claim. If they don't, we take that as a stand and we say you go to the NCLT or judiciary to get it adjudicated. Next is, as I said, Regulation 6A, which has been recently launched, communication to the creditor. IRP shall send a communication along with a copy of the public announcement made under Regulation 6 to all the creditors as per the last available books of accounts of CD, that is corporate data, through post or electronic means, whether the information for communication is available. So wherever the information is available, whatever information is available through, sometimes even only telephone numbers are available, sometimes the email IDs are available, whatever information is available, based on that we communicate with the creditor and we maintain the record this communication is made, because it is the requirement of the law. So we must have backup record that communication is made. So wherever the email IDs are available, we simply use the email ID as a platform and send it, keeping the email ID as a record about the communication. If email IDs are not available, we have to sometimes call also. Email IDs are not available easily from the records of the corporate data. And in those cases, we always say that call is getting recorded. We maintain the call record corresponding record about the communication with the creditors. So, provided that where it is possible to send the communication to creditors, the public announcement made under Regulation 6 shall be deemed to be communicated to such creditors. Now, again, sources of information about the creditor, as I said, it is MCA, books of accounts, contracts and compliance filings. From there, you will get all these details, especially of the financial creditors. There would be correspondence. There would be, for example, sanction letter from the bank. You will get the numbers from the bankers or the branch where you are dealing with. Even the email ID from the letterhead, you will get all these details. So from their filings also, compliance filing also, sometimes the contracts are executed. For example, loan agreements are there. The party notice should be given to a particular address or email ID. The detail will be there in the contract also. So you'll get all these details from these sources. So you can take out the details from these sources and you do make communication with the creditors. So first and second days, this is one of the additional important responsibility of the IRP. We believe that we should do this in addition to many things on the first and second day we have to comply with, apart from public announcement. So, but this is also, in my view, a team can do this kind of dig out information about the creditors where we could have the communication with them. Submission of claim, how claims are submitted. As we are aware, Section 18(1)(b) imposes duty on the IRP, as under IRP shall receive and collate all the claims submitted by the creditors to him pursuant to the public announcement made under Section 13 and 15. And how the claims are submitted, the claims forms, we all are aware that operational creditor is required to be submitted in Form B. How it can be submitted? It can be submitted in person or by post or by electronic means. Whereas financial creditor, it is required to be submitted in Form C and it is required to be submitted in electronic means. You say, sir, why in electronic mean, Harshul? Why electronic mean is required for financial creditor? Why not in person or by post? For the very simple reason, you can also additionally submit in person or by post, but mandatorily and statutorily required in the electronic mode for the very simple reason, postal things may get delayed. At the same time, there may be, sir, tomorrow dispute about the submission of claim. Someone is submitted, not submitted, then becomes a matter of evidence. When it is on the mail, the records are very clear about the submission by mail, receipt of the mail, verification of the mail. All these things can be electronically done. And therefore, when you are going to form the COC, who has a very important role in the entire CRP process, we cannot be in the lurch for the longer time or adjudication by NCLT about the receipt of the claim. And therefore, to avoid those kind of anomalies, the claim is required to be submitted at least by electronic mode. So one mode is very clear that in this particular mode, it becomes easier to establish about the communication. It becomes easier to establish about the submission of the claim, receipt of the claim. Only then the question arises about the examination and about the verification of the claim. So therefore, in case of financial creditors, since they form part of the COC, it becomes very crystal clear that within 14 days, the claim is submitted or not, and therefore, it is mandatorily required to be submitted by electronic means. So tomorrow, someone may submit by, in addition to this, they may submit by post, by in person, etc. Another reason also is about electronic record. Usually, unless it is deleted, it will not get destroyed. Whereas physical record can get destroyed. Of course, you will say, Harshul, we have to maintain the record in a physically as well as electronic mode as per the law. Answer is yes. But if tomorrow someone has just financial creditor, most important person in the CRP process, of submitted physically and someone has not kept the record electronically tomorrow for whatever reason, because their claims runs in hundreds and thousands of pages, you know how the bank statement comes. So when these records comes in thousands of pages and someone is not taking by negligence, by whatever reason, if someone has not taken in electronic mode, if it is physically submitted and the record gets destroyed, then becomes very difficult when it is a claim of the financial creditor. Because based on that, they are forming a part of the constitution of the COC. And therefore, for financial creditors, which are very important constituting the COC, the records are kept very clear in electronic means. Next, workmen and employees. It is required to be submitted in Form D. It can be submitted in person or by post or by electronic means. Through authorized representative in Form E. It is required to be submitted again in person or by post or by electronic means. Same by other creditors. which is in forming part of Form F. Again, the same mechanism in person or by post or by electronic. The same thing which we discussed, what the law provides, what are the supporting documents required to be submitted. All these things we'll discuss. As we just discussed about various rules available. Operational creditor rule 7, financial creditor rule 8, financial creditor of a class rule 8A, workmen and employees 9, and other creditors by rule 9A. So all those rules we will again discuss in detail what CRP regulation deals with it. So claim by operational creditor. Claim by operational creditor, a person claiming to be an operational creditor other than the workman or employee of the corporate debtor shall submit the claim with proof to IRP in person or by post or by electronic means in Form B. Such person may submit clarification or supplementary document in support of claim. Debt due to operational creditor may be proved by record with information utility, if any, other relevant documents, including the contract for supply of goods or services to the corporate debtor, an invoice demanding the payment of goods or services supplied to the corporate debtor, the order of the court or tribunal that has been adjudicated upon non-payment of the debt, if any, that's recovery suit or whatever, or the financial accounts, copies of the relevant extract from GSTR 1, that is GST documents that he has paid on the invoices, the requisite GST filed under GST law, and the copy of e-way bill wherever applicable. It shall not apply to those creditors who are not required registration and those goods and services which are not covered under any law relating to GST. For example, if I'm a lawyer and I'm claiming, probably I'm not supposed to, as a lawyer, I am not required to pay any GST. It goes under reverse mechanism. So when I'm not supposed to pay any GST, I cannot provide this GSTR 1. And therefore, for those people, the rest of the documents will apply, the invoice will apply, the proof of delivery. In addition to that, many times we also seek further document. So further, IRP may also look at the financial accounts such as ledger, bank statement, acknowledgement of the debt, books of accounts of the corporate debtor, proof of delivery. These are various other statements which IRP may seek. This is what the statutory documents provided in the Act. But in addition to that, for further verification, for making it sure that this debt is genuine, IRP may seek even further these information. When we say financial account does not mean the balance sheet of the operational creditor. Okay, when I say financial account, ledger would suffice. Claims by financial creditor. Regulation 8, claims by financial creditor. What it says, person claiming to be a financial creditor other than financial creditor belonging to a class of creditors shall submit claim with the proof to IRP in electronic form in Form C. Such person may submit the supplementary document for clarification in support of the claim before the constitution of the COC. Existence of the debt due to the financial creditor may be proved by the record of IU, record of information utility. For financial creditor, this is one of the most important documents, if any, or other relevant document, including financial contract supported by financial statement evidencing the debt, a record evidencing the amount committed by the financial creditor to corporate debtor under the facility that has been drawn by the corporate debtor. So financial facilities, the financial statement that may be a bank statement showing that the debt has not been paid, or any other order of the court or tribunal that is adjudicated upon the non-payment of the debt, if any. So these are the documents which are required to be submitted along with the claim by the financial creditors. When we say about the class of creditors, Regulation 8A, claims by the creditors in a class. Person claiming to be a creditor in a class shall submit the claim with the proof to IRP in electronic form, as I said, in Form CA. That may be proved by record with IU, if any, or other relevant documents, including agreement for sale. When it's talking about the class of creditor, means the class such as debenture holders, home buyers, they all fall within a class when there are more than 10 of a particular class. So that is where these documents are required. Agreement for sale, letter of allotment, receipt of the payment made, or such other document evidencing the existence of the debt. A creditor in a class may indicate its choice of insolvency professional, that is authorized representative, from among the three choices provided by IRP in public announcement to act as a authorized representative, AR. Claim by the employees or workmen. How the claims are submitted by employees? Either they can individually also submit the claim, or they can collectively submit the claim in a group to an authorized representative. So that where we are looking, a person claiming to be a workman or employee of the corporate debtor in individual capacity shall submit the claim with proof to IRP in person. In person means in his individual capacity, by post or by electronic means in Form D. Such person may submit the supplementary document or clarification in support of the claim on his own, or by, if required by IRP, where there are dues to numerous workmen or employees of the corporate debtor. An authorized representative may submit one claim with proof for all such dues on their behalf in Form E. Existence of the dues to workmen or employees may be proved by them individually or collectively on the basis of records with information utility, if any, other relevant documents, including the proof of employment, such as contract of employment for the period for which such workmen or employees claiming dues, evidence of the notice demanding payment of unpaid dues, and the documentary or other proof that may have been made, and order of the court or tribunal. Anytime labor court orders are there, so court or tribunal that has adjudicated upon the non-payment of the dues, if any. So that is, these are the various regulations based on which the claims are submitted. The following debts shall rank equally between and amongst themselves. Now we are talking about ranking given under section 53 of IBC. You say, sir, why section 53? We are talking about the claim submission. We need to understand even section 53 while giving the priority, because as you are aware, when it comes to the resolution plan, when it comes to the, even if we go into liquidation, we should be very clear about in what category they are taken or their claims are admitted. If you see my email going about the admission of the claim or communication to the claimant, I always mention that the claims are admitted in a particular category. And I also in my claim submission list, the list of creditors we prepare, I always prefer to add one more column to add them in a particular category, for the very reason when it comes to the calculation about the debt due to the operational creditor, the workmen, the employees, the things becomes very clear that these are the amount which is required to be paid in priority. These are the amount which does not form part of the priority. So that is where, that is where this classification is required. When we talk about section 53, 1B, it says the following debt shall rank equally between and amongst the following: workmen's due for a period of 24 months preceding the liquidation commencement date, and the debt owed to the secured creditor who has relinquished the security in the manner set out in section 52. C comes wages and unpaid dues owed by the employees other than the workmen for the period of 12 months preceding the LCD, that is liquidation commencement date. Why this becomes important? Because when you are verifying the claim from the employees, for example, some employees is claiming that last 4-year dues are not paid to us. How will you verify that? Since last 4 years the dues are not paid. First of all, whether it will form, to what extent you can admit the claim. If it is time barred, Limitation Act applies to it. As IRP or RP, you may just collect the claim. You may decide, you may not decide about the time barred aspect, limitation aspect. There are judicial pronouncements we will discuss in the later part of the lecture. But over here, 4 years that are there, and if you take a stand that 3 years the claim is required to be submitted within a period of 3 years, and therefore anything beyond 3 years are time barred, then 1 year debt will be excluded there. Then comes to the question of 3 years. Out of the 3 years, 2 years workmen's dues, 24 months payment will form in category B, whereas the other debt, 1 year debt, that will form part of the F, category F. What category F says? Any remaining debt or dues it will go in that category. The first 2 years will come in category B. So claim submission and verification when you are doing, if you are segregating it, though mandatorily law doesn't say that you have to write it down in the communication, but this will be for your own benefit when you write down and segregate it and apply your mind that this is what my debt I have to pay in priority, and they have the claim even during the resolution process. You segregate that they will have first 24 months, which I will pay them in priority to the rest under 51 1B3, 53 1B, and remaining 1 year I will pay for 53 A 1F, whereas beyond that it may be a time but we have to see. So, and if it comes to the wages of the workmen, then it is only period of 12 months under C 53 1C. So that is how the segregation happens even in the verification of the claim you can do. And E deals with the following: dues shall rank equally between and amongst themselves. Any amount due to the central government or state government in respect of whole or any part of the period of 2 years preceding the liquidation commencement date. Again, here the timeline becomes important, that in E category, it will come only for the period of 2 years. The amount due to the central government or state government may be a taxation amount in respect of whole or part of any period of 2 years preceding. पिछले 2 साल का है तो ये E में आएगा, otherwise it will come in F. So that is how the segregation becomes important when you are verifying the claims. The next question that comes to claims by other creditors. How the claims are governed by the other creditors? The other creditors are those creditors which are neither financial creditor nor operational creditors. So Rule 9A, which deals with the claim by other creditor, person claiming to be a creditor other than those covered under 788A and 9 shall submit their claim with the proof to IRP or RP in person, by post or by electronic means in Form F. Existence of a claim of a creditor may be proved on the basis of records in information utility, if any, or any other relevant documents sufficient to establish the claim, including any or all of the following: documentary evidence demanding the satisfaction of the claim, bank statement of the creditor showing the non-satisfaction of the claim, any order of the court or tribunal that has been adjudicated upon non-satisfaction of the claim, if any. So all these documents you have to submit when you are submitting claim under as a other creditor under Rule 9A in Form F. Substantiation of the claim, IRP or RP may call upon first further information, such further evidence or clarification as he may deem fit from the creditors for substantiating the whole or part of the claim. And the creditor shall bear the cost of proving of debt, that is under Rule 11. So creditor have to provide those information whichever is sought by the IRP or RP, and based on that he will collate the claim. Do use understand that at the CIRP process, duty of the IRP or RP is to collate the claim, collect the claim, examine the claim, verify the claim. They are not supposed to adjudicate the claim. Adjudicatory powers are not with the IRP or RP. And therefore, when there is under dispute, any claim remains under dispute, you are not supposed to take a call or adjudicate any claim what the correct amount is. You can say, I'm admitting you in particular so much of your claim, remaining amount remains under dispute. Let him go to the adjudicating authority to get the claim adjudicated through NCLT. So when there is a dispute lying, in that situation, the claim remains under dispute. Submission of proof of claim. A creditor shall submit the claim with proof on or before the last date mentioned in the public announcement, that is within 14 days period. The creditor who fails to submit the proof of claim with proof within the stipulated period of a public announcement may submit the claim with proof to IRP or RP on or before 90th day of IDCD. As we said, that is given under Regulation 12.2. Where the creditor is financial creditor under Rule 8, it shall be included in the COC from the date of admission of such claim. Such inclusion shall not affect the validity of any decision taken by the COC prior to his inclusion in that COC. Few judgments relating to this in Ranjit Das and others, it was held that claim can be admitted even after 90 days of the insolvency commencement date, but the claimant would not be a part of the COC. So whatever decision taken by the COC until the time he is admitted, in that situation, whatever decision taken by the COC will be binding on him. So when he is submitting after 90 days, if he is not part of the COC, he cannot be a part of the COC. In that situation, the decision of the COC would be binding on him. Claim will remain admitted. In Edelweiss ARC, Edel Landmark Limited, it was held that rejection of the claim on the ground of delays are unsustainable because the provisions have been held directly. These 90 days timelines. In this particular Edelweiss matter, it held that 14 days timeline or even 90 days timelines are directly, it's not mandatory. And therefore, the court has taken a view that even after 90 days, you should take the claim. Otherwise, it will be an unjust. Say, for example, law of land provides that you have to submit the claim. If you have any claim under limitation law, the claim is to be made in 3 years. It is within the timelines of 3 years. Any query? Okay. In SBI versus Surya Pharmaceutical Limited, NCLT held that provision with regard to the filing of claims within the stipulated period is not mandatory. So again, the same position, this 90 days timeline, 14 days is not mandatory thing. It is 90 days not submitted. So now we have to reject the claim. It is not like updation of the claim under regulation 12A. Creditor shall update claim as and when the claim is satisfied, partially or fully from the source in which in the manner of after insolvency commencement date. So whenever there is any claim satisfaction, you have to update that to the IRP or RP, and the list will be accordingly updated. Now, what are the regulations about the verification of the claim? Regulation 13 provides IRP or RP shall verify every claim as on insolvency commencement date. So claim up to ICD, irrespective of when it is submitted. It may be submitted after 60 days, within 90 days maybe, or even after 90 days. The claim amount should be up to the date of insolvency commencement date, as on insolvency commencement date, within 7 days from the last day of receipt of the claim, and thereupon maintain the list of creditors containing names of the creditors with the amount claimed by them, the amount of their claim admitted, and the security interest, if any, in respect of such claim, and update it. List of the creditors shall be available for inspection by persons who submitted the proof of claim, available for inspection by the members, partners, directors, and guarantors of the corporate debtor or their authorized representative, or displayed on the website of the corporate debtor. CA filed on the electronic platform of the IBBI or dissemination of the website, filed with NCLT and presented at first meeting of the COC. So, who can inspect this list of creditor also? Recently, one of the matter, where my client was appearing in a capacity as other creditor. Whether can he, in the capacity as other creditor, can he seek the list of creditors and inspect the list of creditor? So, when we sought the list of creditors, immediately the IRP said, I am not supposed to give you the list of creditor, it is a confidential information. And I said, how can it be confidential about it? It should be available in the public domain. So, available for inspection by a person who submitted the proof of claim. If I have submitted a proof of claim, it means I am a claimant. If I am a claimant, the list of creditor should be available to me where my name should be appearing. So, that is irrespective. It is not many times you have conception that only financial creditor have right to demand all this information about the list of creditor is not the correct. In Sirpur Paper Mills Limited versus IK Merchant Private Limited, formerly known as IK Merchants, Kolkata High Court held that CIRP cannot be used to defeat a claim or a dispute which existed prior to the initiation of the insolvency proceedings. Now we'll go through certain judgments. This judgment becomes very important. in RR, because these are the judicial jurisprudence behind how the claim verifications are made. And therefore, I have given a lot of importance to the judgments. In RR Gopalji versus Indian Overseas Bank, it was held that a writing to be an acknowledgement of the liability must involve an admission of subsumed jural relationship between the parties. It means there should be a debtor-creditor relationship between the parties and conscious affirmation of intention of continuing such relationship in regard to the existing liability. The admission need not be with regard to the admission need not be in regard to any precise amount nor by express words. If a defendant writes to the plaintiff requesting him to send his claim for verification of payment, it amounts to an acknowledgement. It is proved that corporate debtor has acknowledged the debt within 3 years, that is, before the expiration of the prescribed period of a suit or application as given under the Limitation Act. Claims are admitted on the basis of valid documents submitted to IRP or RP, whether such claims are accounted in books of accounts of the corporate debtor or not. So many times question arises, sir, in our books of accounts, the claims which are submitted is not appearing. Then whether should we admit the claim? Should we accept the claim? You have to verify that yes, that is what the duty of the IRP or RP is. They have to collect the claim. They have to examine the claim. They have to verify the claim based on the available documents which they have submitted as per the law. And if he comes to the conclusion that yes, this is a legitimate claim, he is supposed to admit it, irrespective of whether it is appearing or not in the books of account. Many times that question also arises that certain debts are acknowledged. Certain debts are acknowledged, but we don't see any entry relating to that in books of account, or we don't see audit of that particular entry, or we don't see actual money coming in that. In one of my transactions where I was acting as IRP, one of the SR group company, someone had submitted the claim of 20 crore rupees just with the acknowledgement of debt by the directors. Then I said, give me further information about that. Give me the invoices, give me the bank statements where you paid the amount, whether you received the amount. They said, we don't have any such document available with us. Only acknowledgement of debt by a director. Now, whether acknowledgement of debt by a director, it can be a fake claim also. Such kind of acknowledgement might have been done in the earlier date, even after admission in the CIRP, because that can be another collusion with the ex-management. You have to examine very carefully whether you actually received this money. They said 20 crore has been given to you as a loan. Whether your account says so, do they show you as a financial creditor in the books of account that loan was taken by our company? In books of account, it is not appearing. In that situation, the next step lies is, have we actually received this 20 crore? You have to check the bank statements. If you ask the bank statement from them also, at the same time, you also should verify the bank statement at your end. Bank details would be available from the bank. So you can verify on that particular date when he says that 20 crore is paid as a loan, whether that amount has actually been credited in your account. If you can see in your bank statement also, then also you are satisfied that yes, this amount is received. You ask them the bank statement about that, but if they can't provide you to verify, further investigate, only after confirming that this claim can be a fake or can be a collusionary claim, you may put it for adjudication or disputed. So you should put your full efforts to examine and verify the claim with whatever document is required by you as per the IBC. The claim verification is required as per the IBC. When we are, of course, there are certain things which are not directly written in the IBC which we have to look into. For example, as I said, about the limitation part, in Claim Verification Act, it is not written. So law doesn't require you to look the limitation. But as a prudent person, you should look at the limitation. If there is a time barred one, if you are sure it is a time barred one, you can take the call that you would remain in the disputed, someone dispute, then you should keep it in a disputed one. Otherwise, you can not admit the claim because it's a time bar. But if you are not sure, just because the claim is submitted is 3 years older than that, That doesn't mean it becomes a time bar, because the claim might have continued. It may not have gone time barred either because of the interest component. There is a continuing of offense, continuation of the claim. Might be because of the acknowledgement of the debt. It is not time barred. Might be because appearing in your books of account. That is why it is not time barred. Many reasons are there why a claim, even after 3 years, may not be time barred. If you don't have that expertise to verify that, you should not take call on that. Not to at least reject it, you should keep it under dispute to get it adjudicated through NCLT. So therefore, you can issue the deficiency letter in that case if you are not competent enough to adjudicate it based on the available information. You are not sure about admission of the claim. In that case, you should keep it under dispute. So based on that, now again coming to few judgments in SBI versus ARGL Limited, application was filed by the CBDT to get their claim admitted, which was rejected by RP for filing of the claim belatedly. Means it was belated claim and therefore it was rejected by RP. Adjudicating authority held it is a strange situation which is adopted by the RP, because in books of accounts of the governmental dues are always reflected. First of all, as a matter of fact, as a first step, IRP or RP has to prepare the list in accordance with the books of account. See, this judgment deals with the process part. Very importantly, how we should carry out the claim submission or claim verification process. It is not directly given in the act. It is coming through a judgment. The court has suggested this, that this is how you should do your claim verification. First of all, as a matter of fact, as a first step, IRP or RP has to prepare the list in accordance with the books of accounts and then invite the claim. Otherwise, the dues reflected in the books of accounts would be rendered completely meaningless. Means अगर आपके books of account में debt है already, वो भी आप verify नहीं करते हो, तो उसका फायदा क्या? It becomes redundant. Books of account, you are ignoring it. And that is not, if you see various judgments, again, one or two more judgments are on this particular aspect, that when the books of accounts are having particular debt, even if the claims are not submitted, even if the claimant has not submitted the claim in relevant form, you remind them now. Nowadays, these questions are less relevant because now, as a IRP or RP, you are also supposed to communicate with the claimant seeking the claim. We have to remind them, please submit whatever form is required to be submitted. So we have connect with them where we can ask them to submit the claim, looking at our books of accounts. But however, even if they don't submit the claim, the judiciary view from this angle, that is an IRP or RP, you have access to the books of account and you are supposed to prepare the list of claimants based on the books of accounts. The creditors, the list of creditors which you prepare based on the claims and verification is separate list which you submit with the NCLT based on the claim submitted. In addition to that, those creditors who have not submitted the claim but they are still appearing in the books of account, you should also prepare a list of those creditors. And those creditors list should form part of your information memorandum. So when you submit this particular, when you go forward and you submit this information memorandum along to the resolution applicant later on, they have notice of these particular claims that may come maybe beyond even 90 days, but before resolution plan is approved. And when they submit the resolution plan, they shall be deemed to have considered those debts which are there in the books of accounts. Though it is not required or specifically written in the act or regulation, we should follow this practice so that tomorrow we don't end up in the NCLT litigations about the claim submission, difficulties with the RA, that is resolution applicant, about whether this claim was informed to them or not informed to them, based on which the resolution plan would have been given by them. So therefore, to avoid this kind of complications and litigations later on, it is always better that you prepare a list of creditors based on the books of accounts, even for those creditors who have not submitted their claims. You have not verified their claims, but your books of accounts are dealing with it. Your books of account are admitting them as a creditor. So those claims should also, and that should form part of the information memorandum. In Navneet Kumar Gupta versus BHEL, NCLAT has ruled that under CIRP, the RP has no authority to reject the claim, part or whole. He is only required to admit a claim or call for more proof in support of the claim. In contrast, liquidator under section 40 has to determine the claim, verify the claim, accepting or rejecting, and the decision is appealable before adjudicating authority. In short, RP is a facilitator in the CIRP, while under the liquidator exercises quasi-judicial power. This is the ratio of Swiss Reserve case as well. So this is what the view in Navneet Kumar Gupta versus BHEL. Very important play where we are talking about. Just a second. Sorry for the interruption. So what is important is about what are the duties of the IRP. At CIRP stage, the duty is to collate the claim, to verify the claim, to examine the claim, and to verify and admit to the extent possible. However, in case of liquidation, you have quasi-judicial power where you have to verify the claim and then admit or reject the claim. In PTC India, Financial Services Limited versus Mr. Venkateshalu, Curry and others, NCLAT dated 20th June 2019, it was held that the RP can collate the claim and may accept full or part of the claim, but has no power to determine the claim or reject. The power is only vested with the liquidator. Similar position is held in this. Next is Regulation 14, which says determination of the amount of the claim, where the amount claimed by the creditor is not precise due to any contingency or any other reason. IRP or RP shall make best estimate of the amount of the claim based on the information available with him. IRP or RP shall revise the amount of the claim admitted, including estimates of the claim made as soon as may be practicable when he comes across additional information warranting such revision. Do understand there is a difference between revision or updating the claim and review of the claim. You'll say, sir, what is this now? Review of the claim is not permissible. You can revise the claim. For example, some claim has come to you. Based on the information you admitted the claim, now there are certain things which has remained under dispute. And based on further information, further documents and supporting documents that is being provided, you admit further claim and you may update your records based on the information available. So that is called updation of the claim. The new creditors have come, you will add those new creditors. That is called updation of the claim. But once the creditor is admitted, say for example, as a financial creditor, thereafter, for no reason, if you start reviewing and then further examining them after admission as a financial creditor, if you again want to review it, again want to verify that for whatever reason, and you change the position, you reduce the claim or you change the category from financial creditor to operational creditor, that is called review of the claim and that is not permissible. There is a judgment to that. We will discuss that also. But here, when we are talking about the revising the amount of the claim admitted, is only dealing with the updating the claim or updating the list of creditor. It does not mean the review of claims. In Swiss Ribbons Private Limited and other versus Union of India and others, writ petition civil number 99 of 2018 with connected matters, the Supreme Court held that RP has no adjudicatory powers. He has administrative powers as opposed to the quasi-judicial powers. He is a facilitator of the resolution process whose administrative function is overseen by the Committee of Creditors and by the adjudicating authority. Many times when you say, sir, claim verification and examining claim verification of the claim is the jurisdiction of the IRP-RP. Answer is yes. Then where the COC comes? COC will not have any role in this kind of efforts about the examination of the claim or verification of the claim. However, COC comes into picture where the guidelines or judicially the position of jurisprudence is broken, the law is broken, the guidelines are broken. Say, for example, when you want to, there are certain directory things, but you want to take decision whether we should accept it directory thing or we should ignore it. For example, admission of claim within 90 days. Whether claim submitted on 91st day or 92nd day, whether you should accept it or you should not accept it. That is where the role of COC will come. That is where we take a stand, that we approach to the COC, say that these claims have come after 98th day and whether we should admit it. And COC will take decision on that because COC is overseeing the entire process. And anything which is not directly given in the act, which is directly where things can be interpreted both ways, we put up to the COC. Of course, it's not relating to the law. When it comes to the law, even COC do not have jurisdiction. For example, someone is claiming as a financial creditor, whereas we have taken them as an operational creditor, verified, and according to us, it is an operational creditor. We admit the claim in operational creditor. For example, tomorrow it goes to the NCLT, and then we go to COC and say that this is a financial creditor or operational creditor. And COC determine the nature of claim. Answer is no. The role of COC is not to determine the financial creditor or operational creditor. That is a jurisdiction of IRP or R. So you should know where to go to the COC or where you should not go to the COC. COC has role in the commercial wisdom about the resolution plan, about the commercial decision. So far as the law is concerned, the first primary at IP level, you can take the decision about the verification of claim. Later on, NCLT can adjudicate the claim. So they have powers. Claim relating to employees and workmen. What are the jurisprudence so far? In Sunil Kumar Jain versus Sundaresh Bhatt 2022 judgment, it was held that dues towards the wages, salaries, and those employees or workmen who actually work during the CIRP are to be included in the CIRP cost and have to be paid in full first as per section 53(1)(a). Rest of the claims towards the wages or salaries of the workmen or employees before ICD shall be governed by section 53(1)(b) and C as applicable. Similarly, section 36(4)(3) specifically excludes all the amount due to any workman or employee from provident fund, gratuity fund, pension fund from ambit of the liquidation estate, and hence liquidator can have no claim over such assets. यानी अगर वो पैसा जो, even if see liquidation is PF and PF fund etc. Usually if it is through the EPFO, no problem. EPFO, I mean that remains with the EPFO and it does not form part of the liquidation asset. It does not form part of the corporate debtor. But many times this PF is maintained with the corporate debtor, trustees of the corporate debtor. In that situation also, the amount belongs to the employees and it should not form part of the liquidation estate. It should not form part of the corporate debtor. In Consolidated Construction Consortium Limited versus Hydro Energy Solution Private Limited, the Supreme Court on 4 February 2022 held that the debt which arises out of advance payment made to the corporate debtor for supply of goods or services would be considered as an operational debt. So many times this question queries arise even to me. Many IPs ask, sir, this deposit is made. for supply of goods or services, whether it form parts of the other creditors. Many times that conception is there that it is other creditor is neither financial creditor nor operational creditor. So the position is made very clear in consolidated transaction. If it is for the supply of goods or services, it is an operational part and it is an operational debt. Coming to the position about the home buyer, one of the very important area for IPs. Nowadays, many claim comes from the home buyer, especially in the real estate side. Real estate companies, you face these things. Complication arises on many queries arise also at a various level. Many times the payments are made in cash and they make a claim. Many times the payments are made, allotment letter is there, agreement for sale is not there. Whether these kind of claims are admissible or not. So all these questions come. We'll discuss. Let's first of all understand what the provision of law says about the home buyers, how things have emerged, and what are the various jurisprudence about the admission of the claim. So section 5(8)(f), first of all, relevant section about the financial debt of the IBC. Financial debt provides as under what it says: any amount raised under any other transaction. If you see the definition of the financial debt under 5(8)(f), it says any amount raised under any other transaction, including any forward sale or purchase agreement having commercial effect of borrowing. The word is very important, just like how we used to see about the time value for money, time value of money, same here, commercial effect of borrowing. It means it seems like a borrowing, it has impact like a borrowing. In that situation, it will be considered as a financial debt. So that is where home buyers, those who purchase the flat, who has booked the flat, they fall within this category. They have booked the flat. They have given advance for the sale or purchase agreement. And what happens in case timely delivery is not provided to them, flat is not provided within the possession period, then what happens? In that situation, in case of default, in most of the cases, the builder or the real estate company is required to pay interest over and above the bank rate in case of refund. So they will be liable for the refund along with interest at maybe whatever percentage, 2% or 2% above the SBI rate or 2% above the bank rate, etc. So those kind of clauses will be there, which shows the impact of commercial effect of borrowing. It also shows the time value for money. And LOT and real estate projects shall have the meaning respectively assigned to them in section 2D and ZN of RERA. So RERA Act में जो है क्या बोलता है RERA Act? What exactly is the LOT and what is a real estate project? Section 2D, LOT under RERA Act is defined as LOT in relation to real estate project means the person to whom a plot, apartment or building, as the case may be, has been allotted, sold, whether as a freehold or leasehold or otherwise transferred by the promoter, and includes the person who subsequently acquires the said allotment through sale, transfer or otherwise, but not included a person to whom such plot, apartment or a building, as the case may be, is given on rent. Real estate project. Real estate project means development of the building or a building consisting of apartment or a converting an existing building or a part thereof, or development of land into plots of or apartment, as the case may be, for the purpose of selling all or some of the said apartments or plots or building, as the case may be, and includes common area, development works, all improvement and structure thereon, and easement right and appurtenance belonging thereto. So this is the definition given in RERA. What are the jurisprudence? Some of the important jurisprudence I have taken. There are many judgments on the home buyer side, but few important which I feel is important I have taken. Home buyers can file the claim even after resolution plan is approved by the COC, but before adjudicated by NCLT. NCLT has allowed submission of the claim by the home buyers, even though the time period of submission has elapsed and resolution plan for the corporate debtor has been approved by the COC. In Appoogar, retail CIRP was initiated against the corporate debtor in August 2018 and RP was appointed. Last day of submission of claim was 11/11/18. The claim were, however, accepted till 2025, April 2019. COC approved the resolution plan on 22nd May 2019. Many LOTs of the real estate project missed the timeline because they were unaware of the initiation of the CIRP. And that is one of the reasons why communication with the claimant becomes important. Even now that amendment is made, that IRP or RP should inform or communicate with the claimants or the creditors about submission of claim and providing them the copy of public announcement and the order copy. So this communication becomes important. One of the reasons is that people are otherwise not even aware about the initiation of the CIRP. However, when they reach to the RP, he rejected the claims, saying the final revised amended plan, that is resolution plan, has already been obtained from the resolution applicant, and in order to provide crystallized information of liability to the RA, the claim cannot be accepted. That is what RP said. One of the home buyer filed a plea before the NCLT, pleading that their claim to be accepted. NCLT directed RP to accept the claim. And what they observed, it is respite to LOT of real estate project who missed the timelines because being unaware of the initiation of the CIRP, their claim to be accepted, their claim can be accepted even at the belated stage, that is even after the resolution plan has been approved by the COC and pending before the adjudication before the NCLT. So this position is very clear that even after 90 days, so far as home buyers are concerned, we should not, just because they are not aware and they have filed the claims after 90 days, we should not reject the claim. This approved judgment is very clear about that particular part, and especially for the home buyers. At least we should accept the claim, verify and examine and verify the claim. We should collect the claim. We should not reject or deny the claim just because they have been submitted beyond the statutory period of 90 days. So far as the definition of class of creditor, I'm sure you are aware, I'm not going into details of it. But if, say, for example, this company, home buyers, real estate company goes into liquidation, what is the position of the home buyers? Where do they stand? They stand in a capacity as an unsecured financial creditor under Section 53(1)(d). Can an LOT of the flat, who may not have registered agreement for sale, but still who can show the proof of payment and allotment through the allotment letter and other supporting document, etc., is financial creditor of a class? Logically, yes. They don't have any agreement for sale. They don't have a financial contract, but still a particular property is allotted to them. This becomes very subjective. See, again, what kind of supporting documents they provide, that is very important. In my view, if the corporate debtor have received the money and refund is not made, then definitely we should admit the claim. Certain documents may be there, certain documents may not be there. We have to see what best documents they can provide. But at least our company has received, the corporate debtor has received the funds. They may have agreement for sale. Some of them may have merely MOU. Some of them may have allotment letter. At least allotment is made. When it comes to the cash component, that is where the dispute arises. Someone claiming a cash which we cannot verify, we should not admit. Some of the claimant may say that we have paid 30 lakhs to the builder in cash. If our books of account doesn't reflect that, if it is not showing in the books of account, it is not showing in the bank account, they can't show in the bank account, we don't have any substantial proof which can show such arrangement, then we cannot admit those kind of claims. In Axis Bank Limited versus Samruddhi Realty Limited, 2022, 136 taxman, 319, Chennai NCLT, by order dated 22nd February 2022. It was held that where the LOT home buyer had approached to the bank for loan, which has disbursed by the bank to the respective LOT, which was disbursed by the LOT to corporate debtor. It means if I am a LOT and I am going to the builder to purchase a flat, to book the flat, but my flat is based on a loan granted by the bank. I am taking loan from the bank and purchasing this flat. This kind of arrangement we are talking about. Okay, so HB had approached the bank for the loan, which was disbursed by the bank to the respective LOT, which was disbursed by the LOT to the corporate debtor. And on corporate debtor now undergoing CIRP, the builder has gone to the CIRP and liquidation. The appellant bank filed the claim. Which is the appellant bank? Axis Bank. They have filed a claim instead of the LOT. However, the appellant bank had not subjectively satisfied that money which it was claiming to have been disbursed to the corporate debtor for time value of money as per 5.8. It doesn't show about the purchase of flat because bank had merely given the loan. Bank is not the flat purchaser. The LOT is the flat purchaser. The claim of the appellant bank was rightly rejected by the IRPRP because the claim should be submitted by the LOT. The bank had given loan to the LOT. The recourse of the bank is to the LOT. The LOT have in turn came from the CIRP. In Navin Raheja versus Shilpa Jain and others, the NCLAT held if the delay in possession of the real estate is not due to the corporate debtor but a force majeure, it cannot be alleged that it is defaulted by the corporate debtor in delivering the possession because it is under the force majeure event. That would also be a part of the agreement for sale which they execute. In Dr. Ramakant Suryanath Pandey versus CS Prakash K. Pandya, NCLT Mumbai on 5th February 2019 held, the scope of the RP is limited to verifying the claim received in light of the regulation 13 and 14 of the IBBI CIRP regulation. Is not adjudicating authority and is not required to inquire into the factual scenario between the parties and determine the rights or liabilities. The task of the IP is limited to limit the claim is received by him are true and correct. Means the claim which he has received is correct claim, that is based on the books of account, based on the documents available, that's it. The task of the RP is to limit itself to confirm that the claim received by him are true and correct. Verification is a process establishing the truth, accuracy, and validity of the claim. It is not meant of passing any judgment or making decision on the quantum of the claim. The GPR Power Solution Private Limited versus Supriyo Chaudhary, RP of Rohit Ferrotech Limited, order dated 29/11/2021. It was held that creditor's claim could not be rejected by RP as time barred if it is filed within extended deadline granted suo motu by Supreme Court due to COVID-19 lockdown. I'm sure we all are aware of Supreme Court judgment about the lockdown, extension of the lockdown and extension of the time period. So it shall be excluded while calculating the limitation period. The same thing that means saying, if you are adjudicating the limitation, then you need to take care of it. Otherwise, the safest way where there is a time bar or something, you should ask your further information and you may at your choice say if the claim remains under disputed, let it be adjudicated by NCLT. If you are sure about the adjudication part, if you are sure about the position of the limitation law, then you can decide about based on that, keeping the notes of it. Otherwise, law doesn't require when there is a time bar date or when about the limitation period, law doesn't require you to adjudicate it. It is a matter of adjudication to take a call whether it is time barred or it is not time barred. It is a judicial call. Therefore, if you are not thorough with the law about limitation law, you should not take call that. In Synergy Technology versus Parthiv Parikh, RP of Sanghvi Forging and Engineering Limited, order dated 18 April 2022. It was held where the appellant filed its claim as an unsecured financial creditor, but the same was not considered by the COC. The NCLT, while approving the resolution plan, the financial creditor who received major chunk of the RA should be refund original claim minus the amount received by the FC, financial creditor. Very interesting, one of its kind. It is not very common judgment. It is not something very commonly we see this, but this is one of the very unique judgments since I found. I thought, let me share with you. Where appellant had filed a claim as unsecured financial creditor, but the same was not considered by the COC. So COC had not considered that while approving the resolution plan. Claim was admitted, but it was not considered in the resolution plan. The financial creditor, so thereafter, whatever is the resolution plan that is distributed, again they have to refund back. And after considering this claim of the unsecured creditor, they have to redistribute the things. So it is one of its very different, unique judgment which I saw and I thought of sharing with you. In another unique judgment of Sumit Kumar Gupta, RP of Vallabh Textile Company Limited versus Vardhaman Industries Limited, the facts were RP rejected the claim on certain grounds, such as claim was filed on the basis of old authorization. The account statements filed with the claim was not sufficient to authenticate the claim amount. The claim of the financial creditor was already rejected by the IRP before, and the claimant cannot file belated claim again. These were some of the grounds which was taken by the IRP to reject the claim. The issue was whether RP is competent to decide or reject the claim of the financial creditor by himself without presenting the complete facts before the COC. Now here where the COC's role come? Usually not. But this is one of the unique judgment where enclared by order dated 27th July 2022 held that RP should not have rejected the claim without even discussing or presenting the facts about the claim to the COC. Usually, and based on this judgment only, I have taken a call that if it is crossing 90 days, because why RP need to go to COC at all? The jurisdiction lies with RP to verify the claim, to examine the claim. It is not COC's jurisdiction. It is RP's jurisdiction. But if it is belated, if it is beyond 90 days, that is where IRP or RP's jurisdiction, in my view, is questionable, because law says even if it is directly, law says 90 days timeline, and if you are accepting beyond 90 days, it is affecting the entire claim of all other creditors as well. And therefore, the view of the COC becomes important, that they should allow acceptance of the claim after 90 days or they should not. I usually take a call, directory call, which is under the law, based on the decision of the COC, because of these few, one or two judgment which has come from NCLAT, that COC's view should also be taken on certain things. That is where I involve the COC. Otherwise, for verification, I never involve COC. Verification, examination, that is my jurisdiction as IRP or RP. But when I am going through the directory provision where things are not 100% sure, not mandatory, but that is what the directory thing is, that is where I usually, if it is not requiring any legal adjudication, I usually involve the COC. While usually COC has no role or authority in acceptance or admissibility of the claim. In this specific judgment, the position was held uniquely by the NCLAT, which shows probably COC may also to be consulted or been discussed about the admissibility of claim, especially where it is disputed claim or where it is beyond the belated claims. Belated claim submission by claimants. Whether claim filed after 90 days of insolvency commencement date, IBICD, is also required to be verified and accepted by the RP. There are contradictory views by various adjudicating authority on it. In cases like Mukul Kumar, RP of KSC Infrastructure Limited versus RPS Infrastructure Limited, NCLAT order dated 30th July 2021 held that CIRP is a time-bound process and claim may be accepted by RP specified as specified in section 12.2, that is within 90 days timelines. In R. Ratarajan versus Mr. Radhakrishna Dharamrajan, RP of Appu Hotels Limited, NCLT Chennai, order dated 15 July 2021, it was held that belated claim cannot be accepted and accepted at belated stage, especially when resolution plan is approved by the COC, is pending before the NCLT. So usually this claim cannot be accepted. There are 2-3 judgments of that nature. However, there are few judgments which also, especially when it comes to the home buyers, it says the claim should be admitted. So special privilege of ignorance is given to the home buyers in this case, that they probably are unaware of the CRP process and the claim submission, public announcement, etc. And therefore, they are given by these judgments an extra leeway that their claim should not be rejected. So, however, the contrary view is taken in this Asset Reconstruction Company Private Limited versus Edel Landmark, Edelweiss Asset Reconstruction Private Limited versus Edel Landmark Limited, NCLT Principal Bench held that rejection of the claim on ground of delay is not sustainable because the provision has been held directly. It was further clarified that RP shall make note of these repeated orders passed by the NCLT, clarifying that the claims of the home buyer cannot be rejected on the ground of delay, as provision has been held to be directory. For home buyers, they say it is directory only, and you cannot reject the claim merely because they were submitted claim belatedly. But when it comes to the operational creditor, at times the judiciary has taken a call that the claim should be submitted within 90 days. You cannot delay it. So both contradictory views are there, but for home buyers, the views are very, very clear, and court has specifically said that RP should take note of it. That there are various judgments that for home buyers, claim cannot be rejected on the ground of delays, so far as resolution plan is not approved at NCLT stage. Question also comes, what happens if there is after NCLT? Approval after NCLT, usually it gets extinguished. So we'll deal with those judgments as well. In Punit Kaur versus KB Developer Private Limited, NCLAT, on 1st June 2022 held that where the home buyers have filed their claim before RP, after resolution plan was duly approved at COC, but before approval of the resolution plan by the adjudicating authority, the claim could not have been included in the list of creditors. However, such home buyers' claim were not extinguished. See the position. The position said, NCLT took a view that we do understand that probably you have not included them in the list of creditors because the resolution plan is already passed by the COC. But still, the home buyer's claim were not extinguished because it extinguished only once the resolution plan is approved by the NCLT adjudicating authority. As extinguishment of the claim of home buyer would happen only after approval of the plan by A. Further, when home buyer had booked the flat, the corporate debtor, and made the payment, and their claims were reflected in the records of the corporate debtor, that is books of accounts of the corporate debtor, the same ought to have been included in the information memorandum. And the resolution applicant ought to have taken note of the said liabilities and should have appropriately dealt with in the resolution plan. And hence, the resolution applicant was directed to prepare addendum to the resolution plan by including such claim of the home buyers. So same position like earlier, that even if the claim is not included in the list of creditor, even if the resolution plan is passed by the COC, but it is pending before the NCLT, still the claim of that home buyer should have been included because it is there in the books of account of the corporate debtor. It should be made part of the information memorandum. That is how it is deemed to have notice or constructive notice to the resolution applicant. And resolution applicant, while giving the resolution plan, shall be deemed to have considered that If they have not done, they are directed to make an amendment or addendum to the resolution plan by including the claims of the home buyers. I hope home buyers के लिए जो position है, you are very clear about it. In Ruchi Soya Industries Limited versus Union of India 2022, 139 taxman to 226, Supreme Court held that once the resolution plan was approved by the adjudicating authority, all claim provided by the resolution plan would freeze, and all such claim which were not part of the resolution plan would not survive. It gets extinguished. But that is after approval of the resolution plan by the adjudicating authority. In Ghanshyam Mishra and Sons Private Limited versus Edelweiss ARC Limited 2021, IBC law.in 54 Supreme Court held on 13th April 2021 that claims of the respondent prior to the approval of the plan cannot be continued. Equally, the claims which are not part of the resolution plan shall stand extinguished. Thus, on date of approval of the resolution plan by adjudicating authority, all the claims which are not part of the resolution plan shall stand extinguished. In PR Director General of Income Tax versus Synergis Dure Automotive Limited and others, Enclate 23 2019, very important judgment also held that once the resolution plan is approved, it shall be final and not subject to modification, even if statutory claims are not included in the plan. Many claims would be there outstanding in the books of accounts of the corporate debtor, but are not filed by the claimant of the creditor. How to deal with it? In my view, we can reach out to the creditors as required under Rule 6A and seek their claim in the manner set out therein. If required, if they still have not submitted the claim, we can send them reminder. Despite of that, if they are not submitting the claim, we may include or incorporate such claim in the information memorandum so that when the resolution applicant can consider the same while submitting the resolution plan, and the claim, if submitted in the later date, can be redressed, and resolution applicant also remain protected about this coverage. So once it is included, any claim or the debt as specified in the books of account of the corporate debtor, but claim is not being received. As I said, you prepare the separate list of the creditor as per the books of account whose claims have not been received. Include that list in the information memorandum so that it goes to the knowledge of the resolution applicant, and resolution plan takes duly address those kind of claims as well, even if it comes later on after submission of the resolution plan, after approval of the resolution plan by the COC. These claims can be addressed. Even it should be included in the resolution applicant, by the resolution applicant in resolution plan. So that is how your approach should be, looking at the books of those debts which are there in the books of accounts. How to approach the time barred debt, time barred claims. Say for example, where there are no transaction with corporate debtor in last 3 years and debt is of prior to 3 years. Firstly, examine that corporate debtors books of account admits that as a liability. The question of limitation doesn't arise, because if it is already admitted in the books of accounts of the corporate debtor, it is still an acknowledgement of debt. The question of time bar doesn't arise, limitation doesn't arise, because it is still admitted. That is an acknowledgement of debt. Secondly, if the debt is already acknowledged during last 3 years, or litigation is going on before some court or competent authority or competent jurisdiction of the court of competent jurisdiction pertaining to same debt. Now, because of the moratorium, that proceedings would undergo moratorium, but that timeline have to be excluded. Again, the question of limitation doesn't arise. The claim is not time barred because it is already going on. The litigations are going on, so that time is to be excluded. Logically, RP is not supposed to adjudicate the claim if there is a dispute about limitation. In that case, RP would apply the limitation limitation law and remains as a disputed claim, not admitted by the RP. As I said, usually by practice, what we do, since I am also advocate and solicitor, I am thorough with the limitation law as well. So I take one step ahead and try to verify the claim based on the information available, considering all these aspects. And then if I am very clear that claim is time barred, I do take a call that claim is a time barred in my view. However, if the other party disputes to it, I say then I will keep you in the disputed category to go and get it adjudicated through NCLT. So I am not rejecting your claim. I am keeping it under the category of disputed claims. As a IRP or RP, I am not the adjudicating authority to reject the claim after adjudication. So I will never adjudicate that. I am based on my best measure, best efforts. I am of the view that it is a time bar. And I have taken many claims which are time barred and I have thrown them out. 2009 के claim आते थे, 2008, 2006 ऐसे पुराने claim भी आए हैं मेरे पास. 2011-12 के तो आज भी आते हैं. So those kind of claim which are we considering that they are time barred? Not necessarily. You have to see many aspects. Just because claim is coming from 2011 doesn't mean that it's a time bar. It is possible 2011 से वो अपने बैलेंस शीट में दिखा रहा है, कॉर्पोरेट डेटर के बैलेंस शीट में कंटिन्यूअस आ रहा है क्लेम लोन टू द कंपनी, and till date we are accepting that as a loan. How can I consider that as a time bar? So जरूरी नहीं है कि तारीख पुराना है, 3 साल से पुराने तो time bar हो गया. You have to understand many things. So it is a technical subject. If you are not thorough with that, you should consider that as time barred, and you can say if other party is disputing, you can say it remains under dispute. You kindly get it adjudicated through NCLT. If you are not sure about it, if you are sure that there is acknowledgement date till date it is appearing in our books of account and that is legitimate, you can admit the claim. So that is about the time bar date. In PTC India Financial Service Limited versus Venkatachalu Kari, 2022 138 taxman.com, on 12/5/2022, the pledgee, upon occurrence of the default by corporate debtor, invoked the pledge by registering shares in favor of the beneficial owner, reserving right to sell the shares. However, the shares were not sold, so shares remained in the name of the corporate debtor, and the claim was filed. Since the beneficial owner was changed, but the shares were still in the name of the corporate debtor, the claim can still be filed since the asset was still in the name of the corporate debtor. Accordingly, the same did not have effect of sale of shares as a pledgee, and he can file the claim as a financial creditor capacity as a pledgee. So invocation of pledge was not complete. He had not sold the shares. So his claim still remains in capacity as a pledgee. In Kotak Mahindra Bank versus A. Balakrishnan 2022 136 taxman.com 138 on 30/5/2022 held that liability in respect of the claim arising out of recovery certificate issued by the DRT would be a financial debt within the meaning of the 5(8). It's a forwarding contract. And consequently, holder of recovery certificate would be entitled to initiate CIRP if initiated within 3 years from the date of issue of the recovery certificate. So far as it is within the timeline, Limitation Act, recovery certificate will have the same character as the original debt was carrying. So if the original debt is of the operational debt, recovery certificate, based on recovery certificate, you can admit the claimant as an operational creditor. If the original debt is a financial debt, then based on recovery certificate, you can admit the claimant as a financial creditor. So the nature of debt would not change just by recovery certificate. So if the underlying transaction is operational debt, the claimant would claim under as an operational creditor. Recovery certificate is just an additional evidence. That is just an order of the court about the debt. Now coming to another one or two important judgments in Orator Marketing Private Limited versus Samtex Desins Private Limited. Decision of 26 July 2021 held that a lender who has advanced interest-free loan to the corporate debtor will be a financial creditor under the IBC. The emphasis is applied on the word interest, if any. If you see the definition of financial debt, so what it says, the loan or the financial debt along with the interest, if any. So when I say if any means there may be interest, there may not be interest. So just because there is no interest, you cannot take a call that there is no time value of money. That there is no time value for money and therefore it is not financial debt. It is not like that. Interest may be there, interest may not be there. That is what the judgment says. It's a Supreme Court judgment in Mr. Rajneesh Jain versus BVN Traders and other, enclosed by its own order dated 18 December 2020, held that neither the COC has power to determine nor the RP has power to reclassify the status of creditor from financial creditor to operational creditor under IBC. In this same judgment, Enclave has also observed the expression time value for money has not been defined under the code, and hence one has to revert to the dictionary meaning of the phrase generally understood. The time value for money concept says that cash received today is more valuable than cash received at some point in future. Means ₹1 का जो आज वैल्यू है उसका वैल्यू फ्यूचर में जो ₹1 का वैल्यू होगा वो कम होगा. Means there is a discounted cash flow. We all are aware what the discounted cash flow mechanism is all about. The same concept. That today what one value, rupee of one value is more than the rupee of one value tomorrow. So that is why the interest is paid. That is how the loan interest is considering as a time value for money. NASDAQ glossary of financial terms define the phrase time value for money as an idea that $1 today is worth more than $1 in future, because $1 received today can earn interest until the time the future dollar is received. Clear about it? So that is how it is. But this, I am sure you understood what this thing, because I see in practical life also many times IRP or RP simply classify the claim at their own discretions. IRP or RP, again in the same judgment which I spoke to you, in Rajneesh Jain versus BVN Trader and others, the court has also taken a view that IRP has power to update the claims, update the list of creditors. They do not have power to review the same. Review is not within the same. So today, if I have admitted the claim as a financial creditor, tomorrow I myself review it and then change the position from financial to operational creditor. Can I do that? That is where this judgment was entirely about. That you cannot do that as IRP or RP. You are not supposed to review by your own motion. If some claim is wrongly admitted by you, it is required to be adjudicated. There is no other mechanism. You cannot by your own self change or reclassify the claim. Even COC do not have that power, because COC will have their own vested interest to classify. I mean, this is a legal matter. Whether a person is a financial creditor or an operational creditor, that is a matter of fact under law. It is not matter of, in this particular judgment, Rajneesh Jain versus BVN Trader, COC had passed the resolution that a particular person is not a financial creditor. BVN Trader is not a financial creditor. And what rationale they had done? Rationale, the claim was put before the COC. The rationale they gave that we wish that BVN Trader is not a financial creditor. And Enclad has specifically raised objection to this. And what do you mean by we wish? It is not about your wish. It is about the position of law. And that's why they said COC do not have any jurisdiction to adjudicate the claim. They do not have power. It is not about the commercial wisdom. It is not the position of commercial wisdom. So if you read, this is very important judgment. If you read through in detail, it is very interesting. A lot of powers of the IRP, RP, or even COC is coming out from this judgment. If you go through in detail, what observations have been made by the Enclad in this judgment, Rajneesh Jain versus BVN Trader, it will be very interesting. That is where will understand अपनी लक्ष्मण रेखा कहाँ तक है इस IRP और RP. So we need to understand that. In the matter of SK Wheels Private Limited, miscellaneous application number so and so, adjudicating authority noted that IRP did not take any decision even after 4 months of submission of the claim by the applicant of the claim of his claim. It was held that the action or rather inaction by RP is not taking in not taking the decision on claim is his abuse of power under the code and contrary to justice and public policy. It directed RP to hand over the possession of the premises forthwith to the applicant and pay the amount claimed by him with the cost of rupees 1 lakh to the applicant. RP के ऊपर cost डाला 1 lakh रुपए because it is utter negligence by the RP that for 4 months he is not admitting the claim, he is not communicating about it. So it's an abuse of power. Limited versus State Bank of India, RP filed application against a notice issued by the Union of India demanding 100% of the sale proceed invoice in favor of government for recovery of $314 million together with interest towards the unpaid government share of the profit petroleum. UI contended that profit petroleum is the asset of the government and out of the ambit of the section 14 of IBC. Therefore, the moratorium is not applicable in recovering its own asset. While holding that moratorium is applicable, the adjudicating authority said, at the most, Ministry of Petroleum can lodge its claim on any legally enforceable right for recovery of the appointed recovery to the appointed RP, being not rendered remediless as prescribed under the IBC. So if you have claim in capacity as an operational creditor, you submit your form B. That is what NCLT said. In addition to the information above, now coming to the claim verification, how we can link with the IM. I don't know how many of IRP or RP is directly doing it because it's not directly given in Act, but it is advisable coming from the various judgment. In addition to the information about the claims submitted by the IRP or RP, IM should also contain the information about the disputed claims requiring adjudication. Why I am saying so? Whatever claims are disputed, which needs adjudication, tomorrow it may go into adjudication and the claim is, let's say, for example, under direction of NCLT, the claim is required to be admitted. In the meantime, if your resolution is already passed, tomorrow resolution applicant may say, I am not having notice of this particular claim. I was not informed about it. Why should I pay for it? So disputed claim also you should put in the information memorandum. Ultimately, it goes to the resolution applicant and they will have constructive notice of this claim as well. So that is the claim received without sufficient document. What are the disputed claim? When I say disputed claim means claims received without sufficient document in support of the claim and hence RP could not admit, or the claims is not admitted by the RP, being disputed claim for position about the amount or about the character, or the time barred claims disputed by the claimant, or the claims which was already under the court litigation or contingent claims, etc. Liability appearing in the books of account, but no claim form has been filed by the claimant. Invocation of the guarantee not been made, or the notice received as a contingent claim. All these things are covered under disputed claim and that should be very clearly set out in the information memorandum. So tomorrow when this claim gets crystallized, any of these claims get crystallized, resolution applicant will not have defense that I was not aware of it. There was this particular things have not been considered while giving the resolution plan. They will not have that kind of defense. So as a IRP, RP, we should be very cautious while we verify the claim about these aspects. Now coming to the claim verification part. Rule 12.2 of the public announcement says, I am talking about the liquidation process, liquidation regulations. So regulation 12.2 says the public announcement shall call upon the stakeholder to submit their claims or update their claims submitted during the CIRP as on liquidation commencement date. and provide the list, the last date for submission or updation of the claim, which shall be 30 days from the liquidation commencement date. Provide that where the stake, so what the timeline here for claim submission is 30 days from liquidation commencement date. Provide that where a stakeholder does not submit its claim during the liquidation process, the claim submitted by such stakeholder and duly collated by the IRP or RP as the case may be during the CRP process shall be deemed to be submitted under section 38. So even those claims which are submitted in the CRP process that shall be deemed to have been submitted in liquidation process, even if the fresh claim during the liquidation process is not submitted. So those claims can be admitted as it is without any updation. Regulation 16 talks about the submission of the claim. A person who claims to be a stakeholder shall submit the claim or update its claim submitted during the CIRP, including interest, if any, on or before the last day mentioned in the public announcement. That is 30 days timelines. A person shall prove its claim for debt or due to him, including interest, if any, as on liquidation commencement date. So creditor have to definitely prove their debt. So what is the timeline? It is about the 30 days. What about now further? The IRP is also required, the liquidator is also required to verify the claim within a period of 30 days. Once the claim is submitted by the claimants within a period of 30 days, the liquidator is also required to verify the claim in 30 days. That will come later. So here when we are talking about the submission of claim, the claim is required to be submitted by the claimant within 30 days from the liquidation commencement date. Financial creditor may submit the claim to the liquidator by providing a record of such claim with information utility. So financial creditor may simply submit the record of information utility, and that would be sufficient evidence. At liquidation stage I am talking about. So only record of IU is also sufficient, provided that where information relating to the claim is not recorded with IU, the financial creditor may submit the same in the manner provided for OC. Now, what is manner provided for OC? OC may submit the claim to the liquidator in such form and in such manner and along with such supporting documents as required to prove the claim as may be specified by the board. So, it is given in the act what documents are required. We will do that later. क्या supporting documents लगाने हैं वो सारे financial creditor के भी और operational creditor के भी. All those documents are meted. So financial creditor, if they do not have this record of information utility, in that situation they have to provide all these supporting documents which are provided in the regulation. We'll do that. आगे आएगा. The creditor who is partially financial creditor and partially operational creditor, they shall submit the claim to liquidator to the extent of his financial debt in the manner as provided for financial creditor as above, and to the extent they are operational debt in the manner provided as an operational creditor as above. So when the person is both financial as well as operational creditor, they have to file both the forms relating to financial debt as well as to the operational debt, separate form. The creditor may withdraw or vary his claim in this section within 14 days from the submission. Now this becomes very crucial. A creditor may withdraw or vary his claim within this section within 14 days of the submission. They have power to withdraw the case. Creditor can be a financial creditor also, operational creditor also. Why these powers are not there in the CIRP? Have you observed that? In the CIRP process, there is no such provision relating to withdrawal of the claim. You can submit the claim. And this becomes very important, very significant. I'll explain you a practical case which I'm facing right now in one of the matter. Practically, I have seen this happening. In CIRP, only one bank had a claim. Loan tha, the claim CIRP process was initiated by the operational creditor. And IRP was appointed by the operational creditor. Thereafter, when the claim was invited, one bank had some loan on the company. So that bank particularly gave claim submission during the CRP process. Based on the claim submission, the claim was admitted and the COC was formed for that particular bank. The decisions were taken by that bank. Later on, what happened? Later on, when we IRP came out with the data, the company or corporate debtor was not having any asset. कंपनी के पास पैसा मिला नहीं, वैल्यूएशन में कुछ भी नहीं है वैल्यू, या तो बहुत नॉमिनल वैल्यू समझ लो. तो अभी क्या करेगा? For COC, only one bank is there. Now in that one bank also, they feel a pain of carrying out the CRP process because as you know, CRP process ka cost COC bank has to contribute. There are ample judgment on that. If bank remains in that, they'll have to pay for good money for bad money. Probably they will not be able to recover even the CRP cost after looking at the asset. वो लोग अपना खुद का जो पैसा CRP प्रोसेस में लगाएंगे शायद वो भी नहीं निकलेगा. Now bank says, I want to withdraw it. I don't want my claim. Because यहाँ पे रहेंगे तो पैसा डालना पड़ेगा COC रन करने में. Then what? In CRP process, there is no such provision. This is a practical thing I am facing right now in one of the matter where I am consultant. There is no mechanism for withdrawal. But can anyone stop me from withdrawing? No. If you stop me from withdrawing, what happens? I will not contribute anything to the COC. I will say we close the company. There is nothing else remain. Go to the liquidation directly. Company don't have any asset. Then the rights of the operational creditor who has some hopes in this recovery, that will also get vitiated. So that is where here in a liquidation process, what I am trying to say is in liquidation process, there is still a mechanism within 14 days at least I can still withdraw my claim or I can modify my claim. In CRP process, there is no such mechanism written in the law. Section 40, admission or rejection of the claim. Liquidator may, after verification of the claim, either admit or reject the claim in whole or part. If you see the language here, it's very clear. The liquidator has power to accept or reject the claim. This language is not there in CIRP. There the language is IRP or RP shall collect the claim. They will collect the claim. They will examine the claim and verify. They do not have adjudication power. Here it's a quasi-judicial power liquidator has. So here they say it's a act specifically provides that they may either accept or reject the claim in whole or in part. Where the liquidator rejects the claim, he shall record in writing the reasons for such rejection. Liquidator shall communicate his decision of admission or rejection of the claim to the liquidator and CD within 7 days of such admission or rejection of the claim. Again, this is very important. It is not there in CRP. Do understand the difference between the CRP process and liquidation process. Liquidator has to admit or reject the claim. But when it rejects the claim, he has to record in writing the reasons for such rejection. This is called communication also. He is bound to communicate to the claimant about his admission or rejection of the claim. This is not specifically mentioned in the CIRP. Of course, by practice, we always give the reason. If there is any cause for dispute or rejection, we always give the reason, detailed reason, that why we are having dispute to the position. But there, our duty in CIRP, the duty of the IRP or RP is to collect the claim and admit the same to the extent possible to see the true and correctness of the claim. That's it. There we are not deciding and rejecting the claims. The position can remain in dispute. Appeal against the decision of the liquidator. A creditor may appeal to adjudicating authority against the decision of the liquidator accepting or rejecting the claim within 14 days from the receipt of the decision. So appeal can lie against the decision of the liquidator. Rule 30, verification of the claim. The liquidator shall verify the claim submitted within 30 days from the date of receipt of the claim and may either admit or reject the claim in whole or in part as the case may be. Further, the liquidator shall also verify the claim collated during the CIRP but not submitted during the liquidation process. So, यहाँ पे तो specific, like in CIRP process, IRP has to see the books of account. IRP also have to prepare what are the debt in the books of account, who are the creditors in the books of account. And then सबका claim लेना है and you have to prepare the list of creditor based on claim received. Not as per the books of account. Books of account, rest of the creditors who are there in the books of account, that will go into information memorandum. But here, Rule 30 says, liquidator shall verify the claim submitted within 30 days from the date, and liquidator shall also verify the claim collated during the CIRP process, but not submitted in liquidation process. Within 30 days from the last day of receipt of the claim during the liquidation process, and may either admit or reject the claim, either whole in part. Rule 30A says about the transfer of debt due to the creditors. A debtor may assign or transfer the debt to any other person during the liquidation process in accordance with the law for the time being in force dealing with such assignment or transfer. Where the creditor assign or transfer the debt to any other person, both the parties, that is assigner and the assignee, shall provide to the liquidator the terms of such assignment or transfer and identify of assignee or transferee, identity of the assignee or transferee. The liquidator shall modify the list of stakeholders as per provision of Regulation 31. So based on that, the list will be updated about the claims. Coming to the claim by the operational creditor, claim can be submitted by the operational creditor of the city other than the workman or employee shall submit the proof of claim to the liquidator in person or by post or by electronic means in Form C of Schedule 2. Existence of the debt due to the OC can be proved by the record of IU, if any, or other relevant documents such as contract for the supply of goods or services to the city, invoice, order of the court or tribunal, if any, or financial accounts, same like how we have in the CRP process. So I'm taking liberty, you are aware of it. So I'm just going it too fast. Then what are the claims submitted by financial creditor, claim submitted by the operational creditor, claim submitted by the workman. The same position like how we have in the CRP process, similar documents are there, similar positions are there. I'm just taking it as a read. Though provisions are there in my PPT, it's the same provision, only form numbers are different. And form numbers, revised form numbers are this: operational creditor Form C, financial creditor Form D, workman and creditor Form E, authorized representative Form F, and other stakeholders in Form G. So these are the forms which are required to be filed. Regulation 21, which deals with the providing of security. Existence of the security interest may be proved by the secured creditor on the basis of record available with the IU, if any, or certificate of registration of charge issued by the registrar of company, or proof of registration of charge with the central register surfacing. If you link this provision with the Companies Act also, there also, if you see the provisions about the charges, you will understand that liquidator will not admit the claim of the financial creditor until this charge, duly charge, is properly recorded and proper proof is provided. These are all synchronized provision. Similar provisions linking to this is there in the Companies Act as well. Similarly, coming to presumption about the security interest, not directly relevant, that's why I marked it black, that not directly related to our claim submission. But while claim submission, this is one of the process that where the secured creditor may relinquish the security, and if they relinquish the security, what process is required to be followed. This entire process is also given under Regulation 21, and how this, what amount is required to be paid. This in amended provision, that where the secured creditor feels that they don't want to form part of the liquidation process and they don't want to relinquish the security. In that case, what happens in that case? from the sale proceeds which they received, they have to pay the amount as required under 53(1)(a) and 53(1)(b)(1), that is the priority of claim, that is CRP cost, as well as the cost relating to the claims of employees, 24-month salary of the employee. That will be paid first, and rest of the amount, excess amount realized, can be kept by the secured creditor towards the security interest. I'm not reading that again because this is not directly relevant for the claim submission, but that is process which is given. Regulation 22, production of bills of exchange and promissory note, that the person seeks to prove a debt in respect of the bills of exchange or a promissory note or other negotiable instrument or security of like nature, or the corporate debtor is liable. Such bills of exchange, note, instrument, or security, as the case may be, shall be produced before the liquidator before the claim is admitted. Now here, this all regulations 22, 23, 24 onwards, all the regulations deals with up to 28. It deals with how the claim is required to be verified with different instruments. So how, for example, there is a bills of exchange. For example, there is a foreign currency involved. For example, there is a bills of lading is there. What kind of proof is required? What further documents are required? So all these things are provided with these regulations. Regulation 24 deals with the cost of proof. A claimant shall bear the cost of proving the claim. Costs incurred by the liquidator for verification and determination of the claim shall form part of the liquidation cost. However, if the claim or part of the claim is found to be false, the liquidator shall endeavor to recover the cost incurred for verification or determination of the claim from the claimant and shall provide the details of the claimant to the IBC. Determination of the quantum of the claim. Where the amount claimed by the claimant is not precise due to the contingency or other reasons, the liquidator shall make best estimate. Now, this best estimate is very vague, but then this is how it can be. But you should not take shelter behind best estimate and make any kind of assessment or any kind of, by admission of the claim without proper verification. Best estimate means after. It is implied that best estimate means you've taken your due care. You've taken best of the endeavors to establish the claim. That is what the best estimate is. Best estimate of the amount of the claim based on the information available to him. Debt in foreign currency. The claim demonstrated in the foreign currency shall be valued in Indian currency at official exchange rate as on liquidation commencement date. The explanation says the official exchange rate is reference rate published by the RBI or derived from such reference rates. So that is how if it is in the foreign currency, what value you should take or exchange rate you should take, that is what it is. Periodical payments. In case of rent, interest, or such other payment of periodical nature, a person may claim only for the amount due and unpaid up to the liquidation commencement date. Debt payable in the future date. A person may prove for a claim whose payment was not yet due on liquidation commencement date and is entitled to distribution in the same manner as any other stakeholder, subject to the contract to the contrary, where the stakeholder has proved for a claim under sub-regulation 1 and the debt has not fallen due before the distribution, he is entitled to distribute the admitted claim reduced as follows. X divided by 1 plus R is to N, where X is the value of admitted claim, R is the closing yield rate of the government securities of the maturity of N, is the date of distribution as published by the RBI, and N is the period beginning with the date of distribution and ending with the date on which the payment of the debt would otherwise due or expressed in years, months, and decimal form. Regulation 29 says mutual credits and set off, where there are mutual dealings between the corporate debtor and another party. The sum due from one party shall set off against the sum due from the other is arrived at the net amount payable to the corporate debtor or to the other party. That is, X owes rupees 100 to the corporate debtor, CD owes rupees 70 to the X. After setting it off, the net rupees 20 is payable by X to CD. So that is how we all are aware of what the set off is. So I am not going into detail of it. Regulation 31, list of stakeholder. The liquidator shall prepare the list of stakeholder category wise, that is operational creditor, financial creditor, other stakeholder, stakeholder of a class, all these things on the basis of proof submitted, proof of claim submitted and accepted under these regulations with the amount of claim admitted if applicable, the extent to which the debt or dues are secured or unsecured if applicable, the details of stakeholder and the proof admitted or rejected in part and the proof wholly rejected. So you have to distinguish between all these categories of the claim. The liquidator shall file list of stakeholder with the adjudicating authority within 45 days from the last date of receipt of the claim. Liquidator may apply to the adjudicating authority to modify an entry in the list of stakeholder filed with adjudicating authority when he comes across the additional information warranting such modification, and shall modify the entry in such manner directed by the adjudicating authority. Liquidator shall modify an entry in the list of stakeholder filed in the filed with the adjudicating authority in the manner directed by adjudicating authority while disposing of an appeal preferred under section 42. The list of stakeholder as modified from time to time shall be available for inspection by the persons who submitted the proof of claim. Again, this list of stakeholder is available to all the persons who have submitted the proof of claims for their claim. So all the creditors available for inspection by the members, partners, directors, guarantors of the city, displayed on the website, if any, of the city, filed on the electronic platform of the board for dissemination of its website. In Swiss Robin case, order dated 25/1/2019, Supreme Court, while holding the constitutional validity of IBC, held that no adjudicating power, this becomes very important now, no adjudicatory powers have been given to RPs. RPs are given administrative powers only opposed to the quasi-judicial powers, as has been sought to be canvassed by the petitioner. Just boxing the powers of the liquidator and RP, a clear distinction emerges as to the nature of powers. A determination of the value of claims by the liquidator is quasi-judicial in nature and amendable to review by the adjudicating authority. Lastly, as compared to the liquidator, RP is fettered by approvals required from COC and their general oversight. So therefore, this is where it is very clearly distinguished in the Swiss Ribbon case about the powers of the IRP or RP, how it is different from the liquidator. In liquidation stage, liquidator is fully empowered to adjudicate the claim. I mean to say, accept, admit or reject the claim. And above that, the appeal can be filed to NCLT. Whereas in COC, it is collation of the claim by the IRP, RP, and it is always supervised by the COC. Navneet Kumar Gupta versus BHEL. Again, I think we already dealt with this case. NCLAT has ruled that under CIRP, RP has no authority to reject the claim, part or whole. He is only required to admit the claim or call for more proof in support of the claim. In contrast, liquidator under section 40 has a power to determine the claims, accepting or rejecting, and the decision is appealable before the adjudicating authority. So adjudicatory powers are there with the liquidator at liquidation stage. In short, RP is a facilitator in CIRP, while under the liquidation, the liquidator exercises quasi-judicial power. This is the ratio of Swiss Ribbon case. Few more judgments coming to the liquidation stage. SBS Transport Logistics Company Limited versus Synergy Container Line Private Limited and others. NCLT Principal Bench on 4th September 2019 clarified position about the acceptance of claim during the liquidation process and held that the claims made before the distribution of assets has commenced by the liquidator shall be duly considered. The liquidator denied the petitioner's claim on the ground that he could not include the claim after liquidation process commenced unless permitted by adjudicating authority. The NCLT observed the claim was already reflected in the balance sheet. NCLT observed that it is duty of the RP or liquidator to ascertain all the claims. It is the duty of the liquidator to collect all the claims whether or not filed by the claimant. Until the asset or funds are distributed, very importantly, until the assets or funds are distributed, a verified claim cannot be rejected. It is the duty only after the distribution of assets that no further claim can be entertained. You know, when this law was emerging or growing, many times, many liquidators, IPs have asked me this question. Sir, as per the IBC regulation, claims are required to be submitted within a period of 30 days. And thereafter, within the next 30 days, you have to verify the claim. What happens in case the claim is not submitted in 30 days? Law is silent about it. Law doesn't say anything. Should we accept the claim? Should we verify the claim? Say, claim is coming after 50 days. Claim is coming after 80 days. Claim is coming after 1 year. Should we still admit the claim? Should we still verify the claim? The ratio is in this judgment that until the assets or funds are distributed, you are supposed to admit and verify the claim so far as it is as per your balance sheet. The claims are correct. You have to verify the claim. And a verified claim cannot be rejected till the company has assets which are distributed. It is only after the distribution process is over, means company now doesn't have anything left, company has no asset left, everything is distributed. Only thereafter, no further claims can be entertained. In Aditya Birla Finance Limited versus CA Padma Appana, liquidator of Messrs. RE Cables and Conductor Private Limited, NCLT Hyderabad on 5th January 2021 held that the liquidator was correct in rejecting belated claims as she does not have any authority to entertain the same when distribution of assets has been completed by the liquidator and application seeking the order for dissolution of the company is pending before NCLT. So here the distribution process is over. Company's assets are sold, the amount has been distributed, and thereafter if the claim is coming, then liquidator has to reject the claim. So this is about that judgment. Liquidator was correct in rejecting belated claims as she does not have any authority to entertain the same when the distribution of asset has been completed by the liquidator. Clear about it? So this thin difference, you need to understand up to what level you have to accept the claim or admit the claim. And finally, the matter of Gauri Component Private Limited, it has been held that delay in filing liquidation claim cannot be a ground for rejecting the claim by the liquidator. So just because there is a delay, 30 days में claim submit करना था, 30 days cross हो गया, 45 दिन हो गया, 60 दिन हो गया, 90 दिन हो गया, 120 दिन हो गया, 1 साल हो गया. That cannot be a ground to reject the claim. However, you are supposed to, as a liquidator, you are supposed to verify the claim within period of 30 days of last day of receiving the claim. Same principle applies. Okay. So with this, we finish the jurisprudence part of it, the judgments and the position of law. If there is if you have any judgment, if you have any queries, you can ask. Otherwise, I'll take to 1 or 2 judicial positions where we can discuss how the courts have viewed as I said, one or two Rajneesh case and that, how court has taken the judicial view. I'll take that. If you have any queries or doubt, you can ask me. We can discuss that, and then I'll take that judgment. Any queries? There is no query. I think there are a lot of chats. I think questions are there or what it is. Okay, I think there are quite a few queries are there on chats already. So I'll take one by one each of them.
Mr. Shah, I would like to ask you one question, sir.
Yes, sir. Please go ahead.
I have one claim before me in a real estate matter.
Yes.
RERA has given one order in 2019, keeping in view of the complaint filed with before them. They have prohibited the company for any further allotment of the flats.
Right.
Now the matter is in CIRP, and as per the inventory given to me by the promoter, they whatever inventory was left over, they have shown as allotment to their one of the company.
But there was a prohibitory order, right? Not to allot.
Yes. There was a prohibitory order from the RERA in 19, and they are showing allotment of all the leftover inventory into 21.
And what is the consideration they have paid?
Ajit?
What is the consideration? Is there any consideration?
Yes, consideration was there. Amount was received earlier also, but they have not submitted their return for the GST and never deposited the GST also. So consideration was not also full.
This would definitely then see then when there is a adjudicatory order or a prohibitory order from RERA court.
Yes,
on
sir.
what ground they can allot it? They don't have powers to allot in that case.
Right,
when
so
they don't have powers, so why would you admit? You need not admit. Let them get it adjudicated through NCLT.
Because I have to take a call on Monday. Now, what should I write to them? I know I cannot reject straight away. That will be beyond my powers.
No, you need not. You need not. So you can simply in that situation you can mention to the relevant RERA order that in view of so and so RERA order, the power the ex management or the corporate debtor had no powers to allot this particular inventory.
Yes, sir.
In my view, this particular inventory cannot be allotted to the group company.
Okay.
In view of that, it is subject to adjudication by the NCLT court. So it remains under dispute. You get it adjudicated through NCLT if required.
Right.
If they so desire, they can get it adjudicated through NCLT. Since it is going to the group company, we cannot establish whether the amount paid is undervalued or not. These are all matter of adjudication, forensic, all those things.
Right, sir.
We don't know what amount is received is correct amount, whether it is properly been valued.
Yes, sir.
So you consider that as a part of your property as of now.
Okay. Thank you very much, sir.
Welcome.
Okay, Mr. Shah, I have one question.
Yes.
This is on this CRP period. You said that if the claim comes after 90 days, so it is better that one should route it through COC and take the views of COC.
Correct.
Whether admitting or not admitting.
Yes.
So in this case, whether we should pass resolution, like how should we, when you take this matter to COC, whether we request that we put it as a voting item for COC, that whether the COC agrees for taking this claim or not, or it's just a verbal thing.
Absolutely. We prepare, see, revised list of creditors would be there. So whatever claims that has come after 90 days, your list will continue. These are the claims you have received after 90 days. So you present it before the COC, which we do anyways in every COC. We show them the list of creditors. These are the new claims which have come. So same way you will show them these are the new claims which has been come. And but it has come after statutory period of 90 days. 90 days requirements are directory requirement, not mandatory. And therefore we want to take the view of the COC. You can pass the resolution relating to that, wherein COC will allow you to accept the claims which are produced before them, which are shown to them, that can be admitted based on your verification. So resolution can be passed.
Advisable to pass resolution.
You can pass the resolution, or you can, either way it is fine, so far as it is in the knowledge of the COC. Ideal way, we pass the resolution that COC is allowing, COC do not have any objection to this particular claim which have come after 90 days. and verification is done. And what is the view of the COCs? We have to record it, that they don't have any objection to that. They don't have any problems with that. So when we come to the discussion, when we write in the minutes, we have to write down their views about why the claim should be admitted or why the claim should not be admitted after 90 days, because it's a directory and they don't have any objection about admitting the claim. It's a legitimate claim, genuine claim appearing in the books of account and therefore appearing in the IM also. So they don't have issues right now admitting it differently. It is already covered in the IM. So various, all those things you can link and you can prepare, you can make your discussion in the COC and prepare the minutes based on that.
Fine,
You
fine,
may
fine.
pass the resolution, may not pass the resolution, but knowledge of the COC is important.
Yes, yes. Either way, whether it is passed by resolution or
Correct.
at least recorded in the minutes.
Correct. And why I'm saying resolution is not specifically needed or specifically needed. If you go through the items requiring resolution of the COC mandatorily under the IBC, the 7-8 items, I think section 28 or so, there it is only one point which says delegation of authority to the IRP or RP. That requires a resolution. Now here, ideally speaking, it's not a delegation of authority, but something which is directly they are allowing IP or RP to do that. Yes. Something which is directory, and we are taking or admitting the claim after 90 days based on certain judicial pronouncements. Relying upon, we are taking a softer stand instead of asking everyone to go through the judicial process. Why this? See, this is also a practical stand. It is not about accepting or rejecting. It's a practical stand. If you don't accept the claim or it remains under dispute, then what happens? If you ask the claimant to go through the NCLT process, what they will do? If the claim is of larger amount, they will immediately rush to NCLT. That will delay your resolution process. That will delay your resolution entire thing, because you put them to the adjudication. You have to finish this within the timelines. Delay, even due to the adjudication or the claim made by the claimant, will delay the entire process of CIRP, and that is not the objective. If the claim is genuine, legitimate, claim is already reflected in the books of account, it is not going to make any major change to the total debt we are calculating or based on which the dissolution plan we are going to approve, then why should we not accept it? I mean, I try to convince the COC with that ground, because there are contradictory judgment about accepting or not accepting. I try to convince them with the says that it's a legitimate claim within the timelines. He is just like your legitimate claimant. And if you go through the NCLT route or NCLT adjudication, then unnecessarily your time will get delayed. The entire process will get delayed. It is not in the interest of the CIRP as such. And therefore, if it is a legitimate claim, then why should we not accept it? It's a directory provision. God give us the power to admit it if required. There are ample judgments on that.
Fine. There's one more question, sir. On this EPFO, you mentioned that it does not form part of liquidation estate. It is outside the liquidation estate.
Right.
But that is okay, so long the money of that employee is deposited with the PF authorities. Like the money is with EPFO. Fine, that is okay. But many a time you will find that the CD has not deposited the PF dues, both employee contribution as well as employer contribution. Now, how do you deal with those claims? Like even many a time the PFO authorities don't even file claims. So how do you deal with those? Because those are not, so money is not lying with EPFO for those items.
Understood. So those claims where the corporate debtor has to pay statutory dues to EPFO and they have not paid so.
Yes.
Am I correct? So in that situation, it is the same position and the same principle lies how we deal with the other tax of the government authorities. How income tax or how GST is required to be paid. How same way this contribution is required to be paid to the statutory authorities is not paid. So they can submit their claim in the relevant form. If they are forming a part of operational creditor, they form part of the operational creditor. It's the same position. Nothing changes.
No, but then you would, with PFO, with PF, there are a lot of contradictory things which keeps
I know there are judgments. There are judgments on this part. I know there are few judgments which says that it is a employees' dues and all those kind of things. You cannot touch those things which are deposited. You cannot touch. You cannot touch those aspects, irrespective of whether that money of PF which is lying in the hands of EPFO or is lying with the trustees of the corporate debtor. So either that amount is lying with the corporate debtor hand or in the EPFO. You cannot touch that. That provident fund, pension fund, gratuity, that is the amount belong to the employee. It doesn't form part of the liquidation asset. But those amount which is not paid to that, those amount which are not paid in EPFO, those amount which are outstanding there also, just like any other regulatory authorities of the government or central government, state government authorities, the claim can be submitted in the same position. And in liquidation also, we already saw it is covered under the 53(1)(e). The position is very clear. Last 2 years amount due to the central government or state government. It is required to be given in the same contribution and same hierarchy. It doesn't make any separate priority in that case. It's a claim of the authorities.
Mr. Shah, I have received a claim from PF department. That is, the corporate debtor has deposited the PF dues late, generally late. So they have imposed penalty and interest on that. What would be the status of that claim?
So that comes as a part of recovery and that falls within the moratorium.
Okay.
Sir, this is Murthy, sir. Continuing on the
Yes.
same PF and EPF case. See, a fund, the word fund is very important. So you have a fund created outside this thing, then that is outside the liquidation estate. In case where the amounts are not paid, that means last 5-6 years में amounts pay नहीं हुआ, termination नहीं हुआ, then LCD जैसे liquidation commencement हुआ, LCD commencement date से, I mean like they stand to get terminated. So in that case, just before 2 years before the liquidation commencement date, only
Correct.
that amounts are to be taken.
Correct.
Sir?
The same priority of last 2 years, 2 years before that. Correct.
And anything beyond it, sir. So 10 साल पहले से plan नहीं चल रहा है. That
So that
amount
will come in other dues. After E, there is any other dues. That will fall in F category, not E.
E category. So 2 साल पहले का जो PF है वही लेना पड़ता है ना सर?
Correct. Up to 2 years will fall in that category of E, and the rest will form in F.
Sir, there is what this unclad judgment on Jet Airways for this PF. What exactly does it says?
So that is what there are 3-4 judgments on this particular aspect is about that provident fund or pension fund or the gratuity which are there. It belongs to the property of the employees, the workmen.
Yes.
And corporate debtor does not have power to take those money, or it will not form part of the liquidation asset for the liquidator. That is the money belonging to the employees. It can be paid to the employees.
That is a fund portion, no sir? That is a fund
portion.
Sir,
if a fund is created,
sir,
that
can
is
I clarify here, sir? Sir, excuse me, can I clarify here?
Sorry?
Can you give me? I'm from the Provident Fund Department. I am a retired additional Central PF Commissioner. I think
Yes.
I can clarify.
Yes,
this
sir.
point.
Yes, sir. Yes, please, please.
Yes, that will be great.
Okay, sir.
Yes.
Regarding the fund, as of now, sir, as the current judgments are after the Supreme Court has upheld the Karmachari wala, all those cases have now been finalized. Please take it from me that the PF dues have to be paid in priority to all other dues. To try doing anything other than that, there will be litigation. I'm not saying that it will go through, but as of now, sir, you are asking about the creation of fund. Let me explain the EPF Act, sir. In the EPF Act, the law requires that the Provident Fund contributions have to be recovered from the wages of the employee. And employer has to contribute and deposit with the PF organization. Here, the moment salary is disbursed, sir, fund is created, you recover, and your contribution is added. You are holding it as a trustee till you deposit. That fund is available with the CD. The moment you disburse salary, fund is created, matching contribution is paid by the employer. Employer has only been given facility of about 15 days time to pay that money. Since he is holding as a trustee, there is no question of saying that there are no funds. There is no separate fund required to be created. Law is given a deeming provision where it says that this fund gets created the moment salary is disbursed. So that argument will not hold good. Now, please read all the Supreme Court judgments. Moser Bear judgment, tourism finance judgment. All of them have very clearly said that, sir, provident fund dues are having absolute priority. They don't even form part of the liquidation. So first you will have to pay even over and above your CIRP cost, including the CIRP expenses. First you have to pay provident fund, then you start your process with the liquidation or RP. This is the provision, sir. This is what I understand. This is what the current scenario is.
Sir, noted.
Earlier there were disputes. Now the Supreme Court has clearly upheld in the tourism finance as well as the Moser ban. Now the department keeps coming and telling you, sir, we have right. Most RPs don't agree. Most RPs fight it out. Some of the tribunals are also giving. But there are NCLAT after the latest, even you take your rainbow judgment. Rainbow judgment also gives them priority there. There, even otherwise. So there is no question of, sir, provident fund. If you want, as an authority from the provident fund side, I would advise you both contribution part, please pay the contribution part. You dispute and fight it out about your damages, contribution and interest you pay. Damages, go and fight it in the tribunal. Sometimes we may get favorable order, we may not get favorable order. I don't know. Because there are Supreme Court judgments which says that damages are also part of contribution for purpose of priority. Section 11 of EPF Act says that it has got absolute priority of all dues, including secured creditors.
Well, sir, one also point here is...
These are the judicial pronouncements which are there.
Sir, Mr. Narayananji, this is the case where salaries have been disbursed and PF has not been credited to the department. A case where salaries have not been paid.
Where salaries are not being paid, you have the advantage, sir. There you can always say that there is no. It comes under a very different legal perception once the salaries are not paid. If the salaries are not paid, you can always say there was no liability to pay PF unless the salaries are paid. But as and when you pay salaries from your CI, as a claim from the provident, from the worker's salaries, at that time, then you will have to factor in the provident fund also.
Of course, that is for the CIRP cost.
Sir,
I think there is a misunderstanding about the what time you are paying. See, so far as the CIRP cost is concerned, that is the entire all the salaries which are paid during the CIRP and all those things. You have to comply with the applicable laws anyways. You have to pay requisite provident fund. You have to pay the pension, etc. That is during the CIRP. What you are saying is absolutely correct, sir. I fully agree with you.
Sir, Harshul Ji, the sum and substance is that, see, 2 years, the point what I am trying to know is that 2 years before the LCD, liquidation commencement date, the salaries are not being paid since last 5-6 years. That's one point. 2 years before the liquidation commencement date, what is the salaries due? Part of it, what is the PF due? That only forms under 53. To the extent you pay the salaries, to that extent you have to pay PF. Yes, sir. Salaries last those
have not been disbursed, sir. For example, if the salaries have been disbursed for 5 years and PF has not been paid, you cannot adopt this 24 months for payment of those provident fund dues.
Sir, 2 years का जो salary से इसमें proportionately जा रहा है तो फिर PF भी proportionately जाएगा क्या?
PF भी देना पड़ेगा, sir.
Sir?
मिनट्स में भी हम चेंज किए
सैलरी पे करेंगे तो उसमें प्रोपोर्शनेटली पीएफ का भी लायबिलिटी आता है सर.
So it is not before the 2 years period. No, 2 years period का पहले का जो है 53(1) में नहीं आता है, नीचे आता है.
नहीं सर, प्रोविडेंट फंड का जो प्रायोरिटी ऑफ 53 का वाटरफॉल मैकेनिज्म के ऊपर है.
Sir, that's what sir. Salary पे नहीं हुआ ना sir.
That's what I said. When you pay salary, आप अगर सैलरी पे कर रहे हैं तो आपको पे करना पड़ेगा. अब salary is not paid. You pay salary only for 24 months.
Sir, the point over there is that is it the PF of 2 years that has to be paid, or since last 5-6 years?
Please clarify. There are two parts of the claim. One claim which already Provident Fund has claimed, for which it might be for 5-6 years, 10 years before you are sick.
Yes, sir.
There are salaries not paid. Salaries not paid is for about 2 or 3 years. Salary part you restricted to 24 months. Once you restrict salary part, PF also gets restricted to 24 months. But the Provident Fund dues which have been claimed prior to this stoppage of salary, where Provident Fund salary has been disbursed, but PF has not been paid, that this 24 months see, what you call limitation will not apply to those dues. Suppose it is 5 years dues are there, sir. And 2 years he has not paid salary. He has not paid salary for 2 years. He has not paid. He has not paid PF for 5 years. So
Sir,
then
sir,
he will have
members,
to pay
please
the
mute.
3-year PF.
Further debt continuity, no?
Yes.
This is what I want to say.
Murarka ji, please mute.
All of you are all much more experienced than me in the IBC part. But this is what everybody who has asked me, who has taken my advice, and being a person with about 25-30 years experience in Provident Fund, consider me to be having a little more knowledge about Provident Fund than any of you.
Anil,
Right.
Anil
I have been
Murarka ji,
advising a lot of but this is a very what you call contentious issue. But judgments are very clear. There are a lot of IBC professionals, IPs who feel that this has a diluting effect of IBC provisions by giving preference to Provident Fund. That's what the Supreme Court has done. This money, sir, one more thing, please take it from me that not a single pie from what you pay goes to the government.
Right.
Entire money you pay goes to an individual employee.
True.
Including damages and interest. So once it is a worker's due, worker, you have not, you disburse salary, you were supposed to recover, you have recovered, you were supposed to put the matching. The fund gets created on the day you disburse salary. A lot of people interpret that where is the fund? I am telling you, please go and read section 6 of Provident Fund Act. It says that employer has to deduct. The moment salaries are disbursed, employer has to deduct. And he has to provide a matching contribution. Both these, he is given a 15-day window saying that by 15th of the subsequent, after the wage month, he has to pay this money. So 15 days he is a trustee.
So when it comes to the CIRP cost, definitely when during the CIRP,
not only
whatever
CIRP,
sir,
I am
you are
saying
saying
that
it has
even the past
to
2
money.
years,
Prior to that, as per the regulation, I believe you have to
under
follow
resolution
the
plan or under
IBC.
liquidation,
Because IBC to that extent will
pending
other rules.
As it stands today, Provident Fund dues get first priority whether in liquidation or whether in your resolution plan. Unless you clear your CA Provident Fund full dues, sir, your resolution plans are not going to get approved.
bank adu okay.
Will please others shut their...
Can the
people please
Miss
mute
Chitra,
themselves?
please, can you just mute your thing?
Chitra ji,
Miss
please
Chitra,
mute.
please mute your thing.
Chitra ji, please mute.
Okay.
Please mute.
Please,
Chitra ma'am, please
you're
mute.
disturbing the entire... Sir, this is what I am trying to tell you. Yeah, it's up to you. It's up to the resolution professional. But I am telling you, as things stands with the latest judgments, the Provident Fund Department will take you up to Supreme Court if you don't pay them. If you are willing to litigate and fight with
This
them,
is always a very contentious issue when it comes to the
but for
Provident
that,
Fund.
my suggestion is, sir, if you
How,
pay
so far as
contribution and
we have
interest,
dealt with, I just can share that so far as we are concerned, we always taken the view that during the CRP, yes, we have to comply with applicable laws and we have to pay whatever Provident Fund salary on salary and all those compliances we have to do. So far as the claim before the CIRP is concerned, we ask them to submit their claim, EPFO and everyone. And while considering that under IBC, we go by the view that IBC has overriding effect over the other laws.
Supreme Court has said that there is no contradiction between EPF Act and
correct. So there is no contradiction and we have to follow this process.
Does not get precedence.
As per the waterfall given in 53.
Has got the same preference as IBC has got. This is what Tourism Finance or what Moser Bayer, all these are saying, sir. Now we cannot go back and say that IBC is having a preference over PF.
No, not where there is a contradiction. If there is a contradiction,
there is no contradiction. One Supreme Court there is no contradiction. PF has its own authority, sir.
Correct. So we follow the same process which is given under section 53.
That's my opinion. It's for the House to take it or leave it. But This is what is happening in most cases.
Right.
Most of the judgments you look at after the latest judgment is your Moser Bear, which the Madhya Pradesh High Court has been confirmed, which also confirms the tourism finance judgment. You please read the judgments. But my practical advice is pay the contribution interest. Hold on to the damages. Let them litigate for the damages.
Sir, the interest amount is also very substantial.
The interest is the employee's money, sir. You cannot say anything. That is employee's money. You have to pay. That money has to. Sir, why PF litigates on that is whether you pay or not. The moment you pay the contribution, PF pays from its kitty to the members with interest. They are paying in advance. So even if you have not paid damages in interest, the moment you pay contribution, up to the date of settlement, interest is paid to the member. Now, from where will the trust recover, sir? It has to be paid. You fight it out, you will never get a chance to win on the interest and contribution. Damages, there are provisions, sir. In liquidation, you can always ask, there are provisions for seeking waiver. Try, seek waiver. As a liquidator, send a proposal for waiver. In the resolution plan, put a proposal for waiver of damages. And if it is, the resolution plan is approved with a provision for waiver of damages, 100% the Central Board of Trustees will consider your application for waiver of damages. Please try that. They have provisions to waive damages. No provision is available to waive contribution or interest. Please go ahead, make a proposal for waiver of damages. There is a provision under section 14B as well as para 32B of the EPF Act. You put it in the resolution plan for waiver of damages because it is for revival. It is a sick company. There were provisions, use that, get it waived. Instead
Sir, many a time I have also noticed that PF authorities will just put a claim amount, and if you ask them that you substantiate with the details of the employees in whose account the money is payable, that details are not forthcoming, and but arbitrary some amount, huge amount is being claimed.
No, sir. Now whatever money has to be paid, Now, who is the custodian of records of the employees, sir?
Company.
Who is the company now, sir?
Okay, once RP takes over, yes, RP.
But then, sir, you provide the list of the employees to whom the money has to be paid. He will tell you this is the amount. You tell the names of the money, names of the people to whom it has to be paid. Sir, it comes back to you, it bounces back to you the moment you say that. Sure. It is the employer who has to provide the details of the employees. Salary details you have provided, sir. Your balance sheet has given the salary details. No, employer details who has, sir? We as an employer only have, because we represent the employer, we have to provide. You provide, it will be credited. And now the rules are very clear. Even if PF general arbitrary assessments are not happening, if they do it, it is very dangerous for them. You need, unless this money, you cannot deposit a money into the EPF account unless the names of the employees are given. ECR has to be uploaded. Without that, money cannot be paid. Even if you pay, it cannot be taken by the PF authorities. It goes into the individual account, sir. And one more thing, sir, let me also, like what Mr. Shah was saying, how do you verify a PF claim? You ask for substantiation, sir. You ask them, sir, any amount payable, like he said, sir says, has it become payable?
Correct.
Employer has not paid. When will it become? There has to be a proper assessment of dues. There has to be an order passed under Section 7. Even damages, very often you will get an estimated. You reject it.
Estimated, you will not. You will never. Estimated or unsubstantiated.
Don't act. Unsubstantiated. You ask them to pass a proper order under Section 14.
They have to bring.
If they give a Section 14 order, accept it. Otherwise, don't accept it. You reject it. You reject it. It's not substantiated.
Net
you
it
ask
comes
for
out.
An assessed order, sir.
No, I got your point, but net it means that as far as employee and employer contribution, the amount has to be deposited, and if there is a delay in deposit, the interest needs to be paid. But this has to be done, and what can be waived off or what can be sought by the RP or liquidator for waiver is the damages. You are only saying that only to the extent of damages, we can approach them or request them, sir, please don't put these damages, because the damages amount is also very substantial. It is not a small amount.
And sir, when you ask through the resolution plan, through the NCLT, the Provident Fund Department will consider, because they have certain set rules which says that in case of a sick company which is being revived, there is a benefit being given that for revival. So they will waive damages. But nobody makes an effort to apply for waiver. Everybody simply rejects it, and what happens is once you go into the judicial line, you lose it. If you lose at the end of the Supreme Court, you end up paying. Your entire resolution plan goes for a toss. But if you had made a provision for application for waiver, the judicial route gets stalled till they reject your waiver application. By the time you complete your process and go. So you adopt this mechanism, I'm sure it will work. But if you want me as an advice, Provident Fund, contribution and interest, if you have money, close your eyes, pay first, stop any further litigation. If you don't have money, that's a different issue. You keep fighting.
That is also an issue. Yes.
Yeah, whatever it is.
Also an issue.
To the extent you have.
Yes.
And your resolution plans will go for a toss if you don't pay this, and you end up and the entire, what happens is, please read section 17B of EPF Act. Since, as I said, your non-obstanta clause of IBC does not apply to them. You finish your resolution plan, you approve it, you go it away. PF will come back and ask the new resolution applicant to pay under section 17B. Please read. Person who takes over is jointly and severally liable to pay any dues relating to Provident Fund, present or past. You will go away. Resolution applicant will get into trouble.
Right.
And that your extinguish of claims will not come in here because it does not form part of your estate. So please don't put your applicants in trouble because these amounts are substantial. We have seen, I've been dealing with another case where the amount was pretty substantial. We tried. An application was proposed to be sent for a waiver, that is being done. Interest and damages. Even interest, sir, they are charging 12%. Technically, it has to be only at 8% at rate which they should pay, which they are crediting to the interest. There also, if you reduce the interest also, they will contest. But when we go ahead and tell the courts that what is going into the employee's account, we have paid, courts will be more sympathetic to us. Suppose you blindly reject, you won't get. You need an explanation for that, why you are rejecting. I'll give you a valid reason why. I am available here. You ask me, my number is there. You take. I will advise you on all your Provident Fund matters. No problem, sir. Anybody who has a doubt.
Can you share your number, please?
Sir.
Yes, sir. Yes, sir. Please, sir. Please put it in the chat box, sir.
Very common queries coming from the PF. You can share the number. It will be useful to all.
Put it on the chat box. No issues on that. So,
definitely.
Provident Fund, sir, you can't better, but I am both an IP. Definitely. I am an advocate. I am an IP advocate and a retired Provident Fund officer.
So definitely, sir, you can put your number on the chat so that on PF matters and everything. So everyone can connect to you.
These things, please, because why I wanted to tell is most IPs are under the impression that, sir, there is no fund, there is no fund. That interpretation, people don't understand. I wanted to just explain how the fund gets created. So now that gets cleared. You say no fund. Now I am saying there is a fund. The moment if you are not paid salary, no fund, sir. If you are not paid salary, no fund. If you are paid salary, fund is there. And that fund does not belong to you. You have to pay that first and then start your CIRP.
Right.
This is the position of law as on date, sir.
Yes.
Understood, sir.
I hope.
Understood.
Thanks for sharing the views.
You
can move to the number, sir.
I will do
it. You can share the number on chat box so that those who are looking for the queries, they can consult you on that.
Okay, sir.
Now we'll go to the next question now. There are few queries that has been raised in the chat box. What if the claim is based on pro forma services, pro forma invoices? In case of contract where contractor does not raise the bill on the basis or raise the bill only on the basis of pro forma invoices, running bills, which are just approved and or not approved by the company, but are not recorded in the books of accounts of the company. In case of those claims are to be accepted, answer to that is if it is we cannot establish, you cannot accept it. It is nowadays for operation creditor they also have to submit GSTR, the GST which they have paid. So that also, on basis of pro forma invoices, you have to seek for further information, supporting documents. You have to see the proof of delivery. You have to seek all the other background and information. If it is admissible in our books of accounts, in corporate debtors books of account, if it is already admitted, you have to admit that claim because it is an acknowledged and admitted one. Invoice is still not there. There is still an issue. So you can always keep that particular part that these documents are not available. But you can admit so far as it is there in your books of account. That should not be an issue. Similarly, another query we have, if a company went into liquidation, in case of a CRP process of real estate company, home buyer submitted cash payment receipts in support of their claims. Can we consider the same? Also, we don't have any books of accounts of the city. Again, cash payment, whether company or corporate debtor have received it, we have to establish that particular part. If it is established in the bank, it is in the books of accounts of the corporate debtor, then we have to admit it, otherwise not. If it is taken away by the directors, promoters, and it is not accounted in the books of accounts of the corporate debtor, then we cannot accept that claim. Similarly, if the company went into liquidation on 5th December 2018, and the properties are registered in the name of guarantors and not in the name of city, liquidator sold guarantors property. Liquidator sold guarantors property on April 2021 through education. What will be the consequences? How can liquidator sell guarantors property? Liquidator will not, that doesn't form part of the liquidation asset. So Sonu, can you just throw light on what exactly is the query? I am not able to understand the query. The company went on liquidation on 5th of December 2018. The properties are registered in the name of guarantors. So if it is in the name of guarantors, it doesn't form part of the liquidation asset. How it is sold? It is not in the name of CD, you say. The liquidator sold guarantors property. I don't think that is a correct understanding that liquidator can sell any third party property, whether be it a guarantor or anyone else. Then next is the, sir, kindly share PPT. Surely Vijayji, I will send PPT to all. In case of CRP process, if the OC has submitted the claim in CRP but not in liquidation, but now as per amendment 2022, CRP claimant should be included in liquidation process and stakeholders should be formed, but the liquidator has not included till date. What will be the consequences? They should immediately include it. Why they have not included? Definitely there is some lapse on the part of liquidator by not including it. But now when they have realized that there is an error on their part, they should now include it. So that should be the answer to that. As requested by the, so far as someone has not suffered any loss, if the claimant or stakeholder has suffered any loss because of non-inclusion, then there are liabilities and penalties, under the IBCs, 3 times the amount of loss that can be a claim on the. So that those kind of things can be claimed, but if there is no such loss to them, then you can include it now. So far as distribution is not made, distribution of asset is still pending, and distribution is not yet made, their priorities are not affected, then they can now it can be included in the list of stakeholder. As requested by the participants, my details are okay. So Narayanji has already shared the details. Those who wanted to consult him, they can consult him also on PF matters. I will also take note of this because on PF matters, I don't get too many PF matters in my assignments, but definitely it's a very interesting subject. A lot of contradictory views were there on this subject. So it will be great.
Sir, I have a question.
Yes.
In case of home buyers, like they have submitted a claim stating that the corporate debtor had promised to give the loan which he has taken, that EMI he promised that he is going to pay until possession. So shall we include that amount also?
No, I could not get the query. Can you please repeat again?
The corporate debtor has promised the home buyers that until they get the possession of the flat, the home loan taken by them, that EMI portion, the interest on that EMI portion will be paid by the corporate debtor.
Right.
So they have claimed this amount of interest also, apart from the normal interest of 8%. So we need to accept this claim also.
No. I think you need to understand the claim is not to them. The amount is to be paid for the loan they have taken. The amount will be paid directly to the bank. I think you are talking about the subvention scheme.
Yes, sir.
Lot of home buyers are coming up with a lot of builders come up with a subvention scheme that they sell that, and up to the till the possession is given, the interest will be paid by the corporate debtor directly to the banker. So the claim, if there is any, that has to come from the bankers, not from the home buyers. Home buyers will get whatever their the property is concerned.
Okay. Sir. And if they have promised any rentals like ₹3 per square feet, for example.
Right.
So that also we have to accept their claim, or we can say that.
Absolutely there, but in what category, depending upon the nature of claim, because certain rent may be going in the category of operational creditor. So you have to see whether they fall within the category of a financial creditor or operational creditor. You have to check that. In one of the existing transactions where I'm involved, it's a similar structure is there. That builder have sold certain properties to the home buyers, and in return they said till the time we give the possession, we'll also pay you X amount as a rent per square feet, 10 rupees or something like that.
Yes.
We'll get the rent per square feet, and that possession is also delayed. In case of delay in possession, there is a separate provision relating to the interest also, refund with interest. So then that provision also will get triggered, which will give them, of course, the right about the financial creditor. But whether the rent component is concerned, whether that falls within the category of financial debt or operational debt, you have to check whether there is any, in what category they are. In my transaction, they fall within the category of financial debt under 58F1. That is having a commercial impact of borrowing. So if that is the situation, then definitely it will fall in that category. So you have to see the terms of your contract. I mean, it is not standard for everywhere. It depends upon the terms and the writing, whether it gives any time value for money or it gives impact of commercial, impact of borrowing. So those kind of things. Usually it will fall within the commercial impact of borrowing. In my case, I'm considering that as a commercial impact of borrowing, because that is a fixed amount I'm getting in return to my investment.
Okay, sir. And sir, you said that for the subvention scheme, the claim has to come only from the bank and not from the home buyers.
Of course, if you are supposed to pay the interest to the bank, you have to see the arrangement. But usually it is always the builder will pay amount to the bank, and which is already paid to the bank. In most of the cases, they pay, bank cut off their interest and then pay the balance consideration in subvention scheme. So if you see the arrangement between the builder and the bankers, the amount which is paid for the real estate property, for example, 2 crore का property है, तो 2 crore में से interest component पहले ही वो लोग reduce कर लेते हैं और balance amount की consideration का pay करते हैं builder का. Generally arrangement में ऐसा होता है.
अच्छा.
In one of the case of Aristo developer where I was a consultant to the home buyer, the similar structure was there. So you have to see the structure, depending upon then you have to decide.
Okay, sir. Thank you.
Any other query?
Sir, one more question.
Yes, sir.
On this list of creditors, those who have not filed claim, you had suggested that in case of CRP, we can put it in information memorandum that these are the creditors who appear in the books of accounts, but they have not filed their claim.
That's correct.
So basically for the information of resolution applicants.
That's correct.
Now, and the liquidation, and when you go to liquidation, then there is also a provision like if the person has not filed claim, but he's had filed claim at the time of CRP, then you can take the same CRP amount as you're in the liquidation also as a creditor.
Correct.
But just in case when he has not filed claim in CRP period, nor has he filed any claim in liquidation period, and its name appears in the books of corporate debtor, then what does the liquidator do? Does he put him in the list of creditors or just ignore it?
No, in liquidation stage, see, when it comes to the liquidation stage, based on what claim you received.
Yes,
he has not filed claim. When you sell the assets and you have to distribute the funds, based on the claims you have received. If there is a claim which has not come, you are not supposed to do anything. That is what the last my judgments are saying, that if it is coming belated after distribution of all the assets, if the claims are coming, then we will not look into it.
Sure. Fine. That's all. Thank you. Thank you.
Anything
Sir,
else?
I have a different opinion on
Yes.
one of the matters.
Yes.
With regard to cases which are happening, with regard to home buyers making a claim after 90 days, the court takes a different view altogether and says the RP has to accept the claim until the plan is getting approved. But with regard to the other financial creditors, if they have not filed their claim within 90 days, which is the predominant period, it is always risky for the RP to accept the claim because strictures are being passed by the courts against the RP, stating that you have no right to accept a claim after 90 days. This is a very ticklish issue which happens in almost all cases.
I know, and that is where I say that after 90 days are completed, you put forward the claims to the COC, and with approval and consent of the COC, are you doing that? So tomorrow, if some NCLT asks you that why you are admitting after 90 days, you will simply say that it is with the permission of the COC.
Sir, here I have got a different, like Mr. Shivaraman, I have got a different take on this. Sir, COC has no right. COC has no right to decide on the eligibility of other claimants because it is conflict of interest, sir. Because in COC, I am already a member of the COC. I don't want anybody to be admitted. COC has no business in claim admission, sir.
No. I'll tell you how it happens.
It's a conflict.
See,
Sir,
it is not about the conflict of interest.
Sir, do you agree it is a conflict of interest?
Then there is a question of law.
Where is the law, sir? For COC to consider claim, sir, it is RP who has to decide, verify or admit. COC has no business in the admission of claims.
Absolutely. RP has to examine, verify and decide. 100% correct. Verification will be done by RP. But after 90 days, whether RP should follow that process.
No, sir. COC has no. After 90 days, they have to go to NCLT and get it. We cannot.
Correct. So that is where the stand is to be taken. That no claim should be accepted after 90 days. That stand is to be taken by the COC. I put it on the COC because there are 2-3 judgments relating to that. When you go to NCLT, NCLT will ask you, have you informed that to COC?
No, sir. Nobody asked, sir. No, sir. COC cannot step into the shoes of adjudicating authority. COC cannot condone the delay.
They will never adjudicate.
Has no authority to condone delay in submission of claims.
That is absolutely correct. They will not adjudicate. Adjudication is neither the power of COC nor of the RP.
Has to go back to
even verify the claim.
Beyond 90 days, guideline of 90 days.
Directory guidelines of 90 days. Whether claim should be accepted thereafter, or they should directly be going to COC or directly be going to NCLT.
That is a view.
COC, why it is to be taken for the commercial reason. If the claimant goes to the NCLT, even if it is a legitimate claim, genuine claim, the person goes to NCLT. The NCLT will take another 6 months to adjudicate it. 6 months to a year. Your process will be hampered for no reason. Your entire resolution plan, which is ready, will get delayed by that time till that claim is getting adjudicated. But that is the reason the commercial impact is there.
But COC cannot condone that. COC has no authority. Tomorrow somebody challenges, it is going to be trouble for RP.
No, there are judgments, sir. That's what
but
we
here,
discussed.
sir, in our
there are judgments.
Our NCLTs are
admit it or not to admit it.
Our NCLTs are taking a different view there.
Sir,
on
the one point.
Yes, sir.
1 point, sir. Just a minute.
Yes.
I do agree to what Mr. Narayana is saying, that the COC has no power.
Correct.
But one thing is, the RP has to inform the COC that such and such claim has come. Now, admission or non-admission is not in his hands.
Correct.
If the COC agrees to accommodate them, then he can do a resolution to get it accommodated. First point. Because there is a shift in the percentage of voting that can happen. That is one thing.
Completely agree with you.
But the RP has to inform the concerned person that since it is more than 90 days, I am not in a position to accept your claim for such and such reason, right? Because of the strictures passed in the IBC code. That is what you have to tell. If the CO is not accommodative to you, only thing is you can only inform the COC. And if the COC says, okay, accommodate him, then you take the claim into your hands. Or
Just to add one more point to this, when you are putting to the COC, I also share with the COC the relevant judicial positions. So when I say, for example, it's a claim of operational creditor, I tell them for operational creditor, the court views that way that after 90 days, they should not accept it and they can file it to the NCLT and get it adjudicated. Usual views of the NCLT. But when it comes to the home buyer, I tell the COC that usual view of the home buyer for the home buyers is to accommodate them. It is a usual view of the NCLT. I share with them the legal position as well. Whatever is available with us, all the judgments and all, I share with them this is what the normal position is. Rest, I just brief them what the legal position lies in this particular aspect, and then based on that, I usually take the views of COC in that and accordingly take it forward.
Sir, I just want one clarification, sir. I just want to know these judicial pronouncements are prior to the amendment of the regulations or after? Because earlier the regulation said beyond the specified limit up to the judicial pronouncement said up to the resolution application, resolution plan was accepted, the claims could be accepted. These were the judicial decisions. But after, at that time, there was no cap of 90 days, sir. At that time, there was no cap of 90 days. Subsequently, there was a change in the regulation which says the cap of 90 days is coming. Whether the judicial judgments are after that 90-day amendment or before, sir. If it is before,
these are all judgments of 2021-22.
Or sir?
These are all judgments of 2021-22.
Okay.
And essentially, the judicial positions are of, you can say, just 6 months before. So it is after this 90 days provision.
Yes, sir. Please share that.
Yeah, that is what here we are having judgments. Okay. All these judgments.
Okay.
We'll share with you. These are the belated claims. These are the judgments. See, this is the 1st June 2022 about the judicially. The judgments are all 2021-22 because maximum about the claim verification. If you see, most of the important jurisprudence have been formed in 2021-22. Before that, there were a lot of judgments were there, but it was not very clear because those certain judgments were already now not required or it is overridden. So the position have changed, the law have evolved. So those positions are now not necessary to be discussed, not required. Those judgments are not, now you can say will not function. It becomes redundant now. So these are the position of 2021-22, which becomes important for us. These are the latest positions, sir.
Very nice, sir. Second point.
At the same time, I think this issue should not be there now, especially after the amendment of section 6A and all, regulation 6A, where now we have to communicate with the claimant. So when we are continuously communicating, probably they will submit that in time. I don't think this 90 days issues will be too much of difficulties now, because when we are chasing, the claimants are now aware of the facts that CIRP is there. Probably in coming days, even NCLT will take similar view. Till now, for home buyers, when we are talking that they were unaware of the CIRP, we take a softer view. Probably now views may become slightly stricter also, because now they would be aware of it. There will be recording mails, there will be emails to them, communications to them. Despite of that, if they are not submitting the claim in 90 days, then definitely the NCLT will have stricter pronouncement to these aspects. In future, that is possible.
Sir,
but irrespective of the claims of the claimant about 90 days or after 90 days, etc., if we have taken due care by incorporating all the claims of books of accounts in the information memorandum, we will not have any difficulties dealing with the resolution plan or RA. So that is the most ideal way. I feel we should consider books of account also, identify those claims which are not claimed but there in the books of account, highlight it in the information memorandum, bring it to the knowledge of the resolution applicant. If these claims have not come tomorrow, if it comes after approval of the COC at resolution stage at the time of filing application to the NCLT, then probably NCLT may take some view on this, but then you should be prepared for this resolution also. At least we are having knowledge of.
Sir, I have 2 points to mention about it.
Yes.
One,
yes.
in such, see, for example, if the books of accounts are available of the corporate debtor, your situation is very clear and simple and straight. You can do that, right? Suppose
Question
you
is where
don't
books
have
of accounts are not available.
all available. First point.
Right.
In those cases also, whatever list is available, you are able to do it. But now, otherwise, if you are not, you have no go, but to just to wait for the claimants to make their claim. That is
absolutely, absolutely.
Second thing is, what has happened is in one of my cases, I said a home buyer, you have filed your claim after the CRP period ended. Understand the point?
Yes.
But there was some communication between me and him during the CRP period. Right. But his form CA came to me after the resolution plan got adopted.
Right.
What the court said to me is, Shivaram, please look into the books of accounts, what is available on your records. And if you find, tell them that this is available in your reference. Nothing more than that.
Correct.
This just pass the stricture and then just left it. Now, this is how it is happening. But normally it is always better for a RP not to get into the problem. For example, I understand if there is a bulk amount of claim and which changes the composition of the COC, necessarily the RP is in a dicey situation. He always approaches the COC and tries to get it accommodated. If it is not, he just throws the paper out and says that you go to NCLT, get the order done, we will do it. That is something, right. That is what is the thing. Right. Normally, what in all my plans with the home buyers, what we have started doing is we tell the resolution applicant, please give a window period of 60 to 90 days. What you say in your plan that for those claimants who have not filed their claims to make a claim because there will be a public announcement stating that the project is going to get up, please come up. So a 60-day or 90-day period is given in the resolution plan, and this helps you before the NCLT because NCLT asks you one simple question. There are 100 home buyers. You have got claim only from 40. What about the 60? You will go and tell them, I don't have the 60 numbers. I don't have the details. Simple as that. Simple as that. Because 92 application is still pending.
Absolutely correct. Nowadays, we write in the resolution plan about this clause that, you give some window period to them wherein they may submit that. That's very, very legitimate and very correct way of doing it, especially in case of home buyers, by providing it in the resolution plan itself about it. I think a lot of people are doing that. That's correct. Very nice. That is absolutely
That is what
correct.
is to be done. See, for example, you have to save your skin, my dear sir. RP is pulled up for something for which he is not a party to it at all. Please understand. He is stepping into the shoes of the corporate debtor with the belief that he will find some resolution. He is not here to take the brickbats of everybody, what the mistakes have happened previously to take the brickbats. He has not come into that. That's what is happening. Almost in all cases, it is happening. Brickbats are being thrown at the RP.
Absolutely. I know.
So this is how
I appreciate it. Views are really good, and I'm happy that everyone is sharing the experiences and the views.
Sir, in our case, just let me share in our case what happened. We had sent mail to home buyers, not one number of mails to home buyers. They did not submit their claim during the CIRP period till the resolution application came in. Resolution was submitted. After COC approved resolution, it went to the COC. It is pending with the adjudicating authority. Now these claimants have come and filed a claim. Then we said that we cannot do since the plan is already with this thing. You go. They went to NCLT. NCLT allowed, saying that this thing should be. Now the plan was approved. The plan, COC is approved. It's pending with the adjudicator. Now the entire the plan takes a change because these are substantial claims. Now the resolution applicant will be in a trouble.
True.
Though they have been informed, they did not. They were all staying somewhere else. They said we were not informed. Then the email details were provided to the court that they were informed, but court said nothing doing. You admit their claims.
Correct. Wonderful sharing experiences, sir.
Everywhere we are at the receiving end, sir.
Yes, that's true. That is what the line we have chosen. A wonderful line where we can serve the people. We can always see that ordinary men are also involved when home buyers are there, and we have opportunity to serve them.
Serving people free is okay. Spending our money is bad.
Yeah, that's true. Absolutely, agreed with you.
Very
So
nice.
with this, we
Thank
end
you.
our session. Anything else?
Sir, I'd just like to thank you for taking such an interactive
Can I
session.
have your number, sir? Can I have your number? Can you just flash your number?
Yeah, sure. I think it would be there in PPT, but I'll still write down in the chat.
Sir, I'd just like to begin by thanking everybody for such an interactive session. Thank you to all the participants for being so active and sharing their experiences and stories and their queries. And Sir Harshul sir, thank you so much for joining us for this session, for such a detailed presentation, for answering all the queries,
Thank you so much.
for taking up the topic so interestingly. Um, Thank you so much for joining us.
Thank you.
Thank you, sir. We can take a break till 2. The next session will start at 2 o'clock. So I would request all the participants to join back at 2.
Thank you.
Ma'am, a small request. Kindly send the PPT to all the participants. It would be of much help to us.
Yes, sir. So I'll share it with everybody.
We'll do
Thank
that.
you very much.
Thank you.
Thank you.
Thank you.
Together, we have handled several IBC cases successfully. And I think she is also having brought to our team a lot of expertise in terms of her specific skills in coordinating with people, interacting with various stakeholders, analysis of claims, analysis of resolution plans. And we have Mr. Sudhir, who is a chartered accountant, also part of our team. And I am proud to introduce him as one of the youngest insolvency professionals, having come through this graduate insolvency program through IACA. Mr. Sudhir will also be sharing some of his thoughts in this session. Thank you, Sudhir and Meghla ma'am. And we have Mr. Raghu. Raghu is a graduate as well as a lawyer, and he helps us in bringing legal perspectives in the IBC process. Both Meghla ma'am and Raghu, they act as internal IBBA for us. There is an external IBBA in Delhi, but they are the IBBA for us here in our office. So a lot of compliance related issues. They tell us that this is the way to go. This is the thing we must do immediately. So kind of compliances related aspects. So ladies and gentlemen, I welcome you on this very hot afternoon today. So all over the India, I think the heat wave is going on, but I'm sure that our team will be able to bring kind of a professional presentation and practical views on the Committee of Creditors. So before I get into this COC related topic, 2 minutes of the time I would like to add quickly. Would you like to show the presentation of our people team? We have handled so far about 16 IBC cases as a team, and I am glad to share with these participants today here that my team tells me that so far we have conducted more than 160 meetings of Committee of Creditors and also stakeholders committee meetings. In the case of liquidation, we handle stakeholders committee meetings. On the screen, these are all the matters which we have handled. So some of them, into resolution plans, and some of them going into liquidation. Recently, we have been appointed. I have been appointed as interim resolution professional of Ozone Projects Private Limited. And just we have completed successfully the Vasan Healthcare Private Limited assignment. So probably the 16th one will be the Ozone assignment. Okay, go ahead. And we have, these are all the cases which we have handled. Nagarjuna Oil Corporation and MP Distilleries, Vasan Eye Care, L&T IDPL, Reliance Infrastructure, Dharani Sugars and Chemicals, PRC International Hotels, and Star Agromarine Exports Private Limited. I think Ankita has introduced us, and I am proud to say here that we bring out every month a newsletter for disseminating the knowledge and the experience which as a team we have gone through in the process of IBC. So this is capsuled into a monthly journal, and which reaches a lot of people, professionals, banks, and institutions. I welcome. I think Meghla Madam, this is being sent to all the insolvency professionals also. Yes, the digital version. Whatever email data available with us, we are sharing it with all the insolvency professionals. So I welcome all of you also to contribute in this effort. Any special experience which you have gained, which will be of use to the other professional colleagues, that would be really good. Mr. Narayana Kamma here, who just wished me before the meeting, is a very seasoned EPFO, Employees Provident Fund Commissioner, and he has been instrumental in bringing to the IBC regime, apart from his views on PF matters, also as an advocate. So he brings a lot of perspectives. So I have been requesting him, to put on paper a few of his experiences, interesting experiences, which in fact we had gained from his experience in the case of Vasan Healthcare. A special thanks to you, Mr. Narayana Kamma, sir.
Thank you, sir. Thank you. Thank you.
Go ahead. So the other team members, Mr. Nageshwaran is also part of our team. Today, in fact, we had requested him to join, but I think interestingly, he is having a presentation in American insolvency legislation. So he is not able to spend some time today. So because of some time differences, please run through quickly. Mr. Srinivasan is also part of our team. He's a chartered accountant. He's a valuation specialist. Mr. Venkatraman is a banker, State Bank of India, CGM, retired. He has handled. Meghla Madam, of course, she's before you, flesh and blood. Vinod Kannan is a cost accountant, part of our team. And Sudhir. Sudhir is as I introduced you, a chartered accountant. And he has helped us in the Vasan experience. So this is how we work as a team. And okay, now we will get on to our focus topic on the Committee of Creditors. So ladies and gentlemen, my submission to the audience, I would like to set a context to the discussion, and thereafter Ms. Meghla and Mr. Raghu and Sudhir will be giving their presentation on this important topic. Okay. We have been informed in various materials or in various, introduction on IBC process that there are 4 pillars. What are those pillars? We have the IBBA, the all-powerful IBBA, the regulator, and the adjudicating authority and appellate authority. That system of, judicial, the final stamp of approval coming from them. They are the second pillar. The third pillar is the information utility, which is slowly taking shape, where the credit information is becoming a very, very important requirement. Even to file an application under Section 7 or 9, am I right, ma'am? Today it is required to attach the certificate of a information utility on existence of a debt, right? So this is how the third profile, third pillar of the insolvency process. And of course, we are the proud fourth pillar, the insolvency professionals. Okay, so we face a lot of heat on various fronts from our own regulators and also from the corporate debtors, the creditors, the employees. So every kind of focus or the bullets are all aimed at the only person who is in front, who is visible, is an insolvency professional. Fine. So if these 4 pillars are there, where are the Committee of Creditors? Can we call them as one more pillar, is the 5th pillar of the insolvency process? I think deservingly so, because a lot of decisions are taken by the Committee of Creditors in the life cycle of a company which has entered into the IBC process. it goes through the CARP tunnel, and if it comes out well successful, it comes to the surface. Or if it is not successful, it goes deeper into the tunnel into liquidation and probably gets, maybe there is one escape route in liquidation also as a going concern, it can be revived. Otherwise, it goes, for a neat burial, which is also good for the economy by way of, releasing the assets, productive assets getting locked into a company, it's released. The creditors get some money and, they plow back the funds available, the employees and other people, whatever amount they get, it goes, it goes to them. Okay, so I feel the COC, whatever be the performance of them, if you assess the performance of these, existing 4 pillars, IBBA, probably I can say IBBA has done a lot of efforts have gone into this. Ankita, are you asking me where is ICSI, I mean IPS, where is the IPS in these pillars? Are they here or not? There are 3 IPS right now. So we have, so we have ICSI IAP and ICAI cost and ICAI IAP is there. So are they not a pillar? Probably you would like to ask.
Sir, I think they come under the wing of IBBI. So
excellent.
Maybe we are a subset of that pillar.
Subset of that. Absolutely, you are right. So I should say that, IBBA through, IPAs discharge a lot of responsibilities, oversight, monitoring of, the professionals. And also, I think apart from IPs, IBBA is also having an oversight right now on the valuers also, right? The valuation professionals. Probably, I think it may get a little later. Probably, they can take it out and then put it into another regulator, specialized one. But right now, the first pillar is doing very good, accepting that, a lot of, controls, disciplinary action. Sometimes people say that too much of disciplinary action is being taken on insolvency professionals, but I think it is for the larger good of cleaning up the system. I think some of my colleagues on the screen who is participating will definitely agree with me. If we do our work thoroughly and meticulously and professionally, I don't think IBBA has anything adverse on our functioning. I think if you take that extra care, if you take that extra mile to do our work properly, then we need not have to worry about somebody, breathing down your neck, like IBBA is asking. Okay, it is their duty to ask queries. It is their duty to, inspect. All those things are as per part of their responsibility. They are exercising their duties. So I feel that IBBA has done their work excellent manner. Then adjudicating authority and appellate authority, no doubt we are not the right people to make a comment. But given the infrastructure challenges, I think what we are facing is, definitely a much better situation compared to the initial days. A lot of things have settled down. Multiple decisions used to come from one forum to other forum to NCLAT to Supreme Court, but things are slowly settling down. IBC still is, I can say 6-year-old. A 6-year-old child definitely needs a lot of hand-holding, guidance and support. So I can definitely say the the second pillar also has done their bit of contribution. IUs, I think only one IU is there right now, Sudhir, NESL. So probably IUs are yet to take off. A little more pressure or a little more competition to them. Probably the third pillar also will do, quickly catching up with the other pillars. And fourth pillar, IPs. Yes, ma'am. Chitra, ma'am, you want to say something? No. Okay. So we've talked about IBBA and the adjudicating authority and IU. The fourth pillar is the insolvency professionals. This is where I think, a very important kind of an assessment happening. The competency of the professionals and how they are delivering, their work, to what extent they remain unbiased to their profession and also focused on bringing the resolutions or resolving the liquidation, to what extent the response from the other stakeholders on insolvency professionals. Well, I think I can definitely say that the tribe of insolvency professionals are also improving their performance in the last 5 to 6 years. Youngsters have come, people who are not 50s and 60s alone in the field now. Youngsters have started coming. IPEs have come. And IPE as IP also is another concept which has come. So I will definitely say that this concept of, the insolvency professionals challenging times they have, even though with all adversities and all challenges, they are also gearing up, they are also measuring up to the expectations. Maybe somewhere some bad apples here and there, which are being weeded out, which are being cleaned up. Other than that, I must say that the insolvency professionals coming from various backgrounds, mainly, what we could see today is the three wings of, the CS, CMA, CA. Apart from that, we have a set of people from the legal background. Am I right, Raghu? Also, the fifth category is on the general management. Am I right, Meghla Madam? Meghla Madam is actually, she's a management person. She is neither into, the CA, CMA, CS or the legal people, but I can say she is a much better person all rolled into one. So the fourth category also is evolving now. The persons who have had sufficient experience in managing, corporates or managing their own enterprises, they are also equally qualified. They are also equally competent to become an insolvency professional. No doubt, the specialized areas are giving some advantage. For example, a chartered accountant, the moment he gets into an IBC matter, he puts his fingers on where is the flight of capital, why there is loss, where is the amount receivable or recoverable, which are all the assets the company is having. So he is having that knack of, getting into the details. A company secretary may get into compliance matters, why the company went into, a PMLA issue or an enforcement directorate issue or ROC related matters, directors related, operation mismanagement matters. So these are all quite possible for them to quickly identify. So all said and done, it is not a single person responsibility for insolvency professionals. A team does a lot of work around rallying around the insolvency professionals. So I must say that they have also done their job really good, really well. Now, COC, which is the topic of our today's discussions, how the COC has performed. People talked about COC Dharma. I think there is an article, interesting article written by Mr. M.S. Sahu, the erstwhile chairperson of IBBA. Many of you might have read that article, the COC Dharma. Participants are welcome to, share their comments in between. Absolutely no problem. So I would like this program. I would be definitely happy if this program is more interactive, so that it can become more beneficial to the participants. I see 57 of them in total, the total participants. So definitely, I think, I will be very happy. Our team also will be very happy to share some of, our instant responses. So the COC comprising of financial creditors mainly, exceptional cases where only operational creditors also might be there. In my case, the first case I handled as, CIRP matter in IBC. At those times, I remember that IBBA will send all insolvency professionals a request for quotation, request for proposal. You have to quote your fees. They will give some 4 hours, 5 hours time. So within that, they will take it, collate it, and then the next day they will say who has quoted, probably on a weightage. So that person will be appointed as the IRP. That's how it worked. I'm talking about 2017, later part of 17. So that was the process, being followed for appointing the IRPs. So it was only in the case of operational creditors were there in that particular matter. So later on, we handled the many cases where large ticket size financial creditors came into the COC. Now, COC is also in the learning phase. I must say that they are more keen on recovering their money, even though IBC is not a recovery process. Everybody, is very clear in saying that IBC is not a recovery process, but recovery is a byproduct of the insolvency resolution process. Incidentally, the creditors get some money and the company is back on its feet. So that's how it works in IBC. So IBC with the COC in command, how the things are being, revived or resolved. So what is the COC, competency or capability? How they strengthened their team? How the banks started representing in the COC meetings? So I will just take a few minutes. Initially, when these IBC came into the picture, the lenders, they nominated some of the senior persons into the credit department, who are all, large corporate bank or, mid corporate segment. So they used to come for the meetings of COC. Slowly later on, they formed stressed assets, management branch or something headed by a DGM or AGM or GM. So that department formation was very much alive to IBC process. Slowly they strengthened the team, briefed them about IBC process, what are all their powers, what are all their responsibilities, what kind of a question they should ask in the COC meetings. So I could visualize, early days, how the COC members were participating and how current COC matters, how their participation is. So I can definitely see those days as IRP or RP, I used to take a lead and then I used to tell them that this is how it works, this is the provision and all. But today I get a lot of challenges from the COC. The COC asking me, why are we not going for a third set of valuation? We are having two sets of valuers. Why don't you go for third set of valuers? COC today is asking EOI, expression of interest. How much should be the net worth? How much should be the eligibility criteria? How that evaluation matrix should be designed. A lot of participation has come from COC members these days. I can see a definite shift. I can see a definite qualitative improvement. But still, one important grouse I'm having on COC is that the participants into the COC, they come not with a decision. They say that we have to take certain matters to their competent authority. So you please put some items for decision to e-voting. So they don't decide on the meeting itself. They don't come prepared on an agenda which has been circulated much earlier. I think 5 days is the time specified for giving the COC meeting agenda notes, but there is a provision that it can be as less as 24 hours also, right? So 24 hours also is available. So these are all, my observations on the COC's capability, number one. Number two, on the COC, how do they negotiate with the resolution applicant? Different sets of people come, different proposals come. How do they negotiate and get a maximization value for the company? This is one more area where I find, at least in the cases handled by us, the RP had to take a lead. Our team had to present all the facts and also guide them and telling them that, probably you should ask this question. You should raise this matter before the resolution applicants and challenge them that, this company is worth much more than what you people are offering. So that is one area where I thought, the COC's capability and competency in handling these matters, particularly when we talk about commercial vista. Okay. And in particular, I would like to add one more point. The recent decisions of Supreme Court and Appellate Tribunal regarding employee dues, like you have PF dues, gratuity dues, how it should be handled, 100% should be provided in the resolution plan. In liquidation, at least there is some clarity that it does not form part of the liquidation estate. So it has to be paid in full. But in resolution times, the resolution process, I have handled many cases where, PF authorities were handled as an operational data. They got only some 20%, 30%. And all those cases have been, successfully closed. But today, Jet Airways decision comes, Moser Bear decision comes from Supreme Court. And they say that no, nothing doing. You have to pay, you have to provide all dues, PF dues outstanding, be it employee dues or employer dues on the date of CARP. And added to this, some more decisions have come where 14B damages, right? 7Q interest, section 7Q interest, section 14B damages, all these things should also be paid. So these are all adding more challenges both to the professionals, insolvency professionals, and also to the COC as to how a resolution plan should finally be allowed to be approved and how the modification negotiation should happen. And the last point I would like to say, sir, on the COC, the security interest. I have seen in many cases where voting share in a COC will be held by an unsecured creditor, whereas a secured lender, security is available with him, he may have a much less voting share. So when a plan goes for voting, this gentleman having more voting share demands more on par with a secured lender. So these kind of issues also of late have come, and they have their own impact at the time of resolution plan and in the time of distribution in the liquidation process also. Although liquidation process does not differentiate the extent of security held by a secured lender, they don't differentiate. Your money will be paid under section 53 only to the extent of the security, it doesn't say. They are all getting into a pool of secured creditors. Okay, this is yet another challenge for the the committee of creditors. And with this backdrop, the regulations, CARP regulations, a lot of amendments have happened. Slowly, if you see the CARP regulations, towards the end, it talks about liquidation aspect also. It says that how the liquidation costs should be met by the COC. Even before a liquidation is announced, the COC has to think of liquidation process. You have to decide the liquidator and his fees and who will meet the liquidation cost, and also sale as a going concern has to be decided. Assets, in which form you have to sell. All these aspects put a lot of responsibility on the shoulders of COC. So, ladies and gentlemen, so the team from our stable, Mekla ma'am and Raghu and Sudhir, they would like to focus on the constitution of the COC, which is the first limb of our discussion. Second is the role and duties of the COC. What are all the roles they have to perform? What are all the duties they have? The third one is the powers of the COC. COC has got distinct powers. Section 28 talks about, IBC talks about the powers of the COC, which cannot be exercised by the RP until it is approved by the COC. A lot of areas are there. Broadly, these three baskets are there. I thought I can also add another basket where the decisions of the COC bordering on decisions on liquidation, whether the company should be dissolved, liquidated, or it should be, there should be a CARP, and the commercial wisdom associated with that. A lot of areas have come, preferential transactions, how it should be handled. Those things are all required now when an application is submitted by the RP to the adjudicating authority seeking an approval of the resolution plan. Or even in the liquidation application under section 33 also, certain things have to be very clearly stated. Who will pursue the liquidation, who will pursue the special transactions, avoidance transactions applications. So with this context and with this few remarks, ladies and gentlemen, I thought it would be right to have a good presentation, and we would welcome your questions and your comments on this presentation. Definitely, we are here to address, and I hope it will be a very interactive session, and a lot of experience, interesting profile of insolvency professionals are here. Thank you very much for your time, attention, and definitely interesting queries also on the subject, which is very, very important in current context. Thank you so much. Thank you very much. I request Mekla madam to continue with her presentation, or how is the arrangement? Should we start with Mr. Mr. Raghu will be starting the presentation initially. Yes, Raghu, please.
Thank you very much for giving a broad insight about the Committee of Creditors. Now we'll go to the topic Committee of Creditors. See, it is the prime duty of the IRP to constitute a Committee of Creditors once the company comes into a CRP. So what is the committee is defined in regulation 2(1)(d). A committee means a COC established under section 21. So IRP, after a public announcement, collation of the claims received against the CD, determination of the financial position of the CD, constitute a COC. So primarily the COC in many companies comprises of financial creditors of the COC, where the company does not have any financial creditor or the financial creditors are related parties of the CD, then the CD shall constitute with the operational creditors. For constituting a committee of creditors with operational creditors, consisting of operational creditors, the regulations provide that 18 largest operational creditor by value shall be included in the COC, and one representative elected by workmen and one representative elected from employees should be included in the COC. So if the company does not have, if the CD has only creditors of a class of financial creditors eligible to join the committee shall consist of only the authorized representative. So once the committee is constituted, the IRP has to file a certificate of constitution of the committee to the adjudicating authority within 2 days of its constitution. That is verification of the claims initially after commencement of the COC, that is after 21 days. So now we come to the roles, responsibilities, and powers. As Mr. Rajendran sir was telling that though the COC is not in the 4 pillars of the IBC, they have a very big role in concluding the CRP effectively. So the following are the duties of the COC are: provide interim finance to compensate the CRP cost. If the CD is not in going concern and not remunerative, then the COC has to fund the cost involved in running the CRP. Secondly, appointment of RP. As the time is the essence of the CRP, and with that intent, the code prescribes that outer limit of 180 days for completion of the CRP, the COC is duty bound to appoint a resolution professional to conduct the CRP and manage the operations of the corporate debtor at the first meeting held within 7 days of the constitution of the COC. And the other duty is approve eligibility criteria to be submit eligibility criteria for the resolution applicant to submit the resolution plan. So this is provided in section 21(2)(h). With the approval of the committee of creditors, the RP is required to decide this eligibility criteria. Further, the certain issues require approval of the COC. Though the court directs the resolution professional to conduct the CRP, yet such resolution professional cannot take certain actions without prior approval of the COC, which is described in section 28. Around 10 to 11 points are there, which RP cannot act upon without prior approval of the COC. You want me to read one? The items. See, the items include a raising of interim finance, create any security interest over the assets of the corporate debtor, change in capital structure of the corporate debtor, record any change in the ownership interest of the corporate debtor, giving instructions to financial institution maintaining accounts of the CD for a debit transaction for any such account in excess of the amount as decided by the COC, undertake any related party transactions, amend any constitutional documents, delegate its authority to any other person, dispose of or permit the disposal of shares of any shareholders of the corporate debtor, make changes in the management of the CD, transfer rights of the financial debts, make changes in the appointment, make changes in the appointment of terms of the corporate debtor, statutory auditors. We ourselves have no clarity on the point I, dispose or permit the disposal of shares of any shareholders of the corporate debtor or their nominees to the third party. See, if the company is a private company, in case where if it is a private company, then the transfer of shares is vested with the board. And since the RP is in charge of the company and the board, this can be effectively managed. But where the company shares are a public listed company and the shares are traded in demat mode, how this particular point can be made effective is a question mark. Next point. Approval. And other duty is approve the cost relating to COC, approve evaluation matrix for consideration of the resolution plan. See, while approving the evaluation matrix, the COC has a big role that how this the criteria given in the evaluation matrix can be put for valuation. That also has to be decided. Approve the quantum of performance of the security, evaluate the feasibility and viability of the resolution plans, vote on resolution plans, provide information. This is the recent amendment that provide information relating to preparation of the information memorandum and other vital informations which are available about the CD, which are available with the financial creditors. They are duty bound to submit to the RP to collect this information. Evaluate the resolution plans received from the resolution applicant. The prime objective of the code is providing for the revival of the corporate debtor and to make it going concern. So hence every attempt is required to be made first made to revive the corporate debtor and make it going concern, because we have heard in many of the cases that liquidation being the last resort. The code prescribes the manner in which the resolution needs to be evaluated. Therefore, the COC must apply the highest standard, duty of care, and see that interest of all stakeholders have been taken care and follow the due process while evaluating the resolution plan, and also act in a transparent manner in discharging their responsibilities. It is the prime responsibility and duty of the COC to record its deliberations on the feasibility and viability of each resolution plan. And the prime responsibility is to vote on the resolution plan. Any decision thus taken by the COC shall prevail unless the same is in contravention of law. And the Supreme Court has time and again reiterated that the commercial wisdom of the Committee of Creditors cannot be questioned by the courts except on limited grounds. Now, we now come to the powers of the next leg of the COC, powers of the COC. First thing is the COC has the power to replace the resolution professional at any time during the CRP process. Second one, withdrawal of the CRP. The COC, with the approval of 90% of its voting share approval, withdraw the admission of the COC at any time. And if it is prior to the formation of the COC, it is for the IRP and the applicant and the creditor to settle with themselves, and IRP is bound to file the application with the once received the settlement, file the application with AA. The important power of the COC is to approve or reject the resolution plans received. So this power to approve is subject to the final approval of the adjudicating authority. As I said, the Honorable Supreme Court has upheld the supremacy of the commercial wisdom of the COC at many times. The next one is the liquidate the COC, the COC at any time during the CRP, but before confirmation of resolution plan, can decide to liquidate the corporate debtor. Thus, it is evident that the COC during the CRP is vested with enormous powers to determine on future course on the corporate debtor, along with huge responsibilities, duty of trust and care. In some cases, concerns have raised regarding capacity and conduct of the COC. See, IBBI through a circular dated 13th July 2018, sorry, 10th August 2018, specifically informed that the person who is attending the COC meetings should be competent and are authorized to take decision on the spot and without deferring decisions or for want of any internal approvals from the financial creditors. And there are many judgments upholding this particular statement. However, we can still see that the COC with participation of the financial creditors at lower level, and even for the process related approvals, they want us to put the matter to be on e-voting, and in spite that the delay happens in the CRP completion of the CRP within the 180 days. And one more thing I just want to highlight is there is a recent amendment though it is stated in the regulations that the members of the COC shall discharge functions and exercise powers under the code and regulation in respect of the CRP in compliance with the guidelines issued by the IBBI, Still, the conduct and decisions making of the COC is not subject to any regulation, instructions, guidelines, etc. till date, though there was a circular discussion paper circulated by IBBI during 2021. It has not come into light till date. And the actions of the Committee of Creditors is not under any regulated. With that, I will ask my colleague, Mrs. Meghala, to take up the session.
Good evening, everyone. Thank you, sir. Thank you, sir, Raghu, sir. Now let's move on to meeting of Committee of Creditors. Meeting of Committee of Creditors plays an important role in the process, as it is a place or forum where the members of COC come together to gather information with regard to the management of the CD and the process, which is taken care by RP. They can meet in person or by electronic means as specified in the notice. The RP may convene a meeting as and when he considers necessary or at the request of the members having at least 33% voting share. Section 24 and Regulation 18 to 24 deals with meeting of creditors. The first meeting of the Committee of Creditors shall be held within 7 days of the constitution of the Committee of Creditors, wherein he will introduce himself and the COC members, whoever is there. Till then, let us take, there are 5 banks, but there only 2 banks have submitted their claims. So they can form the COC. So RP will be introducing them others with the people, and there they will discuss about the process to be started, because this will happen after the public announcement. So it is a duty of the RP to convene a meeting. The notice of the meeting shall be served before 5 days in writing to every participant. But in case of any emergency, this can be reduced to 24 hours. For this, in the first meeting itself, they can pass a resolution in this regard with the consent of the COC members, so that in future, in case of any emergency, they can go for the period. They need not go for 5 days, it can be reduced to 24 hours. But if authorized representatives are there, then in such case, it can be reduced to 48 hours, because authorized representative is supposed to send this notice to all the class of members, so that they have given 48 hours for representative. So the committee may reduce the notice period from 5 days to not less than 24 hours. The committee may reduce the period to not less than 48 hours if there is any authorized representative. Notice of the meeting. Notice of the meeting is an information to the Committee of Creditors with regard to the place, venue, time, and the agenda, as well as the information. The notice shall provide that a participant may attend and vote in the meeting either in person or through an authorized representative. The participant shall inform the resolution professional in advance through an email saying that this is the concerned person, he is the authorized person for the representation of that particular member, COC member. Generally, it does not happen at all. And in this context, I would like to bring you the notice of IBBA circular dated 10th August 2018, which requires the competent person to take part in the COC so that he can take decision as and when it is required. So please take note that IBBA circular number IBBA CRP 016/2018 dated 10th August 2018 requires that the notice shall include the following. The financial creditors other than the creditors under section 21(6)(a)(b) must be represented in the COC or in any meeting of the COC by such persons who are competent and or authorized to take decisions on the spot and without deferring decisions for want of any internal approval from the financial creditors. Practically, this doesn't happen at all. Whoever comes to the meeting, even for certain process work also, they need not go for Usually RP can go for voting in the meeting itself in person. Whereas these people who are sitting in the COC meeting, they would want to go and refer each and every matter to their parents and get their concern or the approval from the banks. This is what is happening in each and every meeting. So this may result in delay. If
what is the remedy for this? Can the RP stop the incompetent person from attending the COC?
You cannot do that, no, sir. So it is each and every notice carries this, but still, every meeting we are hearing that even for e-voting, they need 8 days, 10 days. They say in between one Sunday is there, in between Diwali holiday is there. As far as the IBC is concerned, 180 days means there is no Saturday, no Sunday. So each and every day counts, but this is only for RP. And COC members, I have seen even for 10 days, we were waiting for e-voting.
It looks like their COC is the one with powers, but no responsibility.
Yes, sir. That is what we highlighted, that in IBBI has come with a discussion paper in 2021 on the code of the COC. But it has not been finalized till date, because I think they are discussing with the RBI and other regulators, banking regulators, and finalizing on that. But unless that comes, this becomes a very difficult on the practical side of conducting the COC, sir.
Sir, it is only a myth. It's only a myth. You are carrying it in your head. Never it will happen.
Yes.
Never it
Not
will
happen,
happen.
sir. They only want your seal and stamp for all their decisions, which are not going to be questioned anywhere else. That's all.
Yes.
See, one simple point I'm telling you, simple point. The mistake is not of the CD. The mistake is of the CD as well as the financial creditor, which has resulted in the CRP process. Please understand that. If they would have taken a right decision at the right moment, things wouldn't have been wavered. Simple, my humble opinion on this.
Yes, sir, I do agree with you. See, because of this, there is not only a delay in the process, even the cost involved with regard to e-voting.
So simple. One more simple point. I'm sorry to use this word. You leave the body of an insect to go out and you catch the tail and you say that I want a resolution on this tail, whereas the full body has gone out. Where will you find resolution?
Not only that, sir, the problem is I can share with you recently, basic expenses. There is the COC says, I won't approve these expenses.
Yes.
You can imagine that if they don't approve the basic expense which is required, you need to have an advocate. You have to appoint an advocate. He says, I won't approve as a CRP expense. What can RP do? And then they find fault with RP saying that you are not getting my company represented.
See,
what RP can do?
So not only that, sir, even we have faced that in the case of appointing a valuer, appointing a transactional auditor. The code says that it is the duty of the RP, and we cannot within 7 days of the appointment of RP is duty bound to appoint the valuer. There is no scope for COC to have take guidance from the COC at all. But for the purpose of taking the financial approval from the COC, the RP is bound to be before the COC, and the COC is putting lot of threshold on these appointments. They want the valuers and the other professionals to be appointed at a very less cost, but the quality they expect is much higher, at a very higher point. So there is a gap between this also. In some of the cases in where we have done, we have seen that we at least some 4 or 5 times we took up the agenda for appointing a special audit transaction auditor, but the COC simply deferred that item for more than 6 months, and because of that we could not able to make an opinion.
You can understand, sir, why. You can understand why. Because any forensic audit will bring out their lapses also. So they don't want forensic audit to happen. So they will force it to go to liquidation. In liquidation, nothing happens. And RP IBB will ask RP why you are not appointed, why you are not filed
Exactly, sir. Even in liquidation also. Exactly that point, sir. That one point. Second point I want to highlight is the appointment of RP itself, sir. In many cases, IRP is not being replaced by the RP. And though the code mandates the continuation of the term of IRP till the appointment of RP, can we expect the IRP to perform the functions of the RP at best of its abilities, because this COC itself is not having the confidence that this IRP will not function as an RP? Then how the COC can expect that IRP to function the RP function effectively? In many of the cases, I see that the RP continues to function till the resolution plan is being approved.
Sir, in addition to that, let me share with you. In an OC case in section 9, IRP expenses are not ratified.
Yes.
He says we don't ratify it as IRP expense. Now, whatever the applicant has paid, deposited, that doesn't get ratified. Then where do IRP go? His fees is not ratified. The amount is not ratified. Then what happens to IRP, sir? This is what is happening there.
So that is why we think we want and we wish that the IBPI should bring in some code for the COC.
Sir, I wanted to ask one question. Like,
Yes,
suppose like the COC members, they are not approving for the valuers and no Form G expression of interest, and then it has to be done within 60 days and 47 days. So, what is the obligation on IRP or RP in such cases?
Can you come again, ma'am?
Ma'am, what I want to ask is, like, we have to appoint valuers on 47th day and no Form G publication by 60th day.
Yes.
Suppose we have put the agendas twice, but then they are not approving it. And that 47th and 60th date has crossed. So what is the obligation on IRP or RP in this cases?
Madam, with regard to appointment of the valuers, I would say the COC doesn't have any role to play except approve the cost. So
Yes.
RP is supposed to appoint the valuer whether the COC approves the cost or not. It is the duty of the RP. It is left to, if the COC is not approving, it is to be left to the AA to decide on that. But with regard to the publication of Form G, RP cannot himself do the Form G, because the criteria with regard to eligibility criteria, the other thing has to be approved by the COC, because it is specified that with the approval of the COC. Without the approval of the COC, RP cannot do that. This is my opinion, and I solicit the others' view also in this.
But sir, then what should the IRP or RP do? Means he should report it to AA, he should report to IBPI. Like, for his safeguard, what should he do?
Well, if the COC does not approve the form publication of Form G, he has to. Yes, he has to file that whether some CRP 7 is there. That he has to file and put the reason in that, madam, because COC is not approving the Form G publication of Form G. And
yes.
I would want to highlight one case where recently in February 2020, I think in one case, I'm not very 1 minute. In one case, I'm not very, I'll just give the name later. It has come in January or February, this 23. In one COC, they have rushed the company without publishing the EOI. They have decided to liquidate the company. And in that case, the NCLT has given a show cause notice to the COC members who have approved the liquidation of the company without going in for the UI.
Okay.
Okay, madam. Let me continue. With regard to notice, RP shall give notice to members of COC.
आराम से पलथी मार के बैठ जाओ आएगा तब आएगा
Sir, excuse me, sir, please.
Sir, I want to ask one question.
So the RP shall.
Sir, may I ask one question?
Yes, madam.
Sir, actually, my question is that during the CIRP period, IRP and RP has not done the valuation of the company. Properties valuation has not been done. And during the liquidation period, liquidation want to do the valuation, but the proposal was not sanctioned by the financial creditor or stakeholder was saying that only one valuer you should appoint. But the rule is this: if we will do the valuation, we have to do at least from the two valuer. So stakeholder has sanctioned only the petition of the one valuer, and that too after the expiry of 3 months. So can we do valuation by this constraint?
No, madam. The code is very clear on appointing the valuer in the case of CRP and in the case of liquidation. See, the code is very clear that supposing in the case of CRP, the RP is required to appoint IBBI registered valuer, 2 set of registered valuer for every class of asset. If the company has 3 class of assets, the RP is bound to appoint 2 set of valuers for all the 3 set of assets. In the case of liquidation, when the company goes into a liquidation, then there is an option with the liquidator either to go with the valuation that has been done during the CRP period or go for a fresh valuation set. It depends upon the timeline where the first valuation is done, because the value of the asset could have been eroded, or there can be difference in the valuation because of lapse of time during the CRP period. And I feel that during these 2020 COVID cases, many of the assets have depreciated because of the market condition. So many cases we have gone for the valuation during the liquidation process also. But there is no question of any coercion from the stakeholder committee or the COC member for appointment of one valuer, or any choice for them to have any say or stake in that question. It is for the RP or the liquidator has to decide on that matter. The only thing is factor here is the cost factor, which is to be taken up by the committee. Otherwise, it is for the IP to take a decision on this matter.
I do agree what you say, but if they don't approve the cost, how am I going to appoint liquidator, sir? If they don't approve the cost, how am I going to take the how am I going to appoint liquidator, valuers?
Sir, here also, if you see the cost, CRP cost, I don't think that all the cost is required to be approved by the committee.
Show me, sir. No, without approval, we cannot spend any money. Every money spent has to be either ratified or approved. So there are 2 ways. Either you take approval or you get it ratified. If they don't ratify, you cannot treat it as CIRP expense.
Not ratified, sir.
No, then we'll have to file with the AA and seek the direction.
Okay, sir. It will take another 6 months by the time I file an IA, get it numbered.
Yes. Yes, sir.
See, these are the practical difficulties.
For these practical difficulties, we don't have answers to IBBI when they question us on delays.
Yes.
Sir, can I ask a question? I'm from Hyderabad.
Yes, sir. Yes, sir. Go ahead, sir.
Yeah, this is with regards to the minimum fee structure which IBBI has brought in by way of an amendment to the CIRP regulations in September 22. So in one of my cases recently over the first COC meeting, so when the item came up, so I was the IRP in that case. So when the item came up for whether continuing myself as an RP or replacing with one another professional. Then on the day of the COC meeting, so in the COC, I had only one bank, which is 100% voting COC member. So on the day of meeting, they kept mum, they kept silent on that. And when I rolled out the voting, then they informally contacted me and they tried to negotiate with the statutory minimum fee. So,
sir, hello, sir, you are.
Yeah.
Your voice.
Yes, sir.
Yes, sir.
So I was saying that I was going by the minimum fee amendment, and I was sticking to the statutory minimum fee of 1 lakh per month, considering my claims were less than 50 crore. So the COC member tried to negotiate with me as a package, which I couldn't accept. So on the when the voting came out, so they have voted for replacing me with one another RP. That is absolutely fine. But my point is, I think since the word used there is shall in the amendment, so that fees whichever is given by IBBI as a benchmark, so that remains as a minimum fee which we have to stick to, right? So if we are going to do this undercutting, then I don't know where will this profession lead to. So I would like to.
It's not about undercutting, sir. It is basically how the COC can go against an IBBI direction.
Exactly, sir. That's what. So it's even my gut feeling is it's not within my remit to go against the law of the land, and also even COC can't do that, right?
Yeah,
Yes, sir. Yes, sir. Absolutely, sir.
The other RP who was quoted less will be in trouble with IBBI.
Yes,
exactly.
Sir. Absolutely, sir.
Yep.
It should be reported to IBBI, sir.
Yep. Yep.
Please report it to IBBI saying that this was the reason they have removed you. No problem. Let the other RP who was agreed to violate the IBBI rules answer the IBBI.
Yep. Okay. Yep.
That's what,
Thank
sir.
you, sir.
COC. COC is not responsible for any of their decisions. They can do anything. Yes. They're not bound by any laws, any rules, no guidelines.
So, these are all the practical issues. Yeah. Yes. Exactly.
Yes, no regulator, sir. They have no regulator.
I think each and every IP is facing this. Practical difficulties are more, and we are answerable to IBBA and COC in their own decision. They will go on.
Yes. Yep.
Okay.
Anyways,
sir.
thank you. Thank you, ma'am.
Sir, if sir, suppose if they are not COC members, they are not contributing to the CIRP expenses. So in that case, it means the majority of the COC member. So can we, reject their claims? Like in one case, it has happened.
What is it you're going to gain out of it?
No, madam. I will reply that. See, you cannot take any adverse action against the code. See, the code prescribes that either the COC member has to contribute to the CRP cost or allow the IRP or the RP to raise interim finance. You have only two choices. Either the COC has to contribute to the cost or allow you to raise interim finance. If they are not allowing you to raise the interim finance, then you are bound.
They are not allowing either of them, sir.
Then you let
Yes, they are not allowing either of them. Correct.
See, in many of the cases, the IP, definitely is practical problem. We cannot go beyond because we have IBBI on our head. So we cannot go beyond the code. So we have, if there is any difficulty in the process, we have no other option except to approach the AA, whether it is going to take time or not.
Yes, sir. There is a NCLT Chennai judgment, NCLT Chennai, where they said that they can be removed from the COC, but you cannot reject their claim. They can be removed from the COC.
Yes, sir. Yes, sir. Absolutely. Sir.
You can remove them from the COC with the approval of NCLT.
So the RP shall give notice to members of COC, suspended board of directors and partners of the CB. Of course, they will not have any voting right. They can come and just view the process. And whenever the operational creditors aggregate due is more than 10% of the total debt, then in such case, RP is supposed to give notice to the operational creditors also, because most of us, we are not complying with this particular criteria because
we want to throw a question to the viewers that whether the IPs in the forum practice giving notice to operational creditors, all operational creditors, to represent themselves in the COC members when their aggregate operational creditor due is more than 10%. Just we want to hear the views of the participants. We thought that if the operational creditor due is, if one individual operational creditor due is more than 10%, then we have to give the opportunity, but it is aggregate dues. So whether practically the IPs are practicing this in their process, just we want to hear from you, from the participants. Any clarity on that? Okay, we'll continue with the slide.
So the notice shall provide login ID and the details of a facility for generating password and for keeping security and casting of vote in a secure manner. The notice shall provide contact details of the person who will address the queries connected with the electronic voting. And with regard to quorum is 33% of the voting share. A meeting of committee shall correct if members of the committee representing at least 33% of the voting rights are present either in person or by video conferencing or other audio and visual means. The committee may modify the percentage of the voting rights required for quorum in respect of any future meetings of the committee. It is to be noted that as per section 24 of the IBC Code 2016, the directors of the corporate debtor shall not have the right to vote in the meetings of the COC. The notice shall state the process and manner of voting by electronic means and the time schedule, including the time period during which the votes may be cast. Here again, the issue arises because if there are 5 banks in COC, each and every bank would ask for extra 2 days. One will say, we'll have to go to the higher ups because and particularly this happens in case of resolution plan. With regard to approval of the resolution plan, it is getting delayed because of so many other reasons. We have already delayed the process and we will be in the fag end of the process. And at that time, they would want to go for 8 days, 10 days. So this is happening again and again. And with regard to compliance, we will be asked in IBBA portal and ICSA portal asking for why there is a delay. You are delayed for 200 days. You are delayed for 150 days. This is how it is happening. And then and there, we also inform them. And particularly from our office, we do each and every notice will carry the circular dated 10th August 2018, stating that the concerned person, the authorized person, whoever is apt in this case has to appear for COC. So this is happening and we are not able to put an end to this. Every time whenever we are going for voting and particularly even for simple matters like process related expenses, we are not in a position to vote in person in meeting itself. Even for such things, they are going in for e-voting because they feel the opportunity is there for them to go for e-voting. Voting by the committee. This is Regulation 25 and 26 covers this with regard to voting. The resolution professional shall take the oath of the members of the committee present in the meeting on any item listed for voting after discussion on the same. But still, we will go for e-voting. To seek a vote of the members who did not vote, electronic voting system shall be kept open for at least 24 hours from the circulation of the minutes. The resolution professional shall announce and make a written record of the summary of the decision taken on a relevant agenda item, along with the names of the members of the committee who voted for or against the decision or abstained from voting. The RP shall circulate a copy of the record within 24 hours of the conclusion of the voting. Actions listed out in section 28 in the code shall be considered only at the COC meeting, where the RP cannot take decision on its own. So those listed under section 28 which Raghu sir read the whole thing. So these things, it has to be voted only in the COC meeting. Agenda of the meeting. Agenda talks about the matters to be discussed and issues to be voted upon. So regulation 21, the agenda of the meeting shall have the following. A, list of matters to be discussed at the meeting. B, a list of issues to be voted upon at the meeting. And C, copies of all documents relevant to the matters to be discussed and the issues to be voted upon at the meeting. Minutes of the meeting. The resolution professional shall circulate the minutes of the meeting to all participants by electronic means within 48 hours of the said meeting. To circulate the minutes of the meeting by electronic means to all members of the meeting and the authorized representative. The authorized representative shall circulate the minutes of the meeting received to creditors in a class and announce the voting window at least 24 hours before the window opens for voting instructions, and keep the voting window open for at least 48 hours of the conclusion of the meeting. If you remember, with regard to notice of meeting, when we were discussing there, I told 5 days is needed and you can reduce it to 24 hours. And in case of authorized representative, it is 48 hours. So that is why they have said it as 48 hours, because for the authorized representative, for him to or for her to send the minutes to the concerned person and for them to vote. Minutes of the meeting is very, very important because RP shall make sure that all the proceedings in the meetings are to be recorded properly, and this would be the proof in the event of the same being defended later. See, for example, let us take particularly when you go for resolution plan approval before NCLT, and if there is a question raised by the NCLT saying that what is the full proof for you to say that this particular plan is feasible and viable and things like that. If the RP would have discussed in the meeting where it was approved by the COC, there, if we are going to record all the nuances of the meeting, then you can show that as a proof saying that yes, it was already discussed with regard to the feasibility and the viability of the project, and after discussion only, COC took a decision that this can be approved. So many other litigations, we need proof. So I would say while preparing the minutes, RP has to take caution to record nuances of the meetings. Accordingly, the discussions and deliberations deliberated in the meetings are to be judiciously minuted for the upkeep of the records, because we have seen most of the cases, at least I can say 80% of the cases, whenever there is a question raised by the litigant, if the minutes are there, that is the place where RP can rely on things. So I would say minutes is very, very important, and for us to record the minutes properly.
I would like to add value to this point. As we were discussing that certain decisions are not given by the committee of creditors, as the approval of the cost or the valuation, auditors, all these aspects, if the RP is diligent in recording whatever the decision of the COC aptly in the minutes, he can protect his skin later on if it is questioned by the IBBI and the NCLT. So RP, whether RP who is acting on the part, let him place it before the agenda, before the COC, and whatever the decision is being taken, let the RP or the IRP record it actual, because tomorrow that is going to protect him from the cases. It is not that he cannot face problem at all. Even if the problem comes, there is some kind of record for him to put it in place saying that it is not held because of his complete thing. It is the COC decision. It was taken up that way.
Sir, what is the sanctity if the minutes are not approved?
No, there is no question of approving the minutes because
the minutes have to be approved. Whenever you go to the next meeting, the previous minutes have to be approved. They don't approve.
Sir, it is not approval, sir. I will just explain it, sir. There is no question of approving the minutes because RP is the chairman of the meeting. So whatever RP is recording, there can be other way that the participant can say this is to be recorded like this and this is to be recorded like this. But there is no question for approval of the minutes. It is only taking note of the minutes, and if there is any deviations in the meeting which is not being reflected properly or recorded properly, that can be corrected. But the fact that the approval of the valuation or any other cost is not being approved, it is a fact that the COC is not approving it. Then how you will be recording?
Okay. Okay, sir. Thank you.
In the case law. Before discussing with the case laws, actually we were discussing on the practical issues faced. We thought that we will have an interactive session for this practical difficulties faced by RPs during the CRP period. As we were discussing, the first point is appointment of RP itself that we have discussed. And I have told that because non-appointment of RP and how the COC can expect the IRP to function diligently or to effectively where the COC does not have a confidence on his ability to perform. So any delay in appointment of RP will have a direct impact on the CRP and the objective of the code itself. And the second point also, we have already discussed on that. The members who attend the meeting are not competent enough to make decisions, take decisions. In many of the COC, I think not in our case only, in all other cases also, all IPs may be facing the same problem. And cost involved in going for e-voting, not only e-voting, other cost also, delay in contribution towards the CRP cost. As we discussed, appointment of registered valuers, other auditors, delay in approving them due to non-cooperation of the COC, the delay may arise in the process. So we would seek the members point also the other difficulty faced by the RPs there in the panel, the participants, so that we will also get to know the difficulties others faced by the IPs.
Sir, with regard to first point, delay in appointing in the RP.
Yes, sir.
If the delay is going to happen, the IRP has to continue till the IRP is appointed.
Yes, sir. Yes, sir. Yes, yeah,
he
yes,
cannot
sir.
shirk his responsibility, right?
Yes, sir. Yes, he has to.
So he has to. So there is no way out for an IRP to get out.
Exactly, sir. But the question is.
See what really happens. I will tell you, sir. 1 minute.
Yes, sir.
The delay in the IRP appointment happens because of financial transactions. Simple as that. Very simple and straight. We have to understand that. For example, if you quote a fee of 1 lakh and the other person is ready to quote for 75,000, the matter gets resolved. Or otherwise, lingering around. It happens. Very simple.
But now, as we were discussing, there is a minimum threshold beyond which we cannot go in.
That is very true, sir. Sir, that is very true, and that shall happen. For example, it will happen, but one thing is the COC has to be more prudent on that. But they are not ready to do that. Let us be very clear. First of all, if the other RP is saying that I'm not going to accept the same fees, what is prescribed by IBBI, for me also the IBBI is the same person, And for the other personals also, the IBBA is the regulator, right?
Sir, there is a problem. When there are two guys, unless both come together, percentage of 66 doesn't come. One is having 53, one is having 47. One fellow wants one RP and another fellow wants an RP. So there's a what you call stalemate. No, RP is not getting appointed. No, what do we do there?
That is what we have to continue as IRP has to continue.
One of the says that you are not accepting my RP. I will not approve any of your proposals. No cost is approved, nothing is approved. He says, I want, as long as my RP is not there, I'm not going to approve anything. The other man says, I want my RP, I want my RP. Both of them are not able to get their RP appointed. IRP is the guy who is in the sandwich, who is deemed RP. Now you tell what the IRP can do, poor fellow.
He has to continue. That is very simple.
He has to continue, but they are not approving cost. They are not approving basic expenses, sir.
That is what, sir. See, the reality is such that, please understand.
They are not ratifying anything.
Anything they will not do it. And one thing, sir, even if you go to the adjudicating authority, and the adjudicating authority will say, have you done your job? They don't question who has done the job. The only question they ask is, RP, are you doing your job? It is a thankless job, sir.
They want the RP. They want the RP to do without fees.
That is what. Simple. One line. And I'm not again, how to say, first of all, cohesiveness has to come in from within us. That is still a long way to go. Once it starts coming in, everything will be in the right place. And second point, what I have faced in two of my cases where I was appointed by NCLT bench. In one of the cases, my CRP resolutions were never passed in the first COC meeting and in the second COC meeting. I had to complete the 180 days period, then file an application. I need to recover the cost still further. I have to recover the cost from the FC. That is one thing which is happening. Second thing is the legal expenses which is being incurred to get my approvals done in the NCLT bench. It is my cost which I am incurring. At the end of the day, NCLT will say, this much is the cost approved, kindly accept it. That is what is the status. So mostly, sir, one thing is, the point is COC Dharma has to come from them, not from us. If COC Dharma, CO is not doing its Dharma, nothing can happen. I'm not saying some of the COC members are very good. Most of them try to resolve the issue. But when it comes to confronting with each other, with regard to pari passu charge or first charge or second charge, there is an issue which creates. There is an issue. Otherwise, everything is set in order. This is what is my opinion.
So wherever the financial implication is involved, IRP or the RP is finding difficulty and is being put to hardship to carry out the statutory duties that have been imposed by the code regulations. And I think many people are facing this, and we don't have any option except to go to the adjudicating authority. And as Mr. Earlier one was saying, that even the cost with regard to the legal expenses that could not be on that cannot be recovered, and the adjudicating authority fixes some fee, and it is without anything, we'll have to accept that. It is very pathetic that the IPs are in that state. I think many of us are facing this problem. And as you said, that unless there is a unity among the IPs and there is a code for COC these issues will not be resolved at all. We'll have to live with it.
Only thing is we need to have a cohesiveness with the COC members, try to explain them the situation and try to get things resolved. Or otherwise we will be in a problem always. We will be in a problem. Even whatever I see in the cases, for example, you tell a resolution plan has to be approved. Say, for example, 180 days is fast approaching. You've got a plan to be approved. What normally the COC says, get an extension of 90 days, we will look into the matter. This is what happens. It goes to the 270 days and the resolution gets ratified. This is the happening in almost all the cases. Never it has happened that 180 days the resolution has happened. Very few. You can just count the numbers.
Yes, sir. Even the fee structure, as you said, a fixed fee, and the other fee with regard relating to the IPs, it is to be approved by the COC, and you will get more only when the matter is being resolved within 180 days. With regard to the performance fee, the other package fee, whatever it is, it has to be approved by the COC, and in no case, I don't think the COC is going to approve, even if they are not going to approve the minimum fees. Any other problem, anybody else facing other than this, sir? If you can just throw some light on that, we'll get to know on that. Okay, we will move on to the some of the case laws we have just marked. As I said, one is Dharamveer Gupta versus Sare Reality Projects Limited, where we were discussing that the NCLT New Delhi bench has issued a show cause notice to the ascending COC members jointly who voted in favor of the liquidation of the CD without even exploring the possibility of resolution of the corporate data. This is what this is the case law which I was referring earlier in the discussion. In this case, the creditors, the RP was not appointed. IRP 2-3 times he has sought the approval of the COC for publishing the EOI, but the COC has not approved the EOI, publishing EOI. Instead, they passed a resolution for liquidate the CD, and the IRP filed the application for liquidation of the CD with the AA, and AA, while discussing on the application, took note that without publishing the EOI, and the COC has taken a decision, and the AA has given a show cause notice to all the COC members who has approved the liquidation. And we have many case laws to refer with regard to the upholding by the Supreme Court. The commercial wisdom of the COC cannot be questioned. Case laws, madam. Case laws.
Sir, with regard to this commercial wisdom, it is only on the financial commercials part of it. With regard to the exemptions and what to say, you get your other things, it cannot, the NCLT bench doesn't give you orders favorable to you. Only on the commercial terms they agree.
Yes, sir. Even this commercial wisdom also.
Sometimes they question that.
Yes, sir. Yes, sir.
Based on equity. They say that why it is not principally used as equity proposition, which is being done, which is to be done.
Sir, there are different views. Supposing the NCLT takes a different view, Supreme Court reverses it and it says that the commercial wisdom cannot be questioned. But even in the Shiva Industries, after in the liquidation, the original owner has taken the property. NCLT has a different view that the original owner, because of the 29A, the original owner cannot take part in the process and he cannot take up the matter. But the Supreme Court decided that as the COC has decided on this matter, the NCLT cannot question this. So there are different views, and at the judiciary level itself, and the law is evolving. In one of the recent cases, with the State Bank of India versus MBL Infrastructure, NCLT order dated 23rd May 2023, the resolution plan approved by the COC was filed with AA. And after filing the resolution plan, COC again wanted the resolution plan to be reverted back for the issue of viability and feasibility. The issue of viability and feasibility was raised by the COC again, and they wanted to recall the resolution plan. But the NCLT has decided that once it is approved, the COC has no jurisdiction to recall its own decision and go again for the viability and feasibility of the resolution plans.
Sir, with regard to, I'm talking about a gold case, Ghanshyam Mishra and Sons Private Limited versus Edelweiss Assets Reconstruction Company. This is with regard to commercial wisdom. In this case, the Honorable Supreme Court held that if the resolution plan submitted by RP is in consonance with Section 34 and 31 of IBC, the adjudicating review is limited within the code itself and not interfering in the commercial wisdom of the COC. In view of the above, it was dealt by adjudicating authority and appellate authority while giving great importance to the commercial wisdom of the COC. It is the responsibility of the COC to make a wise decision while handling the process under IBC. They have to take up the process with serious concern and bring greater focus to take efforts to make this process a successful one. This should start right from the persons attending the COC meeting to take decision as and when it requires, rather than postponing the decision, which will lead to postponement of the process. CARP being a time-bound process, it demands quick action, responsibility of shouldering the decisions and timely operations of the CD. At times, the COC members seek 10 to 15 days of resolution to be passed in EOT. In such cases, the essence of IBC will get diluted and the whole process becomes infructuous. It is expected of the COC to take care of the interest of all the stakeholders rather than being self-centered. To conclude, we can say that it is the COC who brings the CD to CARP, continue the operations, revive the CD, and bring life to the CD by finding a new management, thereby recycling the valuable assets of the economy of the country. So the lenders have enormous responsibilities on their shoulder to take well-informed decision in the larger interest of the welfare of the nation. The same decision was taken in case of K. Sridhar versus Indian Overseas Bank and others, as well as Vallal RCK versus Shiva Industries and Holdings and others. The same way, there is another case where Express Resorts and Hotels Limited versus Amit Jain, RP, Nizar Leisure Limited, NCLAT, New Delhi. Once a resolution plan, they decided in that The thing is, once a resolution plan approved and submitted to AA, COC cannot turn around and pray to adjudicating authority to send a resolution plan back for consideration, and COC cannot be allowed to change its view is the decision taken. Here they say the mere fact that the certain other offers have been received after the approval of the resolution plan, COC cannot have a change of art and start clamoring before the AA that they have no objection to setting back the resolution plan for reconsideration. This will be permitting an unending process since by passing of time situation keeps on changing. After coming to know about the financial offer in a plan which has been approved by the COC, any subsequent offer by any entity who did not participate in the process earlier cannot be entertained. So the COC being satisfied that financial offer given by the applicant is satisfactory, exercise their commercial wisdom, even COC cannot be allowed to change its view since it is bound by its own decision taken in approving the resolution plan. So this was the decision taken in this case.
In the matter of SBJ Exports Manufacturing Private Limited versus BCC Fuba India Limited, as we were discussing on the role of the COC members, the members of the committee are nominated by FCs like banks without conferring upon them the authority to take decision on the spot, which acts as a block in the time-bound process contemplated by the IBC. Such speed breakers and roadblocks obviously cause obstacles to achieve the target of the speedy disposal of the CRP process. And the bench directed, in view of the above, we directed the resolution professional to bring this order to the notice of the COC so that appropriate steps be taken and a copy of the order be sent to IBPI for taking suitable action in respect of the conduct of the members of the COC in the present matter, as well as in the day-to-day functioning of the members of the general speaking. So there are numerous judgment which says that the COC member coming and attending the meeting should have authority at least to take decision on the process matter. For example, approving the valuer, approve the process, the publication of EOI, other process related matter, they should be there and they should be having the authority to take decision on the spot, but it is not happening. Even in spite of the IBBI circular, there are so many orders like this. Even in Jindal Saxena Financial Services with the Mayfair Capital, a similar kind of order was passed by the adjudicating authority, but there is no scope for any improvement unless there is a code in place for the COC members. As we were discussing earlier, that unless there is a code for them, we don't have any other go whether to live with the nuances. So now, any questions? Is there any questions? We are ready to answer any questions on the topic, sir. Hello. Sir, any questions?
Participants?
So we have completed. So we have asked. So any questions is there?
Okay.
You can take up.
Okay. Good evening, sir, and thank you very much for the patient listening, and I could also listen to some of the queries raised by the participants. Meghla ma'am and Raghu have been explaining about the case laws and the backdrop of COC, their role, powers, and recent cases where their wisdom, commercial wisdom, also sometimes have been challenged. So, any questions, sir? We are here to attempt to the extent known to us and to our little knowledge, whatever we can share, we are here. Any questions? Mr. Narayana Kama, sir. Mr. Vinod Nair, Rahul Khanna, Sanjay Kaul, Chitra ma'am, any query? Mr. Raman, Sivaraman, Mr. Sivaraman, I saw you have been raising some good points, particularly relating to the appointment of RP replacing the IRP. I hope I am audible. So Ramchandran, you want to say something?
You are audible.
Okay. Okay, thanks, Ankita. You are on mute, sir.
No, it was all the questions were answered then and there. I think that is why the queries are not coming up. I think because
okay,
each line, I mean, it was, I mean, evolving actually. The questions were coming. I mean, it was addressed effectively. I think, I mean, everybody got their doubts clarified. I mean, it was practical also. It was quite useful actually. Thank you. Thank you very much.
Excellent. Thank you. Thank you so much, Mr. Ramchandran. But I'm still believing that some more participants may like to ask some questions. Please kindly feel free. This is our forum, and this is for the benefit of enriching our own, knowledge and awareness on this profession. As somebody said that, more cohesiveness or coerciveness or some words I heard, that is more required to put our profession in a proper perspective.
Again, CA or CS, attend COC on behalf of COC members. Question.
Okay. Can and advocate CACS attend COC on behalf of COC members, attend COC meetings. I think there is a very clear provision. The COC member financial creditor can engage another insolvency professional as their authorized representative. Yeah, but in some cases, I think the COC members they bring their own set of people. Particularly, I have witnessed the new generation banks or NBFCs. They appoint some advocates for them, to represent in the COC meetings. Strictly speaking, that is not permissible as per the code, the provisions of IBC, where the authorized representative of a financial creditor has also to be an IP. A financial creditor can appoint another person as a as their authorized representative. I think that is one question which has been raised by Mr. Prakash Narinkar. CA Anil Kumar. IP has become a helpless creature who has to fall on the feet of fraudulent promoters because none comes to his rescue. Seems to be a practical situation faced by him, or I don't know. But I don't think this is a factual situation in all the cases. Why we should go and submit before a fraudulent promoter? At the best, I think you can go to the NCLT and say that kindly relieve me. I'm not able to discharge my responsibilities. So kindly discharge my role as RP on this case. I think you have every right to ask claim before the NCLT, sir. Any other question in the chat box, Raghu?
Am I audible, please?
Yeah, Mr. Sanjay, please go ahead, sir.
Just a general query about the notices for meetings.
Okay.
What is the kind of detailing or how elaborate should the notices, in your opinion, be for the meetings that we call to conduct the COC meetings?
Yes, sir. Absolutely, very practical question. I have seen different types of notices being issued by the IRPs and RPs, but I think the law specifically requires, kind of a differentiation of matters to be discussed in one basket and matters to be voted upon as another basket. And the third one is regarding, the annexures or other documents which need to be relevant for this meeting. I think this is the requirement. But having said that, you want to show that?
Yes, sir. In the presentation itself, it was there.
Yeah.
While presenting.
Okay.
The meeting notes.
Oh, regarding the notes.
Yes.
Oh, okay. Where is that you want to show?
So I've noticed the presentation. Actually, you see some notices we come across which are very, very elaborate, very lengthy.
Okay.
And the general idea that I want to gather is there need for so much of elaboration, or should we just send a notice containing the basic details and explanations to the items to be discussed?
Okay. Sir, the code is not actually, putting it in so many words, what kind of, contents should be given in the meeting notice. But I would say a COC is akin to a board of directors of a normal functioning company. In the case of CARP, the regular directors, their powers have been suspended, whereas the COC is in place and they take the calls, they take the decisions. In fact, Section 28 contemplates some of the decisions which otherwise the board would have been addressing upon, or the board would have been taking the decision. So, if I consider the COC meeting as a board meeting of a normal running company, then what kind of a board notes, would be placed before a board meeting? The board papers have to be crisp, to the point, and important details should be there. And, cutting out frills and unwarranted information shouldn't be there. Points, papers, and documents required to take a decision should be there. That is my point. And it can be definitely brief and to the point. You can prepare the agenda notes. I think that would any day be welcomed by the COC members if you are able to bring and then arrange the facts in a very crisp manner, pointed manner. Instead of putting verbose and paragraphs after paragraphs, definitely not advisable. Be to the point and crisp, but relevant papers, relevant documents should be in the form of an annexure. I think that's what we have been doing. And in fact, I would humbly share with all the participants here, our way of preparing the agenda as well as the minutes have been definitely received well and appreciated by the COC members, being, varied public sector banks, private sector banks, and, NBFCs, all kinds of creditors. That's very by Mr. Sanjay, right?
Thank you very much. Yeah, thank you.
Thank you, sir. Thank you, Mr. Sanjay.
And with your permission, can I ask you a question unrelated to COC, something that relates to claims and submissions before adjudicating authority?
Please, sir. Please, Mr. Sanjay, go ahead.
Okay. You see, there's a requirement of submitting the list of creditors with the AA under regulation, I think 13 or 17.
13.
Okay.
13, yeah. Now, we need to keep updating the list of creditors and submitting the updated list to the IBBI. Do we also need to submit the updated list to the AA every time we update?
Yes.
Absolutely, sir. This is in fact one way, one kind of a point which I had to learn the hard way. I was under the impression that why it should be every time filed with the adjudicating authority. And finally, it turned out that, some remarks were made, and finally it was a decision that, yes, as many times you modify the list of creditors and update it, please file it with the adjudicating authority. I think the reason is that whether the adjudicating authority takes note of it or not, it should go into the files of the court, files of the NCLD, at what point of time, what was the change in the COC, because this is very relevant in the case of competing partners in the financial creditors, competing financial creditors for the voting rights. Sometimes it's all boiling down to a few voting points, voting share, where a resolution plan could be approved or may not be approved. So I have seen kind of a battles amongst the creditors, financial creditors. So it is always correct and expected, required of the IRP, RP to file an application. Earlier it was in the cost, in the form of a memo or something like that. Yes. But nowadays they ask us to file it in the form of an application.
And do you usually file it separately or as a part of your periodic reports?
Separately, sir.
Oh, you're filing it separately.
Separately, yeah.
So that means every time we do something, we need to file an application to the A, including on the appointment of the auditor, including in the case of appointment of RP from IRP. You need to do a filing in the form of an IA.
Yes, sir. I think you started off asking about the claims updated
Yeah.
So it has to be done. And also, Mr. Sanjay, you may be aware that in the liquidation regulations, I think it is 31 liquidation regulations, where every time there is a change in the stakeholders committee, constitution of the stakeholders, you have to file an application, and that has to be approved by the adjudicating authority. So the difference in liquidation matters is the approval required. Whereas in CARP, it is simply filing.
Thanks a lot. Thanks a lot.
Mr. Sanjay, you are from which place, sir?
I'm from Kolkata, sir.
Kolkata. Oh.
I'm Kolkata, and you see, I've recently got my first matter.
Very good.
I was having some practical queries on several things, so that's why.
Okay, sir. Good, Mr. Sanjay.
Thank you.
Sir, I have one question. Can I just ask you, sir?
Yes, Mr. Rakesh.
Yeah, this is regarding, when you said that, information to adjudicating authority. I know there is a regulation where there is any assignment of debt by one COC member in place to any other bank or lender.
Correct.
Then within 2 days, you are required to, inform the adjudicating authority.
Correct.
That is mandatory. In fact, I have one question on this also. Whether, do you think that, suppose a COC member continues to the entire CRP period, and then at the fag end, that COC member decides to assign its debt. So, and then you find that a new person comes in, so a new COC member comes in place of the other person. And that, at times can upset the entire thing. So whether this thing, whether it is a desirable one to have the COC members changed or have the COC members the, sort of flexibility to assign its debt during the CRP process. That is one question, and I would like to have your views on that. Second thing is that as far as this what Sanjay ji was asking, that, information to adjudicating authority, is it only restricted to the change in COC members, then only you do it? Or even if there is any change in any other claim like operational creditors claim or employees or workmen claim, even if there is a slight change there, are you required to inform adjudicating authority even for those changes? So these are the two questions which I want to ask you, sir.
Fine, sir. Fine. Mr. Rakesh, my view on the second question is that for any change in the list of creditors, the adjudicating authority needs to be informed. I think, Mr. Raghu, I hope you agree with me.
Yes, sir. Yes.
Because the provision states that
list of creditors.
It is with reference to the list of creditors.
The list of creditors shall be available.
Yeah, shall be available for inspection by the persons, shall be available for inspection by the members, partners, directors, displayed on the website of the CD, filed on the electronic platform of the IBBA, then filed with the adjudicating authority and presented at the first meeting of the committee. Actually, I try to interpret this clause, putting a lot of stress on the last item presented at the first meeting of the committee. That, these are all things which are required to be updated once you file with the adjudicating authority at the first time and there is any change, you have to present it to the committee of creditors.
No, committee of creditors, sir, every time whenever we send the agenda papers, we give that list of claims. That is the claims status as on just before during the agenda papers only it's there. So any change is there. So definitely the next, if there is between the two COC meetings, if there is any change, again, the list of creditors is always there. See, these are the admitted claims status. But informing adjudicating authority for any change, it has to be done every time, whether there is a employee change, claims of employees or even OCs. Are we required to do this, to inform adjudicating authority every time?
That is the view taken by the IBBA as well as the IPAs.
Okay.
This is a view because as I told you, my own experience and also experience in various disciplinary activities, disciplinary action taken by the committees. They see that not filing the changes in the list of creditors with the adjudicating authority as a lapse on the part of the resolution professional. Even though the wordings of this regulation 13, maybe I can is it possible for you to show this on the screen? Regulation
Yes, it will be I think good for all of us.
Yeah, regulation 13, if you really analyze the semantics of this regulation, the words, what kind of words they have used, I try to highlight to the authorities that the intent of this particular regulation is only for the RP to keep a tab on the modifications and also to put it in the website.
Yes.
Yeah, you see, this is the 13 and subregulation 2, and the IRP or the RP shall verify every claim as on the commencement date within 7 days, and thereupon maintain a list of creditors. So the duty is on the IRP or the RP to maintain a list of creditors containing the names and along with the amount claimed by them, amount of their claims, etc., and update it. So here the requirement is only with the IRP or RP what we should do. Then the next limb sub-regulation says the list of creditors shall be available for inspection. Okay, it's with me. Please come and ask me if you want to see. I will give you. Okay, correct. I don't have to do anything else. Next one is also on the same way available for inspection. Go next. See. Displayed on the website if any of the corporate data. Okay, if there is a website, I am putting it on the website.
On the website, correct.
Next one is with the IBBA platform. That is also fine.
Yes.
Then filed with the adjudicating authority.
Oh.
Here only the interpretation comes. So the list of creditors shall be filed with the adjudicating authority, and I am reading it with the last sentence and presented at the first meeting of the committee. So which means all these A, B, C, D, E are with reference to the first list of creditors, the first time when we are preparing the list of creditors, how it should be done, what I should do. will be available for inspection, will be available for inspection by members, will be displayed on the website, will be put on the IBBA website. Okay, all these things I'm doing it. And I'm also filing it with the adjudicating authority. And I'm presenting in the first COC. So the whole structure of this sub-regulation is with reference to the first time whatever thing is happening. Okay, now if I can take you to the, sorry, once again. Updation. There is one place where they are calling it as updation.
Update.
Yeah, that is 13.1. So strictly speaking, the construction of the regulation, the wordings of the regulation do not kind of contemplating that every change it should go to the adjudicating authority. That is, that was the view I had, but later on I had to change my view, stating that, let's do it because probably, sir, the idea, as I was telling you, there has been so many, claims, counterclaims, disputes on the voting share by the financial creditors. Okay, so because of that, the view was taken that every time there is a change, you please file it.
No, I'll just add to that point.
Yeah.
See, why we were of that opinion, because initially once the claim is verified, it is the duty of the IRP to constitute that and file with the adjudicating authority the constitution of the committee and then present it at the first meeting of the committee. So because the code and the regulations are syncing together, we were of the opinion that this is to be filed only when at the first instant and not at the thereafter subsequent. But it was clarified by the IBBA and IPAs that it is not so. We'll have to file at every instant.
Yeah, but strictly speaking, the wordings of it does not, insist that every time it should be done. But in practice, this is the issue which we have faced. So I think your question is very, very correct and very particularly, I should appreciate that this is a problem which I have also faced.
Yeah, the practical problem is, sir, like first 30 days you file you have your first list in the CRP period in 30 days, first 30 days. And from 30 days to 90 days, like the regulations allow that up to 90 days you can take claims. So it can get updated as many as 60 times. Yeah, you can keep getting claims during this period from 30th to 90th day. Does that mean that every 10th day or every 5 days or so, I need to keep, updating this list? Okay, this list will internally, it will keep getting updated, but you put it on portal, say on company's website once in 7 days or something of that sort, you keep updating there once in 7 days, which means every time when you update on portal, you also have to file a IA with adjudicating authority.
Absolutely, sir. Absolutely. Maybe, what we have learned through this process is that even if claims come and then you do update it, please go for an updation on a monthly basis, end of the month basis kind of a thing. So at the end of, a calendar month, we will prepare the list of creditors as on the particular date, and we will present it in the subsequent COC meeting coming. And also the IBBA corporate data websites, month end, we'll also put list of creditors serial number. I think this is,
yes,
list, second list, third list, something like that. True. Updated as on. That is what we have started doing.
I think that is what we have to do, because if it is to be done, and any lapse can unnecessarily call for actions,
Yes, sir. Yes, sir.
So better we link it with COC meeting, sir.
Sorry?
Better we link it with COC meeting. Every meeting.
You have to place it in the subsequent COC meeting.
So once we place it in the meeting, that can be filed, I think. We link.
Yes. I think link it with the meetings. If there are, you see, if the number of meetings are more than 2 meetings in a month or so, that means every meeting you have updated. So you have to update. You have to inform AA also. But if you are having meeting after a gap of 1 month, the gap between one COC to other COC, then monthly I think should be good enough.
Absolutely, you are right. I think one point which the other gentleman had.
Yeah, I had another question. I had registered two questions. The other one was on this assignment of debt by one COC member to another COC member. And this is permissible. The regulation is there. And it also stipulates that in case there is any assignment of debt from one COC member in favor of any other member, then, the corporate debtor and the RP is required to inform the adjudicating authority within 2 days of this change. Yes, so my question was whether this type of assignment of debt should not there be some restriction, like, okay, you are in the CRP stage, and then these are the committee of members, and then and particularly when there are less number of committee of members. If there are large number of COC members, then okay. But if there are just 3 or 4, and then one of them decides to move out, so it becomes a little difficult at times, and that too more so when it happens at the fag end of the CRP's process.
Yes, sir, absolutely. But I think this regulation does not restrict the rights of the creditors to assign the debt during the CRP period at any point of time. As you said very rightly, it has to be placed. Both the parties have to confirm to the RP, and RP has to place it before the adjudicating authority.
Yes, yes.
And, definitely, there is a consequential change in the COC.
COC, yes, correct.
Yes, but I think, sir, any decisions, as you know well, taken by the COC in the earlier kind of a thing, it all stands, and nothing goes back or nothing is rolled back. I have seen cases where the financial creditor, based on an order by NCLT, coming into the COC after the plan has been approved. COC does all its work.
Yes,
but still the CRP period is still continuing. Until the order of plan comes. So suddenly the gentleman comes and, sir, I become the COC member. Please send me all the notices.
Correct. Yeah. He will ask for all the right from inception.
Yeah, what we used to tell those gentlemen.
Yes.
Look, my friend, you have become a COC member today. So from today onwards, anything is happening, you please ask me. Anything prior to this period, you ask your good friend from whom you have taken over this debt. So if you are taking on an assignment, you take all those papers also on assignment.
Yes, logically it should be like that, but then practically it doesn't happen. They will ask for right from inception. They will ask all details.
All details. Yes, this has happened. But I think since they were not party to this meetings, I have taken a view that under confidentiality arrangement, you better approach your person, the assigner, and take all those things from him. I think they were able to exchange the documents.
Logically that should happen, but then he will keep saying, hey, now I'm COC member, you please share. So how much you cannot say no, particularly when.
So Mr. Rakesh, you are in which place, sir? You are from?
I'm from Delhi, sir.
Delhi. Good, sir. Good, very good. I think the heat wave is lashing, or you are having some good rains there.
Yeah, these things keep happening. Okay, fine. Part of life.
Yeah. Okay. Very good. Any other questions? Any other? There is one chat box. I think Harvinder Singh. Sir, can you share your practical experience and difficulties while preparing evaluation matrix RFRP? How to prepare? What things and IP take care while preparing EM, EOI, and RFRP? Of course, a very loaded question. In a small question, I think he has asked almost everything relating to this. Sir, it depends on the size of the corporate data industry and in what stage it is. Since we handled, asset intensive cases, and recently, a company where nothing is there as a physical asset, but only intellectual properties are there, like you have a brand value, you have a customer recall. Vasan Healthcare was the company which we did. There was physically no asset belonging to the company. But still, the valuation perspective was very good because, the healthcare industry was doing well and they had a good brand value, and, turnover and collection was very robust. So we were able to have, good valuation. But I think your question is on preparing the evaluation matrix and RFRP. I think RFRP has to capture these perspectives. What are the strengths of the company? So those things would help, the resolution applicant in a better way to give a good plan. Evaluation matrix is a very good question. Evaluation matrix is a kind of a tailor-made for each assignment, depending upon the possibilities of how you will get a resolution plan. You have to design various parameters and marks for various situations. Generally, we take the sacrifice, upfront payment of resolution plan, quantitative and qualitative. So within the qualitative and quantitative, which is normally a 75-25 or 70-30 ratio we take, but there are different methods of the evaluation matrix scoring also. A plain vanilla evaluation matrix could be the person submitting a resolution plan himself can put marks for his plan, very clearly saying that if I put some 100 crores is my resolution plan value, I put 30%. So upfront 25 to 30%, how much is the mark? That is one way of doing it. The other way of doing it is on a kind of a percentile basis. Like, you have seen the competitive exams for IIT, JEE and all. So with reference to the person giving the highest valuation or highest number for that category. For example, resolution plan value, whoever is giving the highest, his number will be taken as the 100%. So the next person's value will be taken 80% of the first person, 60% of the first person. So that is another way of preparing the scoring for evaluation matrix. Plenty of factors come into play in the evaluation matrix. As a practical perspective, I can share that almost we would have changed the evaluation matrix, the pattern at least 10 times in our experience so far. We know some of the cases best practices adopted. So from there we add and then do some corrections and make it on a specific case-to-case basis. And preparing EM is definitely a very, very elaborate kind of exercise. EOI, expression of interest, is a enough kind of thing. RFRP, I definitely would like to put a lot of extra information, which is more relevant to the resolution applicant. Nowadays, I think special importance is being given in the code and regulations. Even information memorandum also, in addition to the normal listed data, you are supposed to add something more, Raghu.
Yes.
I think there is one kind of a amendment which came, right? I think information memorandum, some additional data which you have to add. Am I right?
Yes,
36. 36, regulation 36, it says, company overview, including snapshot of business performance. I'm reading regulation 36, some of the items which have been added very recently from 16 September 2022. Company overview, including snapshot of business performance. This one also. On the top. Yeah, the information memorandum shall highlight the key selling propositions and contain all relevant information which serves as a comprehensive document conveying significant information about the corporate data, including its operations. So to answer this question, instead of stuffing all those things in the RFRP, even information memorandum itself has now become more informative. Okay, somebody else, I think there was another person almost ready to ask a question. CA Shruti Logia, would you like to ask any question?
Yes, sir. Sir, in one of our meetings, the other COC members, they were requesting to show all the papers of one more COC members, like how we accepted their claims. So is it possible to share? And the other COC member, however, they permitted that yes, you can show our papers. But then we said, in case like you want to see, you both can exchange the papers. We will not be in a position to show that.
Okay. Good question. Interestingly, I also faced a similar kind of an issue, although it was in liquidation, probably in the liquidation matter. But nevertheless, during CARP, this kind of issues come because it affects the voting share and the equation of the COC members. Very pointed response, I would say. The code as well as regulations do not allow the IRP or RP to share some other person's claim details to another person. If you have submitted a claim, that's a document which belongs to the under the custody of the IRP or RP. So why I should share this information to another creditor? Okay, having said that, there is a requirement. A COC member can inspect the documents, the claim documents. So just now we had seen there, the list of creditors, should be available for inspection. Similarly, there is a provision that a creditor, particularly a financial creditor in the COC, may ask information from the RP or IRP, any details. So my point and my stand at that point of time was that I have the list of creditors with me along with the supporting information. If you want to come and see, have an inspection, you are welcome. You can come and see. Otherwise, if you are asking a copy of his claim, I'm not supposed to share that. And I would not like to share that. Okay, if you want to have an internal arrangement, between you and the other person, I have no problem. Outside of me, you can do whatever you want to do with it. Maybe my stand is right or not. The other participants here may share your view, but I would say that it will amount everybody asking this information, that information. Am I right, Ms. Shruti? What is your view?
Yes, sir. If we allow one person, then everybody will ask about all the claims. So it's not practically possible to. And no, it is confidential also. So that will be. But I was not knowing, sir, that they can come and inspect all the claim documents. I thought that they can only see the list of creditors which is available.
I think that point which you are saying is also right. So again, what is the inspection rights given to whom the rights of inspection is given? Available for inspection by the persons who submitted proofs of claim. The list of creditors shall be available for inspection by the persons who submitted proofs of claim. Okay, very good. So there, your point is right. Only the list of creditors shall be available for inspection, not the entire backup papers, evidence and proof. Okay, so that is your point is well taken. Now let me go to section 21, subsection 9. The committee of creditors shall have the right to require the RP to furnish any financial information in relation to the corporate debtor at any time during the CARP process. RP shall make available any financial information so required by the COC within a period of 7 days of such requisition. Now, committee of creditors shall have the right to require the RP to furnish any financial information. Now, is asking about another person's claim will be a financial information? I don't think so. Any financial information means about the corporate debtor, maybe their assets or liabilities, balance sheet details.
Financial information includes the claims. Claims.
Okay, then can you show mark 21.9? In that case, another question may come. The wordings of this 22.9 is that the committee of creditors shall have the right. They are not saying that a member of the committee of creditors. They are not saying. So it is a collective.
Their own.
Sir,
Yeah.
sir, I think financial information is defined in 313.
Okay.
So I think we have to go by that definition.
Okay. So what is that 313?
Records
schedule?
Financial information in relation to a person means one or more of the following categories of information, namely records of the debt of the person, records of liabilities when the person is solvent, records of assets of person over which security interest has been created, records of any of instances of default by the person against any debt, records of the balance sheet and cash flow statements, such other information as may be specified. So this is what has been.
True, but here financial
Something is referring to corporate debtors information, sir.
in relation to the corporate debtor, yeah. In relation to the corporate debtor, I think so. If you add financial information with reference to the corporate debtor, I think in relation to the corporate debtor,
Then I think you just need to share the details of debt of the person. You cannot possibly share the information given by other people in respect of their claims.
Sir, if you go back to the definition, please can you show more 313? Sir, I think Mr. Sanjay or
Sanjay, yeah.
Section 3. Definition.
Section 330.
So, if you look at the definition carefully, the words, number one, records of the debt of the person. Second, records of liabilities when the person is solvent. So, this is a completely different kind of a connotation of, financial information. This is section 3, no? So, when a definition clause we are seeing in section 3, it applies to entire CARP, personal insolvency, everything together.
That's
so, if
right.
you go to section 5 definition, then it goes to the corporate debtor CARP in particular. So, my view would be, is there any separate definition for financial information in section 5? No.
I think
when he is solvent means it is more in reference to the corporate debtor, sir.
No, why we should say solvent? This company itself is in insolvency provision now. It has come here.
Yes.
Isn't it? CRP, it has been admitted into CRP. Claims have been given. One person wants to know about the other person's claim. So where is the question of somebody is solvent here? So, sir, my observation, my interpretation would be like the financial information referred to in section 21, where the COC has the right. That right itself is a collective right. In my view, I would like to narrate one example. There was a company in which the COC comprised of, hostile creditors, financial creditors. One is a public financial institution, other is a private money lender. The private money lender had no records, no documents, but he says that I have given a huge sum of money to the corporate debtor. And there is some documents like, checks have returned, letterheads, all those things, promissory notes, everything is there. Somehow the debt got admitted, even though I did not admit the debt by an order of the NCLT, the debt got admitted. Now, when there was an issue in the COC, this person who is having a significant voting share, he wanted significant in the sense, I think something like about 20-25% he was having in the COC. He wanted the recordings of the COC meetings. I want it immediately tomorrow morning because you have recorded the minutes completely different from the actual proceedings which have been recorded in the COC proceedings. So you give me the video recording of the COC meeting. He sent a notice to me. And then immediately he filed a complaint against me in the NCLT. that the RP is behaving in a very autocratic manner. He says something, he writes something else in the minutes. I asked for the recording, he has not given. All these kinds of things he raised. So then I raised this issue in the COC meeting. The other financial creditors present in the meeting, they said that whatever you have recorded is perfectly all right. We go with the recording of the minutes. There is no need to give the tape or the recordings to this person. And that decision was taken collectively with more than, there was a requirement of 51%, I think, in such cases. But more than 70% they passed resolution. And that fellow got really snubbed after that. So why I'm saying that, these kind of things happen sometimes. So the collective requirement, I think section 21(9), the committee of creditors shall have the right to require the resolution professional to furnish any information. So Raghu, would you agree with me that right is given to the collective body, not to the individual?
Yes, sir.
Individual COC member.
I think that's a very good point.
Yes, sir.
In the definition, you use the word solvent, insolvent.
Yeah.
Solvent. So what I presume is that it has more to do and reference to the past data when the company was doing good. So maybe that type of information is defined as the financial information, or rather a part of the financial information, sir. Any views on that, sir?
No, in that case, it should have been when the person was solvent, isn't it? I think it can go endlessly, but it's a good point and good discussion. But I am thankful for pointing out this definition.
Sir, the case which you mentioned that no, it got more than 70%. But suppose if it gets below 51%, then we need to share it.
Yeah. Yes.
Okay.
So you're referring to the newsletter, your newsletter that you roll out. Can you be able to share that, sir? What?
Yeah, surely, sir. Surely. Maybe. Sorry. No, sandbox. Sir, we can definitely share. By a digital version. I can. Once I get your email ID, we can definitely share that.
Okay, sir. Right, sir.
Maybe you can just. Is it Mr. Murthy?
Yes, sir. Murthy.
Okay, Mr. Murthy, from where you are joining?
I'm from Hyderabad, sir.
Hyderabad. Okay, very good. You can just send the email here. You can put it here or your email ID.
Yes, sir. I'm just typing it, sir.
Okay. Can you type something here? You please write our email ID so they can write to this email ID and then we can send the.
That's nice of you, sir.
Yeah. Create and grow research at gmail.com. Okay. Excuse me.
So do you have a website or maybe?
Yeah, we have a website also.
Yes, sir. We have a website also, sir.
This is the email ID, just click it, and then you can also send the website also. www. So I think Narayana sir has come back, I think.
I was there, sir.
Oh, good, sir, good. I didn't have the pleasure of probably seeing you.
I was hearing you. I was hearing you guys.
Oh, okay, good, sir, good. Sir, you want to say anything? We have come to the fag end of the
Nothing much, sir. Thank you very much. Thank you for an enlightening session. So it was good.
Thank you, sir. Thank you.
Morning
Sir,
also we had some heated discussion about Provident Fund because wherever I come in, Provident Fund will follow me.
Absolutely, sir. Absolutely. I think you have created.
Most of the IPs still are aligned against Provident Fund Department. So it will take some time for them to reconcile to the fact that they have to now go with the law which is evolving. With Moser Bear coming in, sir, I think now things are settled.
Yes, sir, absolutely. The Supreme Court also has put the, the last
Moser Bear,
name.
Tourism Finance, all these are settled. So now things are getting some clarity now.
And I can definitely share with all the IP friends here that in case you have any query, any problem, any difficulty in Provident Fund related matters, I think Mr. Narayana Kama will be the right person to guide you. In fact, he has put me into the right persons, and everywhere I go there, oh, that gentleman, Mr. Narayana Kama, he was the Regional Provident Fund Commissioner in what is that place, sir? Dharwad or Hassan, sir? You were?
I was there in Mysore. Then I was in Hubli.
Yeah, Hubli, Karnataka. So that was very helpful. And there is some email ID.
I can help you guys getting connected with the concerned Provident Fund Commissioners if you are having issue dealing with the person with whom you are dealing. If you have any issues, maybe I can put you on to the senior officers.
Good, sir. Good,
any of the guys.
Absolutely. Absolutely, sir. Absolutely. So thank you very much, all the participants, for your presence here and active interaction. And I thank Ms. Mekla and Mr. Raghu also for sharing whatever notes, whatever they had prepared. It is a kind of both ways, it helps us to refresh and then improve our own understanding.
Summary of this session can be put in Sandbox, sir.
we can put it, sir. Why don't you put it, sir? We'll put your photo and then publish it.
No, sir. That is your thing. You got a full recording? No, you can do it. Not difficult.
ICSI is having the recording. Maybe Ankita should.
So we can share the recording if you need it.
I think the recording is made available in the website, in the site, I think. All the recordings.
We upload the recordings on YouTube. I think 3-4 days we can upload it.
Generally, in a day or two post the sessions you upload.
Thank you, sir. Thank you. I think I am also grateful to Ms. Chitra Perinkulam Raghavan. I think we interacted with her or not. But I think she has responded that Sandbox is really good. So thank you very much, ma'am. Thank you. I will be delighted, to share with all our friends.
Thank you so much, sir. Rajendran, sir. Mekla, madam.
Thank you, sir.
Yes.
Thank you.